Kind permission. One matter for suspension of sentence, my lord, hearing on same combination is on day after tomorrow. In one, please, my lord. Two cases, sir. One case suspension of sentence.
Date fix ಆಗಿರ್ಬೇಕಲ್ಲ ಅದು?
Day after tomorrow.
You want it to be preponed?
In the same day, 20th.
What is that memo?
For suspension of sentence, IA file ಮಾಡಿದ್ದೀನಿ.
ಬೇರೆ
ಹೌದು 307 ಅಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದ್ದ ಕೇಸಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅದು ಕೂಡ ಸೇಮ್
ಕರೆಕ್ಟ್ ಎರಡು ಅವತ್ತೇ
ಅವತ್ತು
ಬರುತ್ತೆ
ಬರಲಿ.
ಕೊಡಿ.
20th day after tomorrow.
No, if you file the application, they will list it even without you moving the memo.
Already file application is filed.
File ಮಾಡಿದ್ರೆ ಅದು ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ.
Okay,
Date
great, great.
we have corrected that ಇದು ಕೊಡ್ತಾರೆ.
Please.
Adjournments, page 5.
Your Lordship, if I may make a mention,
Page
Your
1,
Lordship.
number 1 to 4.
if I may make a mention, please.
Yes.
Your Lordship, in OSA 10 of 2024, the shipping matter, it's been reserved for judgment. Your Lordship, we had filed a list of authorities.
Yeah, filed so many memos. We are going to list it again. What is that? Once of the matter is reserved, you go on filing everyday memos.
My apologies, Your Lordship. Your Lordship, the issue is while filing the list of authorities.
We'll list that matter day after tomorrow.
Please, Your Lordship, please.
Adjournments, page wise, page 1, cell number 1 to 4, page 2, cell number 5 to 7, page 3, cell number 8 to 12.
Here for respondent serial number 11, yours. I'm not well today. What is the matter?
Recalling the earlier data. We will see what is that. Recalling also again time.
Yes, your my lord.
Why?
Today I'm not well, your honor. Next week I will.
No, what is that recalling?
Recalling is on
Interim maintenance litigation expenses awarded 20,000. They filed a
ಯಾವ್ದೋ ಹಳೆ
ಹಳೇದು
it's very old order.
that is the seeking record.
We'll see.
Serial number 11 and 12 my payment next week, my lord. I am also some personal inconvenience today, my lord.
What is the fun in listing the matters?
Parted matter 4 serial number 4.
No,
Next week, my
What
Next-
is intellectual applications?
Yes, my lord.
4th next week any date, my lord. I'm not seeking adjournment.
Page 4, cell number 13 to 17, page 5, cell number 18 to 22, page 6.
My lord, serial number 22. Lord, the appellant's mother is not well. She's aged about 92 years. Therefore, he has to leave.
Appellant ಗೆ ಏನ್ ಕೆಲಸ ಇರುತ್ತೆ ಇಲ್ಲಿ?
ಇಲ್ಲ, appellant's counsel's mother. Sorry. Dr. T. Somshekar,
KSFC.
please, my lord.
Your matters are the oldest matter. KSFC matters.
I understand, my lord. I'm a proxy counsel. These are my instructions. Any date may be fixed.
List on.
24, 24, 6.
Deeply obliged.
Page 6, cell number 23 to 25. Page 7, cell number 26 to 29. Page 8, cell number 30 to 32. Page 9, cell number 33 and 34.
Serial number 34, my lord, for the respondents. My lord, senior counsel Kamath has some personal inconvenience. He's out of town, my lord. The matter may be taken up in 2 weeks. We've informed the other side, my lord.
Whom do you represent?
I represent the respondent, my lord.
Respondent. Right, Shankar Narayan Bhatt, where is he?
Shankar Narayan Bhatt.
ಇದು ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ. When do you want it?
2 weeks time may be granted, my lord.
ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ. If there is some inconvenience to 2017 matter, you are only pressing this.
My lord.
We said we will hear all those applications along.
My lord, some emergency is out of town, my lord, senior.
Okay. There are counsel for the respondent seeks adjournment. As a final chance, based on next week. Next week. We'll impose cost next time also if you do like this.
He's
26.
26.
Obliged, my lord.
Page 10, cell number 35 to 37.
My lord, serial number 37. I appear for the appellants. My lord, so the concerned counsel is sick, my lord. If it can be had next week. I've informed the other side also, man.
Agenda as requested by the appellant's counsel, list in the next week. Yes.
Next, page 11, cell number 38 to 44. Page 12, still number 45 to 49.
46. 2 days accommodation. Maybe by Friday I will
26.
take my submission.
As requested, Friday, no, Friday will take up for criminal appeals.
ಇವತ್ತೊಂದ್ ದಿವಸ ನಾನು
Day after tomorrow,
please.
as requested, Thursday.
Please.
20, 26.
Requested by the appellant. As listed.
Page 13, still number 50 to 53. For orders, still number 1.
Submission for that.
Serial number
36.
36.
Matter compromised. We are filing joint memo.
Already compromised, both the parties are present. Compromise may kindly be
36,
recorded.
ಏನು compromise resolution or resolution?
My lord, the resolution granted by the trial court, which was challenged here, now they settled it and they are paying the
Correct.
permanent aluminum.
ತಕ್ಷಣ ತಗೊಳ್ತೀವಿ ರೀ, ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟ್ರಸ್ ಮುಗಿದ ತಕ್ಷಣ ತಗೊಳ್ತೀವಿ.
Please, please.
ಅಲ್ಲ, ಇದು
Serial number 1, my lord.
ಎಲ್ಲ ಹೋಗೋದಿಲ್ಲ.
For the applicant.
Respondent,
In this matter,
serial number 1.
Serial number
For
1.
orders, still number 1.
Response counsel had to pay the cost.
we had to pay the cost. We will pay it, my lords. I mean, by the end of it, and I can pay it right away if my lords gives me the permission. Please,
What is, why this
my lords, and
admitted, final hearing list ಆಗಿತ್ತಾ?
yes, my lords.
ಮತ್ತೆ they should have listed it in final hearing.
That's paying the respondent
Counsel submits the appeals to the appellant.
Compromise.
My lords, we are also speaking to the parties as well. The appellant in this particular case happens to be an auto driver. So we are negotiating and subsequently,
ಇಲ್ಲ ಆಗೋದಿಲ್ಲ.
Illa, my lords, we are negotiating. The parties are also here.
All right, you negotiate now.
My lords, one last of,
Cost.
no, I pay the cost.
Paid, my lord.
The counsel for the response submits that cost is paid. Therefore, office subsections will comply. As requested, if at all you want to do something, you do.
My lords, we are, my lords. I mean, the party,
Final hearing
No, one-
list ಆಗುತ್ತೆ. Cost ಎಲ್ಲ ಕೊಡಕ್ಕೆ ಶುರು- Is that correct?
Yes, my lord.
Is there any sincere attempt?
no, my lords, we have been making sincere
I
attempts. my
don't
lords.
know. I have no information.
ನೋಡಿ, ನಾನು ಹೇಳ್ತಾ
Illa,
ಇದ್ದೀನಿ.
my lords, sir is
Be aware of that.
No, he's appearing as a proxy counsel. The regular counsel is not here today. We have also informed the regular counsel as
No,
well.
no, no. I am the regular counsel, sir.
But the other counsel,
You do not even know whether he is
In-
the advocate on record.
no, my lords, the person whom we were interacting with,
In the last time ಯಾರೋ ಮಿಥುನ್ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ತೋರಿಸಿ. ಹಾ, right. Sorry, this is happening day.
no,
in,
please,
day out.
one last opportunity, my
No,
lords,
lords,
one last.
We will list it for next week final hearing. If
No,
it-
my lords, anytime next week, maybe listed, my lords, anytime next week, my lords.
The counsel for the appellant submits that appellant is making attempt for a settlement. Okay. This matter is pending since 2017. 17. For not arguing the matter on the scheduled date, costs were imposed. If at all the appellant wants to settle the matter, he should settle it before next hearing date, or he should go on with the matter. ಇದು ಆರ್ಡರ್ಸ್ ನಾವು ಹಾಕ್ಬೇಡ ಅಂತ ಹೇಳ್ರಿ, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನಾವು ಹಾಕ್ರಿ. ಪ್ಲೀಸ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ಮಂಡೇ.
Date may be fixed.
20,
my lord.
25/6.
Please, my lords.
Still number 2, Roshan MC, Rama Ramachandra Iyer.
My lords, for the respond in this matter, my lord. The appellant have not approached us and served copies, my lord.
Not served.
No, my lord.
No representative submits that copies are not served on him. Again, one of his is ordered to the same is not returned. Finally, 10 days rest. What the whole returned ಅಂತ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. Return ಅಲ್ಲ. It should have been dismissed. What is that IA 1 of 2027?
It's for stay application, it's stay, my lord.
Stay.
My lord. IA number 2 is for condonation, my lord.
ಯಾವ ರಿಕಾಲಿಂಗ್ ಇರ್ಬೇಕು. IA 1 of 2027. No, 2017. ಏನು? What is IA 2 of 2017? Condonation of delay. Delay is condoned.
No, my lord. They have not appeared, my lords.
They're not
After
appeared.
filing that is, they haven't up.
1 of 2017 is first. The concept for the response submits that the application is, the order dated 5/6/2024 is not complied. Therefore, the IA 1/2017 very stay application. Dismissed, no further orders are required. This, how many days delay was there?
32, my lord.
32 days delay.
They claim,
For petition call,
we have not received the copies, my lord, so I don't know the exact, the contentions in the appeal
it
memo.
was served on you, it seems.
No, my lord.
Then for dissolution of marriage is dismissed. Counterclaim is allowed.
Counterclaim was allowed, my lord.
Declared as null and void. Counterclaim was for declaration of marriage. Respondent is directed to pay ₹5 lakhs each to the petitioner and her daughter.
That he has paid, my lord.
Yes, paid.
He has paid, my lord.
The records show that, consistently there is no representation for the appellant. By the impugned order, the petition of the appellant for divorce is dismissed, and she was granted ₹5 lakhs permanent alimony. It appears the appellant is not interested in prosecuting the matter. Marriage is declared as null and void and after declaring the marriage null and void, where is the question of granting alimony?
That is what we contended, my lord. That's why we had filed an appeal, but they have not come, my lord.
Like counterclaim, husband appeal. Or we have to give legal aid because poor lady, we do not know what has happened. This is from family court, Bangalore. How old was the child?
My lord, now she is 17 years old, my
24/3/2022. Marriage was 24/3/2022. 2002. So, ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು? 22 years, huh?
She's made a
marriage. ಏನು ಇದಾರ ಇಲ್ವೋ ಅವರು?
She's doing a bachelor's, my lord.
She's?
My lord, she's doing a bachelor's in Reva University, my lord. And he's
Not daughter. Wife is alive.
wife is alive, my lord.
So you are in touch with the daughter and
Yes, my lord. They have been appearing trial courts, my lord. They have filed for maintenance also. He's paying maintenance also. Every month they're appearing, my lord. They've not been appearing in high
in
court.
the maintenance case, maintenance is granted.
Granted,
Then
my
why
lord.
the trial court held that marriage is null and void?
My lord, there was no marriage, my lord. But then he agreed that child belongs to him. So he's been paying the maintenance. We also challenged in our appeal, my lord. But then since they are not appearing, we had withdrawn it.
Dismiss ಮಾಡಿದ್ರು.
You communicate to them, ask them to appear.
Who is the advocate who was appearing here? Roshan MC.
My lord. My lord, we have sent them several reminders, my lord. They have not been appearing, my lord.
Continuously has not appeared.
No, my lord. They have been appearing trial courts, my lord. Even last week they had appeared, my lord.
The matter is pending still.
Yes, my lord. They collected the maintenance in trial court, my lord.
The matter, section 125 CRPC is pending for the trial court and parties are
Even
appearing.
DV is also pending, my lord. DV is also pending in trial.
Counsel for response submits that the proceedings between the parties under section 125 CRPC and Protection of Women from Domestic Violence Act are pending and parties are participating there. So we'll issue court notice to her.
My lord, we have taken a lot of steps, my lord. We have taken steps in this case for them, my lord.
Not in this area. We have not taken steps here. Where is the question of you taking steps?
We have been sending WhatsApp messages, emails and all, my lord.
You are sending to the advocate. It seems.
Even the party, my lord. They are sent to the wife also.
They will not come if you send because they are fallen out. Who is appearing before the trial court?
The same advocate and even the wife comes, my lord.
See, they should come and conduct the cases, the matrimonial cases. Lives of the parties are involved. If they are doing like this, we have to refer it to the bar council if that is the case.
My lord, it may be dismissed, my lord. We have been appearing in their case.
We understand. See, when we take up the parties, cases of the parties, where these family court matters, minors' interests are involved. Because you said when alimony is awarded, taking into consideration minors' interest.
Yes, my lord.
So when minors' interest, it's the duty of the court also to see that the interest of the minor is safeguarded. They should appear.
My lord, currently she is major, my lord.
Now she
She
is
is a
major.
graduate also, my lord.
Under the circumstances, there are not many. Paper revision over here. Will appoint some person as amicus curiae or refer it to the legal service. Legal service authority, if we refer, what happens? They have to issue notice. These parties, if they come or they do not come. Somebody, if assist us as the amicus curiae, will dispose of this matter. Sohani Hola Srimati Sohani Hola is appointed as amicus curiae to assist the court on behalf of the appellant. Okay. We were wondering, the trial court holds that declares that marriage is null and void. Again, it grants alimony to the
wife, my
to
lord.
the petitioner and her daughter. We have to see it.
Yes,
The petitioner. Consistently is remaining absent on the head. Consistently in the registration furnisher, registration show her name is a cause list and furnish her the copies list for final hearing on 2 weeks.
1-7.
Already 1-7.
Much obliged, my lord.
Cell number 3, Sandhya.
It's a matter where, my lord, the court notice may require for the appellant. For this reason, my lord, we also wrote a letter, my lord, seeking further instruction from the appellant. We're not getting any.
Left on the one.
Please, my lord, for the appellant, what happened, my lord, it was
6
represented.
times.
Please, my lord, now the serve ಆಗ್ತಿಲ್ಲ. And my lord, the appellant, my lord, we also trying to contact, my lord, we are also unable to contact. So I also wrote a letter, my lord, acknowledgement bandilla.
Produce the acknowledgement.
Acknowledgement bandilla. I just wrote a letter, my lord.
Letter la post. You have sent notice and
Please,
RPD.
please, my RPD ಕಳಿಸಿದ್ದೀನಿ. So
Petition for divorce is allowed.
please, my lord, the wife's appeal, husband's petition is allowed on the ground of cruelty. 2010 marriage, my lord, now I don't know, my lord, parties might be moved. The respondent has not been served, my lord.
This is very repetition. You are going to file the acknowledgement, then we'll list on some other day.
Acknowledgement ಅದು 23 ಅಲ್ಲಿ ಕಳಿಸಿದೆ ಸ್ವಾಮಿ ಬಂದಿಲ್ಲ acknowledgement. I may need to issue. On the my lord, I may issue once again notice because of the want of acknowledgement. You see, appellant was represented by
respondent. Yes, to 5 times ಆಗಿದೆ.
5 times ಆಗಿದೆ. ಸರ್ವ ಆಗ್ತಿಲ್ಲ.
Now, for the appellant submits that. Despite his issuing notice, the appellant is not turning up. Already sufficient time is granted. Finally, if you get the acknowledgement in the meantime, we will grant you 10 days time, we can file it.
I have to issue one more notice. Acknowledgement ಬಂದಿಲ್ಲ. I will issue one more.
Postal tracking system ಇರುತ್ತಲ್ಲ.
ಅದು ಸ್ವಲ್ಪ 6 months ಅಷ್ಟೇ ಇರುತ್ತೆ ಸ್ವಾಮಿ. 6 months ಆದ್ಮೇಲೆ ಅದು ಡೀಟೇಲ್ಸ್
6 months back.
6 months back ಅದು acknowledgement ನಾನು ಟ್ರ್ಯಾಕ್ ಇಟ್ಕೊಳ್ತೀನಿ.
2 weeks time is granted to the failing which the appeal shall stand dismissed. 2 weeks ಕೊಡ್ತಾ ಇದೀವಿ ಅಷ್ಟರಲ್ಲಿ ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಹೇಳಿ ಕಳಿಸಿ.
ಅಲ್ಲ ಇವತ್ತೇ ಕಳಿಸಿ.
Yes.
Please.
Cell number 4, Shashikant.
ಇದು ನೋಡಿ 5/8/2023 for recalling. DDA date is wrongly mentioned. Delays date to be mentioned. Second set ಇಲ್ಲ ಅದರಲ್ಲೂ there are so many errors ಅಂತಾರೆ. ಇಲ್ಲಿ second set ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. 5/2022 what is the order? 2022 application ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ? 23 ಅಲ್ಲಿ. Again they will not no representation for the appellant. Finally, 10 days time is granted to Do the need to failing which I 1 and 2 of. Sorry. Failing which ಆಗಿದೆ ಅಲ್ಲ previous one. No representation for the appellant. The preliminary order dated 3/6/2024 is not complied. Therefore, I 1 and 2 of 23 already stood dismissed. No further orders are required.
Seal number 5, Basvaraju.
Filed
Third time.
counter file ಮಾಡ್ತೀವಿ ready ಇದೆ.
Pardon?
PF ready ಇದೆ madam. Counter file.
But that is returned, not in station ಅಂತ ಬಂದಿದೆ.
ಅದೇ address ಅಲ್ಲಿ ಇದೆ ರೆಸ್ಪಾಂಡ್.
Furnishing PF issue notice. Fresh you have to give it.
Press notice.
At request. Third time ಅಂತ ಬಂದಿದೆ.
Same address refuse ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Receive ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Not in station. You have to take
How
it.
many times go it?
Trial court ಅಲ್ಲಿ. She had contested before the trial court. At request finally, yes, ಯಾವ year is appeal 2020.
21 madam.
2 weeks time is granted to do the needful, failing which the appeal shall stand dismissed. Yes. 2 weeks ಕೊಡ್ತಾ ಇದೀವಿ.
Acha.
Application ಹಾಕೊಳ್ಳೋದ್ರಿಂದ ಹಾಕೊಳ್ಳಿ.
Seal number 6, Tukoji Rao HS.
Appellant's counsel. It's an appeal challenging an order of the learned single judge admitting a company petition. I'll not detain the court for too long. Please be kind enough to come to.
No, office objection.
No, that has been complied with. That is on court fee
By
that's been paid.
No, annexure to be attested by competent authority. Non-furnishing of the memo as per order dated 22.
That memo was insofar as court fee that's been done. I'm told it's been done.
But registrar has not placed it.
I will look into that. The court may just kindly see what the
Uh,
application before the court is for stay. Please be
Right.
kind enough to come to bottom of page 11.
Correct, unless you rectify the office objections, how can we hear you?
It has been done. I'm told
But
it's been.
we'll pass it over, let the
Please.
registry verify and list it at 2:30. I mean, we'll take it
Agbodu,
at
or
2:30.
please keep it, I mean, any short date the court may please keep.
30 madam, in some.
I'll leave it to the court, I'll leave it to the court.
Learned counsel for the appeal. If they are not done, they ask them. to be-
ಶುಕ್ರವಾರ ಆಗ್ಬೋದಾ? Great. ಅಲ್ಲ ಯಾಕಂದ್ರೆ in case they need to check it up, it may take some time. 2:30 ಅಂದ್ರೆ ಅವ್ರ ಮೇಲೂ it's unnecessary pressure. ತಾವು ಶುಕ್ರವಾರ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ
See, if they have complied it.
I quite see.
Because
ಮಾಡಿದ್ದಾರೆ. But even to verify, it puts unnecessarily a strain on the registry. That's why I'm requesting the matter can be taken upon.
Sir,
ಅಲ್ಲ ಡ್ಯೂರಿಂಗ್ ದ ಡೇ ಅಂದ್ರೆ ಎಲ್ಲರಿಗೂ ಸುಮ್ನೆ ಒತ್ತಾಯ ಆಗತ್ತೆ ಅದರಿಂದ ಇನ್ನೇನಿಲ್ಲ.
file ಹೋಗ್ಬೇಕು.
ಹೋಗ್ಬೇಕು ಬರ್ಬೇಕು, it is just an unnecessary pressure.
Oh, ಅಲ್ಲಿ ಇದೆ ಅಂತೆ, branch.
ಅದಕ್ಕೆ, that's why I'm saying.
Comply.
It is not within the court campus, that's why I'm
21/6.
21, great.
Because ಅವರೇ ನಮಗೆ ಕೊಡಕ್ಕಾಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಹಾ, ಅದು ಕಾಂಪ್ರಮೈಸ್ ತಗೊಳ್ಳಿ, ಅದಾದ್ಮೇಲೆ ಅಯ್ಯ ಆರ್ಡರ್ಸ್ ನಂತರ ತಗೊಳ್ಳಿ. No, not your man, some other.
ಅಯ್ಯೋ, ಅದು ಸಾಧ್ಮೆಂಟ್
No, ಕಾಂಪ್ರಮೈಸ್ ಮೊದಲು.
Seal number 36, SN Bhatt.
ಅವರು ಇನ್ನು ರಿಯೂನಿಯನ್ ಮಾಡಿದ್ರೆ would have been more happy. What is the decree passed? Petition partly allowed. Dissolved by decree of divorce. Petition was under section 13(1)(b) and 3. Then unsoundness. So what is the 3 is for medical ground, alva?
Please, my lord. 13(1)(1)(b), 3, my lord.
1B is for desertion, no? 3 is for medical ground.
Medical ground.
They have raised that as ground below.
On which ground it was allowed, on which ground? First ground, desertion, intentionally deserted, that was negative, held negative. Negative. Finding, whether petitioner proves that respondent has been suffering from continuously for mental disorder in the affirmative.
Now
In
the
the affirmative,
divorce was granted on 13(1)(3), my lord.
that is mental health ground.
Please, what the learned judge of the family court has given a finding that there is an evidence from the hospital at Bangalore, my lord. That's Nimans. The evidence led by them.
Record the compromise. Now, if there is a finding that she's suffering from mental ill health,
The mother is present, my lord.
ಒಂದು ಫೈಂಡಿಂಗ್ ಆಗಿದೆ ಅಲ್ಲ ಟ್ರಯಲ್ ಕೊಟ್ಟಿಂದ
Parents are present.
ಡಾಕ್ಟರ್ ಯಾರವರು no doctor is examined PW2 Shankara doctor was examined before the trial court.
No, my lord.
Petitioner has filed the affidavit, examined himself as PW1.
No, my lord. Only
The
parties.
records of Nimans to substantiate the claim with regard to response mental health. So only he and got the same mark to PW2. Records ಬಂದಿದೆ. Who is PW2? Who was PW2? No, very administrative. PW2 was some administrative officer or doctor?
He is an officer, my lord.
PW. PW1. ಅಲ್ಲ ಹಾಗಿದ್ರೆ ನೀವು ಮತ್ತೆ ಅವ್ರಿಗೊಂದು ಗಾರ್ಡಿಯನ್ ಅಂತ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿಸ್ಕೋಬೇಕಾಗುತ್ತಲ್ಲ
Guardian, no.
ಸಮಾಲೋಚನೆಗೆ. No, he is the administrative officer. Nimans the doctor examine ಮಾಡಿಲ್ಲ ಅವರು.
Doctor was not examined. That is the reason.
Only
Ground what I raised before.
Court has held that decree is granted on that ground, not on the ground of desertion.
Please, I'm not disputing that, but because
Our difficulty is when there
and
is a
I could
finding.
understand, my lord. I could understand, but her mother is also present today.
Prima facie we have to satisfy. We have to now ಮಾಡೋ ಸಾಕಾಗೋದಿಲ್ಲ. Again, we have to refer her to Nimans only. It's little difficult for us to record it. What she is doing? ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ?
ಕೆಲಸ ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ. She is not on working. She is a housewife. And now presently she is residing with her in parental home. She is residing.
ಅಲ್ಲ ತಿಳ್ಕೊಳ್ಳೋಕ್ಕಲ್ಲ, ತಿಳ್ಕೊಂಡು ನಮ್ಮ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಮೆಡಿಕಲ್ ಇರಬೇಕಲ್ಲ. Now she has signed the petition. There is a finding.
She has filed a petition and now she has also filed a.
ಕೆಲಸ ಮಾಡುತ್ತೆ ಹೇಳಿ ಪಿಟಿಷನ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ಬೇಕಾದ್ರೆ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ we have to refer her to some medical examination if she is capable because doctor was not examined.
Please, I'm not.
The finding is
That
apparently
is the one of the grounds what I have raised
incorrect.
also.
That seems to be incorrect because they could not have given such finding in the absence of medical evidence. What to do now?
Now my request is that she could be referred to some psychiatrist regarding that.
Now,
So
report bandre we can hold that as per the report she is mentally fit to get enter into a agreement.
Lord, my submission is, since the matter is settled between the parties, we don't want to press on the medical issues. We have given some certain,
Trial court finding record ಆಗಿದೆ ಅಲ್ಲ.
of course, my lord, but what we want is we want a divorce, that's all. Ground,
Correct. ಈಗ court has to satisfy that the parties have entered into the agreement.
please, my lord, please,
One
my lord.
week ಆಗುತ್ತೆ ನಾವು ನೀವು ಹೇಳ್ದಾಗ ಇಲ್ಲ ನಿಮ್ಯಾನ್ಸಿಗೆ ರೆಫರ್ ಮಾಡ್ತೀವಿ ಹೋಗಿ ಬಂದ್ಮೇಲೆ we can also record that no doctor was examined by the trial court. We can record that. 1 week ಎಲ್ಲಿಂದ ಬರ್ತಾರೆ ಅವರು?
Mysore.
ಮೈಸೂರಿಂದ.
ಮೈಸೂರಲ್ಲಿ ಒಂದು ಇದ್ರಲ್ಲಿ ಇದೆ ಬೇಕಾದ್ರೆ ಅಲ್ಲಿಗೆ ಮಾಡಿ JSS ಅಲ್ಲ ಅಲ್ಲಿ KR ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಒಂದು ಇದಿದೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ ಅದು ಸೈಕ್ಯಾಟ್ರಿ ಇದು ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಶಿ ಇಸ್ ಫ್ರಮ್ ಮೈಸೂರು.
She is from Mysore.
ಅಲ್ಲೇ ಮಾಡಿಸ್ಕೊಂಡು ರಿಪೋರ್ಟ್ ತಗೊಂಡ್ ಬರ್ಲಿ ಬೇಕಂದ್ರೆ ನಾವಿಲ್ಲಾಂದ್ರೆ DLS ಗೆ ರೆಫರ್ ಮಾಡ್ತೀವಿ ಅಲ್ಲಿಂದ ಹೋಗ್ಲಿ ಬೇಕಂದ್ರೆ ರಿಪೋರ್ಟ್ ಅವ್ರು DLS ಏನವ್ರು ಕೊಡ್ಬೇಕು ಇಲ್ಲ ನಮ್ಗೆ ಡೈರೆಕ್ಟ್ಲಿ ನಮ್ಗೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬೋದು. ಆಸ್ ಯು ವಿಶ್ ಇಲ್ಲಿ ಕಳ್ಸೋಣ ಅಂದ್ರೆ ಇಲ್ಲಿ ಕಳಿಸ್ತೀವಿ ಇಲ್ಲ ಅಲ್ಲಿ ಕಳ್ಸೋಣ ಅಂದ್ರೆ ಅಲ್ಲಿ ಕಳಿಸ್ತೀವಿ.
Since mother is present, she may be represented by mother.
ನಿಮ್ಗೆ
She may
ಈಗ
be.
ಅರ್ಜೆಂಟ್ ಇರುತ್ತೆ ಬಟ್ ವಿ ಕಾನ್ ಹ್ಯಾವ್ ಯು ರೆಡ್ ದ
I
ಪ್ರೊವಿಷನ್ಸ್ ಆಫ್
understand.
ಮೆಂಟಲ್
Please, ma'am, please, I
ಇಟ್ಸ್
understand.
ಸೀರಿಯಸ್ ಮ್ಯಾಟರ್ ಬಟ್ both parties and counsel are present. They submit a joint memo. $35 lakhs. We understand your anxiety and getting it disposed of early, but we have the responsibility in recording this
Understand, ma'am.
case.
ಅದು ಹೇಳಿ
Joint memo appointed by the
ಅಲ್ಲ,
parties.
ನೀವು ಮಾಡಿ.
Right is
ಅದು-
submit the execution.
Well,
Mhm.
my lord, if the court permits,
Okay.
just to settle the dispute between the parties, I want to make a submission.
Yes, sir.
Uh, It is not that we want to prove the medical grounds, everything in future also. We want to withdraw the, if the court permits, I can withdraw the allegations of medical grounds so that you can, your lordship can record and.
But then we have to record that she has agreed for this settlement. Even if you withdraw, the trial court has recorded a finding.
Yes, ma'am,
That
that
she
is there.
is,
Record is
that is
there.
the whole problem.
Reasonings ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, but it's a periodical, it is not a regular mental. This thing.
That
It's a
seems to be
periodical.
ಯಾಕಂದ್ರೆ ಅವ್ರು ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡದೆ ಮಾಡಿದ್ದಾರೆ ತಪ್ಪು. ಯಾಕೆ ಹಾಗೆ why it was done like that? Without examination, how the trial court held that that ground is proved?
There are medical.
They did.
Under judge has come to the conclusion on the basis of some record from the Nimanj.
Exhibits P4, P3, P4, P5.
W1 has filed a.
Lord, from the P5, 6 and 7 below.
ಇಲ್ಲಿ
Three to
PW
And also P3 if is an outpatient record of
They
KR
have to
Hospital,
commit
Mysore below.
suicide.
It is only from the 3 to 7. One from KR Hospital, and 2 is for 1 from JSS Hospital and 3 from Nimanj.
She has denied taking treatment in Nimhans and Care Hospital. Oh, she had taken in Care Hospital also as per these records. ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ಮದರ್ ಅನ್ನ ಒಂದು ಗಾರ್ಡಿಯನ್ ಅಂತ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ದೆನ್ ಅಟ್ ಲೀಸ್ಟ್ ವಿ ಕ್ಯಾನ್ ಡೂ ಇಟ್.
Now, if your lordships accept that she could be appointed as a guardian and on the basis of the matter is concluded, says I will file an application immediately. It could be taken about 2:30 below.
What do you find better way?
My lord, it's
Because now there is a.
now keeping pending for a
If we keep,
referring to the matter once again, Dr.
once we permit her to be represented through the guardian, that finding that she was ill, we are also feeling little in a fix here.
ಹೆಂಗ್ ಮಾಡಿದ್ರು ಒಂದ್ ರೀತಿ.
ಅವ್ರು ಯಾರು ಡಾಕ್ಟರ್ನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ, ಓನ್ಲಿ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗಿ ಫೈಂಡಿಂಗ್ಸ್ ಕೊಟ್ಟಿರೋದು.
Otherwise, we have to record that you are withdrawing that allegation.
Please, my lord,
Secondly,
it may be
we have
recorded.
to touch the trial court finding also.
Please,
Trial court
please.
has not, without any examination of the doctor, though she had disputed the documents, it has arrived at conclusion, so that is not sustainable anta ಮಾಡಬೇಕಾಗುತ್ತೆ ನಾವು.
My lord, may I make submission, sir? The order was passed on the ground of 13(1)(3), my lord, can be set aside. And in view of this compromise petition, all the things,
That's what.
it could be, a matter could be settled, ma'am.
ಹಾಗೆ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.
My lord,
Now you have said in your this thing, you are
on
withdrawing.
the ground that
Please,
the
my lord. Para number,
materials are not there, that
Which paragraph?
para number 4 regarding withdrawal, my lord, I have not, my lord. Because just now,
You have not said that you have withdrawn those allegations.
no, it's just, it is,
You-
ಈಗ submission
All
ಮಾಡ್ತಾರೆ.
right, we can understand if they want to rest, we have some.
paras 23 of the judgment, my lord, may kindly
We
receive
saw that.
what the learned judge has.
We saw that because that was apparently seems to be incorrect without medical examination of the doctors. That should not have been accepted as the answer. You file a better memorandum of joint memorandum of facts. So that we can, as he said, we can set aside that finding. Still, we can grant the decree for divorce by
Not-
mutual consent.
Please, my lord, my submission is.
ಇಲ್ಲ
since-
ಅಂದ್ರೆ ಇಲ್ಲೇ ನೀವು ಅದನ್ನ 13(1) ಪಿಟಿಷನ್ ಮಾಡಿ ಹಾಕ್ಬಿಡಿ. ಅಂದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ under section so and so ಅಂತ. But ಏನಾಗ್ತೀರ ನೋಡಿ, you make it, you find it in a better way.
Kindly pass over, my lord, at 2:30 we'll make.
ಅದೇ ಈಗ ಇರೋದ್ರಲ್ಲೇನೆ ಇನ್ನೊಂದು ಎರಡು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲಿಗೇಷನ್ಸ್ ವರ್ ಮೇಡ್ ದೇ ಆರ್ ವಿತ್ಡ್ರಾನ್ ಅಂತ ಮಾಡಿ ಡಿಸಲ್ಯೂಷನ್ ಕ್ಯಾನ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ಬೈ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಅಂತ ಮಾಡಿ
Please. Kindly pass over.
ಅವ್ರದ್ದು ಇದನ್ನ ಕೊಡಿ ಜಾಯಿಂಟ್ ಮೆಮೊರಿ
It could be taken about 2:30.
230.
Hearing on IA matters. Cell number 7. Rama Ramachandra here.
My lord, for the appellant in this
A.
matter,
Shivarama.
Mother, the court had directed us to file the assets and liabilities, but we couldn't serve the copies, my lord.
CDF 476 page, attachment of salary. Whom do you represent here?
Appellant, my lord.
Appellant. Oh, yeah.
We have filed, as per the court order, we have filed the statement of.
File it later on, my lord. I'm
There's
sorry.
a statement of objections.
No, two have filed, statement of objection also have filed, and statement of assets and liabilities also has been filed.
Correct. Now there is delay condonation application is pending. Hello. MNT 3383. I'm sorry.
Cell number 7.
Sorry. Maintenance filed by the appellant, statement of objections, original salary certificate. Non-compliance of office objections raised on IA 2 of 2023. What is that? Counter objections to the application filed by appellant under non-filing of affidavit of assets and liabilities statement by the advocate for the appellant.
We are filing the fresh one, my lord. We'll file memo to not press that, my lord.
Correct. You have filed it or we are going to file it?
We are going to file it, my lord.
What is this IA 2 and 2023 office objections on that?
That is under section 24, we had filed an application seeking maintenance, my lord, interim maintenance.
You have filed it in 2023. So far you have not complied with the office objections.
My apologies, my lord. We will comply it today, my lord, in the course of the day.
ಒಂದು ಫ್ಲಾಗ್ ಹಾಕಿರ್ತಾರೆ ಯಾವ್ದಲ್ಲ ಸಿಗೋದೇ. ಇದು 1 of 2020. ಅಲ್ಲ 2020 no office objections ಇಲ್ಲ IA 2 of 2020. ಇದೆಲ್ಲ IA 2 ಅಲ್ಲಿ objections ಅಲ್ಲೊಂದು
My lord, sorry, my lord, that is IA seeking under section 91, my lord, we had filed.
Got it. Is that proceed direct the respond to produce the relevant documents with regard to his monthly income. Value is killing error and share. What is this? As filed IA for direction. Second set of IA 2 of 23 is not filed.
We will file, my lord.
ಮೇನ್ ಕೇಸ್ ಮುಗಿಯೋ ಹಾಗೆ ಇಲ್ವಾ? ಬರೀ ಇದ್ರಲ್ಲೇ ಹೋಗ್ತಿರ್ಬೇಕಾ?
One of the main cases is
comply of subsections and IA 2 of 23 pending which the said application shall stand dismissed. ಇದು ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಫಿಡವಿಟ್ಸ್ ಅದು ಅಷ್ಟೇ ನೀವು ಯಾವ್ದು which is IA 1 of 2019 in support of IA 1 of 2019 this affidavit has to be filed by you. Maintenance. Correct?
We had filed for interim maintenance, my lord.
Why you have not filed for?
We are filing another one, my lord. Last hearing date, you had directed us to file it under section 24, supporting with an affidavit, my lord.
Serial number 8. She has filed application for this maintenance.
Interim maintenance.
ಹೌದು ಅದನ್ನೇ ಹಾಕ್ಬೇಕು. 2019 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಇನ್ನೂವರೆಗೂ ಜಜ್ಮೆಂಟ್ ಹಸ್ ಕಮ್ ಇನ್ 2021. At request finally, at request finally 1 week time is guided to those and equal in respect of IA 1 of 2019 and 2 of 2023, failing which the said application shall stand dismissed. Based on 1 vara biಟ್ಟು. See, you argue the main matter itself, it can be.
We will argue the same day, my lord. Others documents on the same.
26/6.
First week. First week.
ಕಂಪ್ಲೇರ್ ಮಾಡ್ತಾರ ಇಲ್ವಾ ನೋಡೋಣ.
ಸರಿ.
Cell number 8. Kavita D. RP Somshekhriya Raghvan.
ಕನ್ನಡ ಅಲ್ಲ ನಾವು ಸ್ಯಾಲರಿ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಗೆ ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತೀವಿ ಸೊನ್ನೆ
Termination of delay allow ಮಾಡ್ಬೋದಾ? ಏನಿದೆ? Is it ex parte decree or
No, contested, my lordship.
contested?
I'm the respondent before the High Court.
Adultery. What is the reason you have assigned for delay?
There are 5 reasons as now raised by the honorable court, my lordship. One is that whether the court has got the matrimonial jurisdictions to entertain the petition, whether the petitioner has shown the sufficient cause and made out the valid grounds.
Petitioner filed the appeal instead of MFA, no?
Yes, my lordship.
Third, order Sunday number 1 of 2021. Third. ಅದಕ್ಕೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಬಟ್ ಸ್ಟಿಲ್ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಮ್ಯಾಟರ್ ಎರಡು ಹಾಕಿದಾರಲ್ಲ
ಎರಡು ಸುಮ್ಮನೆ ಒಂದು ಕಂಡೋನ್ ಡಿಲೇ ಸಾಲೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್
Delay of 476 means for attachment.
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಫ್ ಸಾಲೆ
My lordship.
in the interest of justice. IA 1 of 2021 is disposed of accordingly. ಇನ್ನೊಂದು you want to file
ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತದೆ ಸಾಲೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಇದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತದೆ
6 time. Respond number 1 and 1.
R1 to R1.
File counter to IA 1 of 2023. Okay. Admit by record or call for modern matter request written consultation. Admit call for TCR. List of the 2 weeks.
Much obliged. Seal number 9, Yashiv Kumar B.
Okay. Fill on the
My lords, for the petitioner, my lords, on behalf of KKB, my lords, I for
Date ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬರೋದೇ ಇಲ್ಲ. Yes.
my lords, I for substituted service of notice to respondent through a paper publication, my lords. My lords, the
He had contested before that High Court expert ಎಲ್ಲೇನು?
ex parte ಆಗಿದೆ madam, ಅಲ್ಲಿ family court ನಲ್ಲೂ ಆಕೆ attend ಆಗ್ಲಿಲ್ಲ.
Correct. Is it the correct address or not?
The address that we have known, we have sent it to that, my lords.
ಬರೀ ಒಂದ್ಸರಿ ಮಾತ್ರ ಹೋಗಿದ್ಯಾ? ನೋಟಿಸ್
ಇಲ್ಲ 3 ಸತಿ ಹೋಗಿ.
ಲೆಫ್ಟ್ ಅಂತ ಬಂದು ಒಂದೇ ಸರಿ ಹೋಗಿದೆ ಅಂತ ಕಡೆ. You produce her address proof, we'll see.
How do I
ಏನಾದ್ರೂ
produce?
ಇದೆಯಾ?
The address, what is there in the cost title is what we have, my lords. When she was residing, I guess she has changed the resident and we do not know where she has gone or changed the residence, my lord.
Then how, what was, and you say she was suffering from schizophrenia, etc. How do you serve on her? Marriage was reached it 2013.
13, my lord.
Petition was filed in 2019.
Yes, my
For 6 years, where she was residing?
She was residing in the same residence, my lords, and that is the address that we have sent the notice even in the lower courts and in the high courts, the appeal, my lords.
According to that was second marriage for her.
Yes, my lords.
What about you? What about him?
My lords, I am the proxy advocate for this matter, my lords. I do not know the details.
You take steps, but we have a doubt. First, ask him to furnish her address proof. In this matter, the respondent.
My lords, may I submit, my lord?
was
We have
expert.
exhausted all means of address, even in the lower courts.
It has gone only once.
Here,
In
my
the
lords?
trial court also, she was expert. So ask your colleague to furnish her address proof. We'll see. Last decided, it will be there.
Yes, my lords.
The appearance council shall furnish the address proof. ಅದಕ್ಕಿಂತ ಬದಲು ಇನ್ನೊಂದು ಬಿಟ್ಕೊಳ್ಳಿ. The records show that appellant alleged that the respondent was suffering from schizophrenia. And the notice left ಅಂತ ಬಂದಿದೆ ಅದು. Notice issued by this court is returned with endorsement address left. Appearance council shall furnish the address proof of the respondent. This from 2 weeks later.
37.
Obliged, ma'am.
Seal number 10, Prasanna VR, Manjunath Prasanna, appellant for the respondent in this case.
A2 of 20 for direction for state. Yes, Direction means maintenance.
Maintenance. Yes.
I have filed my objections.
Interim maintenance or?
Interim maintenance.
Maintenance, I have filed my objections,
How
Lordship, in
much,
this.
how much you have sought? This was an ex parte decree.
Yes, my lord.
Party. She was working and now also she is working. That was suppressed by her. I have filed her documents also, salary certificate, which she has produced in the DV court. I have produced salary certificate in the present salary certificate also.
Where it was produced?
In the objection statement, along with the objection statement, I have
No,
produced.
that salary certificate was produced in which court?
There
Here-
was
here
a case,
in
there is a case pending between the parties.
High Court, in High Court also I have
High court
produced.
also.
Yes.
Then
Criminal miscellaneous is pending before the trial court at Putturu, my lord.
There she
In
had-
which they have produced the document showing that I am working in Muthoot Finance, a private finance.
So
what
it's
is
a
the
sub-
salary? Even assuming she's working in a private institution, what is
Earlier
her
it was 12,000 rupees, but now
What-
it is
what
a private
Huh?
finance.
What, correct, private, what is her salary now? Are you aware?
I have no instruction. Earlier she has told that she was securing 12,000 rupees. But today
What he is doing?
He is also working in a private firm, Lordship.
What?
A private firm, and he is receiving only 35,000 to
So
40,000.
what is his designation? What is his qualification, educational qualification?
He's a degree graduate, that's all.
Graduate?
Degree, he's completed his
Yet
degree.
every day degree, correct? What degree?
BA, I believe so.
Both of you have to file your assets and liabilities.
Yes. That may be direction may be given to
Yeah,
them to
please.
file the assets and
Both of
liabilities.
you have to file affidavit of your assets and liabilities, at present or right? Both of you have to file.
But here, my lords, the ex parte, my lords, decree has been obtained by showing the incorrect address based on a fabricated
They have
document.
sought for interim maintenance.
Yes,
They are saying that she is also employed.
yes,
So both of you file your assets and
Yes.
liabilities
Please,
affidavit.
please.
Yes.
Consider this application.
please, please.
Both parties. Records, ಇದು admit ಆಗಿಲ್ವಾ ಇನ್ನು?
Admit ಆಗಿದೆ, but
Admit
an
ಆಗಿದೆ.
application
Records
for
ಬಂದಿದೆ.
interim stay is
Records
pending, my lords.
ಅಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ ಇಲ್ಲ ಅಲ್ಲೇನು ಎವಿಡೆನ್ಸ್ ಆಗಿರೋದೇ ಇಲ್ಲ ಇವ್ರು ಹೇಳಿದ್ದು.
Evidence, some documents have been marked. Exhibit P5 is the rent agreement.
ಇಲ್ಲ
subsequent-
ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಲಿಟಿಗೇಷನ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅಂತ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. You give the litigation expenses and matter can be remanded to give them an opportunity.
Please,
I don't have any objection for remanding the matter with the
But
direction.
litigation expenses ಇಲ್ಲಿದ್ ಕೊಡ್ಬೇಕಲ್ಲ.
She is also equally employed, Lordship. ಅದು
Because then-
unclaimed ಅಂತ ಬಂದಿದೆ, the same address.
Even if she is employed, litigation expense you have to give. See, now even if we, on contest, if we allow the appeal, we will impose cost because she was expert.
But at least let them.
If you succeed, then you will. ಒಂದು ಕೊಡಿಸ್ತೀವಿ ಒಂದು 10,000
exhibit
ರೂಪಾಯಿ ಕೊಡು.
P5 is the only document.
In maintenance is granted in any other cases?
No, my lords,
no,
I have
it's
filed a
pending.
petition under section 12 of the Domestic Violence Act, in which my lords, matter was referred to mediation. However, my lord, the respondent has not ready to either pay the maintenance or take back the petitioner, my lord.
Correct. What we are suggesting.
Yes.
You pay some litigation expenses here. These issues can be sorted out before the trial court. We can set aside the decree and remand it.
Lordship, let them file the assets and liabilities, my humble submission.
If-
Because
See, if at all on those grounds it is dragged here, ultimately, in all probability, it may be set aside and remanded because it was an ex parte decree. Grounds were? What were the grounds?
cruelty grounds.
Cruelty.
Yes.
What were the grounds of cruelty alleged?
She has not resided in the matrimonial home only. She has
That may amount to desertion.
desertion as well as she was giving mental torture, harassment,
Did
everything.
you examine
No.
what was that mental torture?
Examine PW1,
What
examine.
is the this life of the litigation? Litigation expenses ಗೆ ಅವ್ರು ಏನು ಬೇಕಿಲ್ಲದೆ ಕೊಡ್ಬೋದು. 20,000 or 15,000 ಕೊಟ್ಟು we will remand it. And ಅಲ್ಲ bottom ಅಲ್ಲಿ ಅಲ್ಲಿ decide ಮಾಡ್ಲಿ trial court ಅಲ್ಲಿ. Consider ಮಾಡ್ಬೇಕಂದ್ರೆ ಇಬ್ಬರದು ಅಷ್ಟೇ. Affidavit with that ಒಂದು ಬೇಕು. ಈಗ ನಾವು she is also employed ಅಂತ ಹೇಳ್ತಾರೆ. Litigation expenses ಅದನ್ನ they can pursue their trial. ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ ಎಂಪ್ಲಾಯ್ಡ್
ಅವ್ರು ಹೇಳ್ತಾರೆ ಎಂಪ್ಲಾಯ್ಡ್ 2017 ಇದು ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಫೈನಾನ್ಸ್ ನಲ್ಲಿ ಏನೋ ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೆ.
ಅದೇ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ 2017 ಇದ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ ವಾಸ್ ಎ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸಿಸ್. ಐ ಆಮ್ ನಾಟ್ ಶೂರ್ ದಟ್ ಶಿ ಇಸ್ ಕಂಟಿನ್ಯೂಡ್ ಇನ್ ದಿ ಸೇಮ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್.
ಈ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಕೇಸಸ್
Of course, that is.
ಇವರು ಕೆಲಸ ಬಿಡ್ತಾರೆ ಇವರು ಕೆಲಸ
Of
ಬಿಡ್ತಾರೆ.
course, the only document exhibit P5, which is a
What
rent
we are
agreement.
saying is
Please.
ಒಂದಿಷ್ಟು litigation expenses ಕೊಟ್ಟು
ಆಗ್ಬೋದು. We have.
We'll do that. You are advocate
Please.
on record.
Yes, Lordship.
So we can do that. Litigation expenses, whether she is employed or not employed, you have to pay.
But very reasonable, I request Lordship, because both are employed. I have,
If you want some relief,
they have dragged the matter. She was staying in the same address. It claimed as unclaimed. It's not.
ನೋಡಿ ಮದುವೆ ಆಗೋವಾಗ ರಾಯಲ್ ಫ್ಯಾಮಿಲಿ ಐ ಆಮ್ ದ ಸೇನ್ ಆಫ್ ದಿಸ್ ರಾಯಲ್ ಫ್ಯಾಮಿಲಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಮೇಂಟೆನೆನ್ಸ್ ಬಂದ ತಕ್ಷಣ ನಥಿಂಗ್ ಪಾಪರ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಮುಂದೆ. ವರ್ಕಿಂಗ್ ಇರೋ ವಿಷಯ ಎಲ್ಲ ಇದರಲ್ಲಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲೂ ನಾನು ವರ್ಕಿಂಗ್ ಇಲ್ಲ ಅಂತಾನೆ ಬರ್ತಿದ್ದಾರೆ.
ಏನಿದೆ
ಅಲ್ಲ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಕೂಡ ಐ ಆಮ್ ನಾಟ್ ವರ್ಕಿಂಗ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ಸಪ್ರೆಸ್ ಮಾಡಿ.
ಇದು ಎಷ್ಟು IA 2020 na? The fee of 20 is for stay. Though the matter is listed for hearing on application, with consent of both sides, the matter is taken up for the final disposal. By the impugned judgment in the decree. The brief facts of the case are as follows: that the marriage of the appellant and respondent was solemnized on 22/8/2016. 3 years nalli petition hakidara. 22/8/2016. The respondent, it was a registered according to Hindu customs. The parties are Hindus. The marriage of the appellant and respondent was solemnized on 22/8/2016 at Padil, Dakshin Kannada. The respondent filed MC number 381 of 2019 before now go to the additional principal judge, second additional principal judge, Family Court, Bangalore, seeking a decree of divorce on the ground of cruelty. In the said petition, service of notice on the present appellant was held sufficient, and she was placed ex parte. The trial court, on recording the evidence of the respondent, present respondent, and on hearing allowed the petition. ಇಲ್ಲ 1A and 1B ಅಂತ ಎರಡು ಹೇಳಿದ್ದಾರೆ. ನಾಟ್
Petition is only under 1A.
ಮತ್ತೆ ಇಲ್ಲ ಅಲೋ ಮಾಡುವಾಗ 1A 1B ಅಂತ ಎರಡು ಮಾಡಿದ್ದಾರೆ. ಕರೆಕ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ನೋಡೋಣ. ರೆಕಾರ್ಡ್ಸ್ ಇದೆ. ಇಲ್ಲ TCS call. You have the copy of that?
I have certified copies notes. Please.
ಇಲ್ಲ TCS ಇದೆ ಅಂತ ಇದೆ. TCS ಕೆಪ್ಪಿಲ್ಲ ಅಂತ ಇದೆ.
Even decree notes says 1A only.
380. I'm sorry, correct, you are right. Petition is under section 1A.
Please.
ಇದರಲ್ಲಿ ಪ್ರಿಯಾಂಬಲ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ 1A ಅಂತ ಅಷ್ಟೇ ಹೇಳಿ.
Decree notes, you lost me kindly see page number 24 notes, 23, 24.
24 ಅಲ್ಲಿ 1A ಮಾತ್ರ
1A ಮಾತ್ರ ಇದೆ.
ಅದೇ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಮ್ಯಾನ್ಯುವಲಿ 1B ಅಂತ.
The certified copy now subsequently ತಗೊಂಡ್ರು after disposal.
Correct. Yeah, right. Even the decree produced by you, it's only 1A is shown. But in the operative portion of the judgment, the learned judge has corrected it by way of correction, handwritten,
Please.
included 1B also.
Delete ಅಲ್ಲ.
Allowed the petition. Petition and granted the decree of divorce. Even as per the decree and the preamble of the judgment, the petition was filed only under section 13(1)(1)(a). However, the operative portion of the judgment, in the operative portion of the judgment, a correction is made by the trial court, including trial court, while saying that the petition under section 13(1)(1)(a) and 1B of the Hindu Marriage Act is approved.
It appears not, it is struck down, not 1B is struck down.
Not struck down, it is
Inserted, not it is a typographical, not. Because not decree not reads 1A only.
ಅಷ್ಟೇ ಇದೆ. ಅದನ್ನೇ ನಾವು ಹೇಳ್ತಿರೋದು, ಅದನ್ನೇ
How? Please, please.
ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಇಲ್ಲ ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ.
Please, please.
Lord counsel for the appellant submits that where she was residing,
Lord, she is residing in Upinangadi, Lord.
not in this given address.
No, Lord, exhibit P5 I have flagged, Lord. So let me kindly see the rent agreement. Rent agreement was executed on 10/7, whereas the stamp paper is 11/7.
And she was residing alone, not with this.
Not in the said address, Lord. That is concocted document.
At the relevant time, the appellant was residing in Bangalore, but only showing. ಇದು ಬೆಂಗಳೂರು ಅಂತಾನೆ ತೋರಿಸಿದಾರಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ನಾನು
409.
Rental agreement, they were residing in rental house separately for some time. That's what we showed last resided address.
Correct. ಇಲ್ಲಿ 409 ಅಂತಾನೆ ತೋರಿಸಿದ್ದಾರೆ. Your exhibit P5 is rental agreement also, it pertains to the same.
that agreement, Lord, do not relates to the appellant herein, because by the time, Lord, she was hoosted.
See where she was residing according to you.
Upinangadi, my lords.
ಅದಕ್ಕೆ-
Ramanagara house, Upinangadi village and post. I have furnished the correct address in the cost statement.
Was residing at in Uppinangadi village, but the respondent showing the wrong address managed to get the service endorsement.
Unclaimed.
Unclaimed.
It's unclaimed.
Endorsement ಅಲ್ಲ ಅದು.
Yes. It's unclaimed.
Service ಅಂತ ಇದೆ, but matrimonial case discretion is to the court, either they can ask for
This come as unclaimed lot.
to get an endorsement. Endorsement it did not come unclaimed. Anyway, it had come as unclaimed, no?
Unclaimed. Yes.
And secure the ex parte decree. Next one. ಮ್ಯಾರೇಜ್ ಆಗಿರೋದು ಉಪ್ಪಿನಂಗಡಿಯಲ್ಲಿ.
Yes.
Admittedly as per the parties, the
Puttur,
marriage
madam.
took place ಉಪ್ಪಿನಂಗಡಿ ಅಂತ ಏನೋ
ಅದೇ ಉಪ್ಪಿನಂಗಡಿ ವಿಲೇಜ್ ಪುತ್ತೂರು ತಾಲೂಕು. ಕೋಟೆಚ ಹಾಲ್ ಈ ಸೆಟ್ ಮಿನೋಟ್ಸ್ ಪುತ್ತೂರು.
ಉಪ್ಪಿನಂಗಡಿ ವಿಲೇಜ್ ಪುತ್ತೂರು ತಾಲೂಕು, ದಕ್ಷಿಣ ಕನ್ನಡ. The petition is filed within 3 years of the marriage. Before the trial court, ಏನ್ ಕೊಟ್ಟಿದ್ರು ಅಡ್ರೆಸ್ ಅನ್ನ? Statement of accounts, photograph receipts? No, nothing. Rental agreement exhibit P5. ಅದು his address, that is his address.
ಹೌದು.
Both were.
Correct ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಿರೋದು. ಅವ್ರ ಹತ್ರನೇ ಇದ್ರೆ ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಅಂತ ಹೇಗೆ ಬರುತ್ತೆ ಅದು? If she is living with him only?
Both they were residing in the same address in the rented
No,
house.
She was, see, address proof of a particular person you have to give. Your rental agreement is not the address proof. The respondent producing the rental agreement which was in his favor claimed that that was the address proof of the appellant also. There was no actual address proof. 65B evidence, then CD What is that CD?
That is what the respondent claims that is a message exchanged between the parties through WhatsApp.
She needs
She
divorce.
used to pay some amount to the respondent. That's what.
Therefore, there is some force in the submission of appellant's counsel that the address insert notice was not served on her, not served on the appellant. A fair opportunity needs to be given to the appellant before throwing her out of the Solomon institution of marriage. Institution. So also she is, even though it is contended that the appellant was is also gainfully employed, the interim maintenance or interim alimony or permanent alimony issue can be decided by the trial court, and the appellant respondent has to pay litigation expense of this case. The matter, the impugned judgment can be set aside and matter can be remanded to the trial court for fresh consideration after giving the opportunity to the appellant.
One kind request, Lordship, direction may be given to dispose it within 6 months.
Appearance of the parties, but you have to pay that amount, you have to deposit there. And you,
I kindly request a reasonable amount. He is also not having much income from.
brother is saying 25,000 is reasonable.
Reasonable, you are not paid any maintenance. Here 25,000, nothing will happen.
Hence the following order. The appeal is allowed. The impugned judgment and decree dated 1/8/2019 in MC number 381 of 2019, passed by the second additional principal judge family court Bangalore, is hereby set aside. The matter is remanded to the trial court for fresh consideration and giving opportunity to the both parties. Both the parties. The respondent, to avoid further delay, the party shall appear before the trial court on date 15/7/2024 without any further notice. The respondent shall deposit, respondent herein shall deposit, the respondent / husband deposit litigation expense of ₹25,000 before the ಅಲ್ಲೇ ಮಾಡ್ಲಿ ಬಿಡಿ. I'll deposit ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅನ್ನೋದು ಇದೆ ಅದು 25,000 before the trial court. Next, the appellant wife, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋದು. And on such deposit, the trial court shall release the same to the appellant wife. She shall file her statement of objection. ಅದು ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು appearance ತಕ್ಷಣ. ಅಲ್ಲದ ಏನು? You file it on the date of appearance.
I have to secure
Shall
instructions.
file her statement of objection within 30 days from the date of her appearance.
Please.
Thereafter, what mediation, thereafter,
Mediation failed in the DV case, Lordship.
dispose of the matter in accordance with law, as expeditiously as possible, at any rate within 6 months from the date of appearance of the parties, a statement of objection.
Statement.
6 months from the date. Family court ಅಲ್ಲಿ
ಅಲ್ಲ, ಯಾಕೆಂದ್ರೆ-
6 ತಿಂಗಳಲ್ಲಿ ಮುಗಿಬೇಕು ಅಂತ ಇದೆ.
ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಮಿತ್ತ mediation
Every time prolonging the matter, Lordship.
You could have filed your statement of objection on the date of appearance itself. 2020 case ಇದು. Appeal itself is. ಅದ್ರಲ್ಲಿ ಬರ್ಕೊಂಡು. She shall pay. ಈಗ ಅವ್ರು ಮಾತ್ರ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು appearance ದಿವಸ.
ಅಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಮತ್ತೆ ನಮಗೆ ಅಲ್ಲಿಂದ ಪುತ್ತೂರಿಂದ ಇಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎವಿಡೆನ್ಸ್ ಬರಕ್ಕಾಗತ್ತ, ಅದಕ್ಕೋಸ್ಕರ ಐ ಮೇ ಹ್ಯಾವ್ ಟು ಸೀಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಅಲ್ಲಿ ಪುತ್ತೂರಿಂದ ದಿ ಅಪಲೆಂಟ್ husband himself claimed that I am employed. Lords, if I am employed, lords, she may find it difficult to travel. That is why, lords, I have to secure some instructions from the party with respect to.
The date of the filing of the statement of objections.
Please.
Okay.
Please. Okay.
Cell number 11.
Obliged, Lord.
Hanmantappa A.
The appellant is at liberty to seek remedy before the trial court for interim / permanent alimony and litigation expenses.
Obliged.
Illi litigation expense.
Good. Much.
Obliged.
Cell number
Any
11.
ways to dispose of it.
For appellant, madam.
For respondent in this case, Your Honor.
Respondent filed a IA for recall
time ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ ಇದು.
ಹಾ.
What is the order dated 10/11?
10/11/2022, Your Honor.
20,000 litigation expense was awarded, my lord. He's seeking for a recall of that order.
Therefore, the appellant is also government employee, Your Honor. City Civil Court has FDA, Your Honor. He has more than 41,000 per month, Your Honor. Respondent is a retired government employee, Your Honor. His pensions more than
Correct. What is the appellant? Who
appellant,
represents you?
government employee, Your Honor.
Appellant, my
City
lord.
Civil Court is a FDA clerk, Your Honor.
What she is doing?
She's in FDA, my lord,
FDA
in a
civil-
court, my lord.
Civil court, Your Honor.
Civil court. And he is also no retired Kannada Culture Department, is working as a in Kannada Culture Department, my lord. He was retired on 31/12/2019.
She is
Only 20 litigation expense, not maintenance, my lord. It
Correct.
was heard, my lord, heard, and there is order has been passed.
Yaವಾಗ when did he retire? After this order or before?
2019.
This order, Your Honor.
After this order.
Alala, trial court after us, 2020. Salary, pension salary certificate is produced, Your Honor, dated
She is also FDA.
16/12/2021, 13,975, Your Honor.
What is the decree granted? On contest only it is granted.
Yes, ma'am.
Yes, Your Honor.
It was heard and thereafter order.
Again, a marriage invitation card, certified copy of the order sheet in MC number so and so. Certified copy of mediation report.
Yes, yes.
Very important in proof of this reality.
Ah.
Now she is also employed.
Yes, Your Honor.
Why do you insist for that?
Litigation expenses, my lord, not maintenance, my lord.
Litigation expenses adreno, it is.
Because of unnecessary litigation, my lord, he was started, my
No,
lord.
no, no, Your Honor.
We are entitled petition will be
Earlier, my lord,
dismissed with cause.
hello.
Or this appeal will be dismissed, allowed with cause.
Earlier, my lord, they filed an
Here she has filed a complaint before.
two MC petition filed
Police
before
were
the
on.
trial court.
Not appeared on that day.
Please, my lord.
Yes,
It was an ex parte order.
yes, my lord.
We'll recall that order. Orders recall model. Orders on IA 1 of IA 1 of 2023
Job.
on her.
Ten amendment benefits, my lord, got more than 50 lakhs, my lord, and also owns a house.
No, Your
20,000 rupees, my lord, for litigation. Even though, my lord, I'm employee, my lord, that doesn't mean that litigation expenses, my lord. Because of he filed an MC petition before the trial court, my lord, it was continued proceedings, my lord.
Section 25 or
24, my lord.
24. ಇದು ಅಲ್ಲ, this was granted ex parte. He was
Ex
not,
parte.
he was unrepresented on that day. ನಿಮ್ಗೆ ಲಿಬರ್ಟಿ ಕೊಡ್ತೀವಿ ಬೇಕಂದ್ರೆ ಹಾಕೊಳ್ಳಿ 24. Then you have to submit your assets and liabilities, etc.
Yes.
ಮಾಡ್ಕೊಳ್ಳಿ.
Earlier order, I filed objection, my lord, to the application.
Challenging the judgment and decree of divorce granted against her on the ground of cruelty and desertion. The wife has referred this appeal. The respondent, husband though served, was unrepresented. This court on 10/11/2022, on admitting the appeal, she had filed IA 1 of 2021. ಏನ್ ಹಾಕಿದ್ರಿ IA 1 of 2021 ಅಲ್ಲಿ? 21 ಅದನ್ನೇ as if interim. IA 2 of 2021 is for stay.
Yeah, one for direction, my lord, two for 21 is stay.
ಕೊಟ್ಟಿದ್ದಾರೆ. But it was not an ex parte decree.
No, Your Honor, it is a contested matter, Your Honor.
She is employed. What is her salary?
More than 40,000.
ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. FD
40,000,
ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ?
judicial department.
ಜುಡಿಷಿಯಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
Civil court, Your Honor.
ನೀವು you were employed in which department?
Kannada
ಕನ್ನಡ
culture.
ಮತ್ತು ಸಂಸ್ಕೃತಿ ಇಲಾಖೆ ಸುಮ್ಮಿ.
ಕನ್ನಡ ಮತ್ತು
ಸಂಸ್ಕೃತಿ ಇದೆ SDA, Your Honor.
He was SDA.
SDA. 2020 he was retired, Your Honor.
Children are there out of the marriage?
No issues.
No issues,
No
Your
issues,
Honor.
my lord.
It is only, it seems only for the preliminary, it seems.
Yes.
3,000.
ಅದನ್ನ recall ಮಾಡ್ತೀವಿ, we'll hear you both on this, ನೀವು ಬರೀ litigation expense ಮಾತ್ರ ಕೇಳಿದಿರಿ, one of the.
First time litigation expense only. I am not seeking for a maintenance. In fact, my lord,
No, now we were saying.
one more MC is filed before the family court, my lord, for restitution of conjugal rights. And that was settled, my lord. He agreed for to take back the appellant, my lord. ಕರ್ಕೊಂಡು ಹೋದ್ರು, ಮತ್ತೆ ಅದಾಗ್ಲಿಲ್ಲ, ಮತ್ತೆ ಡೈವರ್ಸ್ ಹಾಕಿದ್ರು. He continues of litigation, my lord.
Correct. ನೀವು ಇದರಲ್ಲಿ why did you not seek any permanent preliminary? You were arguing that he owns several properties, etc. ಹಾಗಿದ್ರೆ ನೀವು
only seek
ಕೇಳ್ಬೋದಿತ್ತಲ್ಲ, ಬರೀ litigation expense ಯಾಕೆ ಕೇಳಿದ್ರಿ?
only litigation expenses, my lord.
ಅಂದ್ರೆ ನಿಮ್ಗೂ ಬೇಕಿಲ್ಲ ಅಂತನಾ?
ಬೇಕಿಲ್ಲ ಅಂತಲ್ಲ ಸರ್.
But now you are saying that he owns.
ಅಲ್ಲ, ಎಂಪ್ಲಾಯ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, litigation expense ಅಂತ. ಮೇಂಟೆನೆನ್ಸ್ ಅಂದ್ರೆ ಎಂಪ್ಲಾಯೀಸ್ ಅಂತಾರೆ, ಅವ್ರಿಗೂ
more than 65 years on old several.
ಮದುವೆ 58 ವರ್ಷಕ್ಕೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. There is lot of age difference between them.
Think 52 years, 53 years, Your Honor. More than the appellant and respondent is age between 15, 16 years, Your Honor.
The petition was filed, he was aged 58 years as per your petition averment.
Yes, Your Honor.
And she was aged 43 years.
43 years. 2012 date of marriage, Your Honor.
Difference ಇದೆ. Was it the first marriage for him?
Yes, Your Honor. First marriage.
58 ಅಂದ್ರೆ ರಿಟೈರ್ಮೆಂಟ್ ಎಷ್ಟಿರುತ್ತೆ? ಮುಂದೆ 2 ವರ್ಷ ಇರುತ್ತೆ ರಿಟೈರ್ಮೆಂಟ್.
Yes.
ಮದುವೆ ಆಗಿದ್ದ ಯಾವಾಗ?
2012, Your Honor.
2012. Petition is filed in 2017 within 5 days. Sorry, 5 years.
5 years.
Recall ಮಾಡೋಣ. ನಮಗೂ ಕೊಡಿ. ಕೊಡ್ಲಿ ಬೇಕಾದ್ರೆ ಅದ್ರ ಮೇಲೆ ಪುನಃ we hear both of you. You furnish, both of you furnish your income too.
No problem.
Brother is saying we can say that, but 20,000 ಕೊಡಬೇಕಲ್ಲ ಅವರಿಗೆ.
Now is more than 49, 50,000, Your Honor. She is salary, Your Honor.
ಅಲ್ರಿ ಸ್ಯಾಲ್ರಿ ಆದ್ರೂ litigation expenses ಕೊಡ್ಲೇಬೇಕಾ ನೀವು?
Yes, yes, madam.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಕೇಳಿರ್ಲಿಲ್ವಾ ಮೇಂಟೆನೆನ್ಸ್ ಎಲ್ಲ?
She has no ask. She has filed maintenance petition DV Act, Your Honor.
it was
The
settled.
only compensation of is 5 lakhs order, Your Honor.
ಅದು ಕೊಟ್ಟಾಗಿದೆಯಾ?
ಅದು is stay ಆಗಿದೆ ಸ್ವಾಮಿ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ ಅದು.
ಅದನ್ನು ಕೊಟ್ಟಿಲ್ವಾ ನೀವು?
ಅಲ್ಲ, ಅದು ಅಲ್ಲಿ 50,000 ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ನಾವು.
ಅಲ್ಲ ಬರೀ 50,000.
ಅಲ್ಲ, 20% ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ ಹೈಕೋರ್ಟಿಗೆ ಬಂದಿದ್ವಿ, ಅದನ್ನ 50% ಮಾಡಿದ್ರು, ಡೆಪಾಸಿಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ.
Whether she has withdrawn that?
I don't know. A deposit the court.
ಈಗ ನಿಮ್ ಪೆನ್ಷನ್ ಎಷ್ಟು ಬರುತ್ತೆ?
I think 2021 15,375 rupees. I produced the copy, Your Honor.
ಅಷ್ಟು ಕಡಿಮೆ
13,975. ಅವ್ರ ಸರ್ವಿಸ್ ಕಡಿಮೆ ಇದೆ ಸ್ವಾಮಿ ಅವ್ರದ್ದು, ಅದಕ್ಕೋಸ್ಕರ.
ಸರ್ವಿಸ್ ಕಡಿಮೆ ಇದೆ.
ಸರ್ವಿಸ್ ಕಡಿಮೆ ಇದೆ ಸ್ವಾಮಿ.
ಇದೇನಿದು ಗವರ್ನಮೆಂಟ್?
13,978, Your Honor. Dated 15/12/2021.
So her net salary is 27,575. ಅವ್ರದ್ದು ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ? ಶಿವಕುಮಾರ್ 13,000. ಇದ್ರದ್ದು ಪೆನ್ಷನರಿ ಬೆನಿಫಿಟ್ಸ್ ಎಷ್ಟು ಬಂದಿದೆ?
More than 50 lakhs ಬಂದಿದೆ ಸರ್. Don't disclose.
No, Your Honor. I think 16 lakhs or 17 lakhs, Your Honor.
16 lakhs?
Total.
ನೀವು ಹೇಳೋದು ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲಲ್ಲ, ಈಗ you have produced your pension slip.
ಅಲ್ಲ, I produced the pension slip, Your Honor.
ಅದನ್ನ ಕೊಟ್ಟಿದ್ದೀರಿ, ನಿಮ್ಗೆ ಅನುಕೂಲ ಇರೋದನ್ನ ಕೊಟ್ಟಿದ್ದೀರಿ. ಎಷ್ಟು ಪೆನ್ಷನ್ ಡ್ರಾ ಮಾಡಿದಿರಿ ಅನ್ನೋದು ಕೊಟ್ಟಿಲ್ಲ. ಸರಿ, ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ಎಷ್ಟು ಬಂತು ಅಂತ ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
I think 16.
ಇರ್ಲಿ ಬಿಡಿ, ಕೊಟ್ಟಿದ್ದು. ನಾವು ವಿ ಆರ್ ನಾಟ್ ಫೈಂಡಿಂಗ್ ಏನಂತ has awarded rupees 20,000 towards litigation expenses. Response counsel seeks to recall the said order on the ground that he is retired, and whereas the appellant is still employed in judicial service. The appellant's counsel submits that respondent has drawn heavy pensionary benefits, and he has not even paid the maintenance awarded by the magistrate under the DV Act proceedings.
DV Act proceedings.
DV Act proceedings. Since
She has filed 498, Your Honor, is also acquitted, Your Honor.
If the respondent is retired, he has to pay the litigation expenses. Moreover, he has not produced any records in proof, any records to show how much terminal benefits he has received from his, after his retirement from the service. Therefore, we do not find any ground to recall the order dated 10/11/2022, hence the application is rejected. All right, admit ಆಗಿದೆ ಈಗ, admit ಆಗಿದೆ
Admit ಆಗಿದೆ.
final hearing now. 20,000ಕ್ಕೂ ಇಷ್ಟು ಅದಕ್ಕೆ ಒಂದಿಷ್ಟು ದಿವಸ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂತೀರಲ್ರಿ?
17. Seal number 12, Hanmantappa, Sampath.
This case matter for an appellant, my lord. This 24 applications filed by the appellant. Now they filed today filed an objection.
Filled up
Affidavit of
respondent.
Assets and liabilities are filed both the parties.
Have also filed.
I have also filed. Today I am filing objections to the application.
Now you have filed affidavit, no?
Affidavit is filed. The only ground is the divorce is granted under 13(1) Roman 1. Therefore, she is not entitled for maintenance unless the,
It has to be tested here, alva?
please, madam, therefore, main petition itself has to,
Tested here.
therefore, main petition itself has to be heard. Madam. She was only granted, my lord, on the ground, but a statement given by the children of the appellant, my lord.
Statement
Both.
given by the appellant before whom?
Before the trial court, my lord. Now they 27, my assets and liabilities, my lord.
Assets and liabilities produced by you, page 27.
Document number 7, my lord.
What is this?
This is a letter saying legal notice through advocate sent by the children of the appellant and respondent, my lord. ಈ ಮೊದಲು ನಿಮ್ಮ ಮಕ್ಕಳು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನೀಡಿದ ಹೇಳಿಕೆಗಳು ಅವರ ತಂದೆ ಒತ್ತಾಯ ಮೇರೆಗೆ ಆಗಿದ್ದು ಈಗ ಅವರು ನಿಮ್ಮ ಪರವಾಗಿ ಸಾಕ್ಷಿಗಳಲ್ಲಿ ಇಚ್ಛಿಸ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. They given evidence before the trial court matter that someone that one person has
Children have filed OS 630 of 2023.
that is for partition. They filed in a partition. Except mala oral evidence mala nothing is there. One night track mala.
Like, who has given this notice to whom?
To the appellant mala by the children.
Krishna, postal assistant. He is a postal assistant.
Please ma'am. He is the respondent ma'am.
ಅಲ್ಲ ವಕೀಲರಾದ ನಾವು ಅಂತ ಇದೆ. ಪ್ರೇಮರ್ ಅವರಿಗೆ ಮಧುಸೂದನ್ ಹಾಗೂ ರಾಕೇಶ್ ರವರಾದ ವಕೀಲರು.
There are the children. Children's ma'am.
So they had given evidence against the mother before the trial court.
Please ma'am. That's
What was their age at that time? Evidence ಕೊಟ್ಟಾಗ. ಮಧುಸೂದನ್ and ರಾಕೇಶ್. ಅವ್ರ ಏಜ್ ಎಷ್ಟಿತ್ತು? ಟ್ರೈಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಾಗ.
16. The minors mala I think so. ಇಲ್ಲ minors ಅಲ್ಲ at that time they are
PW
more than 18 years.
Person had also given evidence when he was around 12 years, he had seen his mother into second respondent over phone.
12 years minors.
PW
Madhusudan and is Rakesh both of them.
2 and 3. ಇದು ಈಗ ನಾವು additional evidence this is.
PW3 Rakesh is 12 years my lord.
At the time of giving evidence.
Evidence ma'am.
PW ಅವ್ರು ಹೇಳಿದ್ದಿಲ್ಲ 12 ವರ್ಷದಿಂದ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Mother
ನೀವು ಅದನ್ನ ನೋಡಿ. When he was around 12 years, he had seen his mother ಅಂತ ಅವ್ರ ವಯಸ್ಸು ಅವಾಗ ರೆಕಾರ್ಡ್ಸ್
is
ಬಂದಿದೆ.
speaking to the second respondent for phone ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಒಂದು ನಿಮಿಷ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಅಂತ ನೋಡೋಣ. PW 2 and 3.
PW2 was 23 years when he has deposed.
Evidence was given.
When PW3 was 21 years.
Correct, but that is not even their letter. Said to be given by some advocate.
Someone.
Madhusudan, 23 years. graduate BBM. PW3 21 years, graduate BCom. Ibru major idru evidence kodava. But they say when they were aged 12 years or 10 years ಅಷ್ಟು ವರ್ಷ ಹಿಂದಿಂದ ಮಾತಾಡ್ತಾ ಇದ್ದದನ್ನ ನೋಡಿದೆ ಅಂತ ಅಷ್ಟೇ.
ಅಷ್ಟೇ
They have seen them in the bedroom.
ಮನೆ ಒಳಗೆ ಹೋಗಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟು ಬಿಟ್ರೆ ಇನ್ನೇನು ಹೇಳಿಲ್ಲ.
She was doing
She's a housewife. Housewife.
home. So it's as good deciding the main matter.
Main points. Yes.
ಯಾವಾಗ appeal ಯಾವ ಇರೋದು?
21
ಮೇಲೆ
21. Main matter argument ಮಾಡ್ತೀರಾ ಅದ್ರ ಜೊತೆಗೆ ಅದು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು.
ಲಾಸ್ಟ್ 10 years ಮೇಲೆ she is suffering from without
The
income.
trial court they have.
He is a postal assistant ಮೇಲೆ drawing 68,000 rupees ಮೇಲೆ and also landed properties ಮೇಲೆ. ಒಂದು 10 ರೂಪಾಯಿನೂ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ 10 ವರ್ಷದಿಂದ ಅವರು.
Correct, we have to see that now.
Please ಮೇಲೆ I have filed an assertion both of parties sir.
That's a lie. Now, the decree is granted on the ground of adultery.
ಆಮೇಲೆ in she filed an criminal misdemeanors ಮೇಲೆ
Criminal miscellaneous ನಲ್ಲಿ it is
that is
awarded.
pending before the district court ಮೇಲೆ now.
What is the
ಟೈಲರ್ ಕೆಲಸ ಮಾಡ್ತಿಲ್ಲ ಅಂತ
ಅಲ್ಲೂ ವಜಾ ಮಾಡಿದ್ದಾರೆ.
ಟೈಲರ್ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಹೊರತು ಈ ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು ಸೀಸನ್ ಅಡಲ್ಟ್ರಿ ಅಂತ.
as if ಕೊಟ್ಟಿದ್ರೆ this finding was getting contradicted. ಕೊಟ್ಟಿಲ್ಲ, ಅಲ್ಲೂ ಕೂಡ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ ಒನ್ಲಿ ನನ್ನ ಗ್ರೌಂಡ್ ಮತ್ತೆ ಟೈಲ್ ಶಿ ವಾಸ್ ಅಡ್ಮಿಟೆಡ್ ಆಸ್ ಟೈಲರ್ ಅಂತ.
Under I number 1 of 2021, the appellant is seeking an interim or permanent element.
Yes, madam. Litigation expenses and maintenance 30,000.
30,000.
Yes, madam.
And
It was posted for final hearing madam next week
interim or permanent ಏನು ಕೇಳಿಲ್ವಲ್ಲ ನೀವು? 30,000 per month
per month.
in the interest of justice. ಅದೇನು litigation ಮುಗಿಯೋವರೆಗೂನಾ ಅಥವಾ ಏನ್ ನಿಮ್ ಪ್ರೇಯರ್ ನೋಡಿ? And maintenance of alimony and ಅಂತ ಬೇಕು. ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆದು ಹಾಕ್ಬೇಕಲ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ. Have you said alimony and litigation expenses? The trial court has decreed
Month ಅಂತ
petition.
30,000 per month.
ಅದು ಕರೆಕ್ಟ್ ಪೆಂಡಿಂಗ್ ದಿಸ್ ಪಿಟಿಷನ್ ಆರ್ ಲೈಫ್ ಟೈಮ್?
Lifetime.
ನೀವು
Yeah, no.
ಹಾಗಂತ ಎಲ್ಲಿ ಬರ್ದಿದ್ದೀರಿ? On the ground of adultery. Ground of adultery. The said 2 sons of the appellant had given evidence against her. Under the circumstances, this application needs to be considered along with the main matter. At least for final hearing on 2/7.
Number 13, C. Shankar Reddy, Y. Nagraj, K. V. Monish Kumar.
Appearing for respondent number
In
2.
connected matter, similar application came to be filed. It was allowed on 3/6. Appeal ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇರಬೇಕಾದ್ರೆ ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂಡ್ ಫಾರ್ ಕರೆಕ್ಷನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಅವಾರ್ಡ್
Rounds of appeal waiver.
ಅದನ್ನ ಇಲ್ಲಿ
ನಾವು ಹಿಂದೊಂದು ಮಾಡಿದ್ವಲ್ಲ ಇದು.
ಹೌದು ಕನೆಕ್ಟೆಡ್
ಇದಕ್ಕೆ ಕನೆಕ್ಟ್ ಇದೇನಾ 13.1 ಅಲ್ಲಿ ಮಾಡಿರೋದಾ?
ಹೌದು on 3/6/2024.
What is the number 1? ಈ ಕೇಸು ಪೆಂಡಿಂಗ್ ಇತ್ತು, ಅದ್ರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ದಿಸ್ ಕೇಸ್ ಅಂತ ಇದೆ.
ಹೌದು.
2021 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದಾವೆ. Order summary number 1 of 2023. The
Copy not served, ma'am. Appeal, ma'am. Respondent number 2.
Whom do you represent here?
K. V. Monish Kumar.
KP?
Respondent number 2, my lord, BWS.
ನೋಟಿಸ್ ತಗೊಳಕ್ ಆರ್ಡರ್ ಮಾಡಿದ್ವಾ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ?
ಮಾಡ್ತೀವಿ.
ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, 152 ನಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದನ್ನಷ್ಟೇ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ. ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ ಕಾಪಿ ನಮ್ತೀನಿ.
Copies.
This appeal is filed by the claimant challenging the adequacy of the compensation awarded by the reference court. Pending this appeal, the reference court has amended the award on the application, invoking section 151 and 152 CPC. Based on the application of, ಇದರಲ್ಲೂ respond number 2 ನೇ ಇದಾರೆ ಅವರು.
Respondent number 2.
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರ ಈ ಕೇಸಲ್ಲೂ?
ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರು ಹಾಕಿದ್ರ 150 based on the application filed by the second respondent. Therefore, the appellant seeks amendment of the appeal memo to urge additional grounds questioning the correctness of such amendment. Under circumstances, such amendment to the appeal memo is necessary. Hence, the application is allowed. The appellant is permitted to amend the appeal memo to include the additional grounds as paid for. 1 of 23. ಇನ್ನೂ ಮಾಡಿಲ್ವಾ? ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ವಾ?
ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿಯರ್ ಆಗಿದೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್ ಆಗ್ತದೆ.
ಅದರ ಸೈಡ್ ಕಾಪಿ ಟು ಬಿ ಸರ್ವ್ಡ್.
ಹೌದು.
13 ನಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. 13 ನಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ರಲ್ಲ? ಕೆ ಬಿ ಮೋನೇಶ್ ಕುಮಾರ್ ತಗೊಂಡ್ರಲ್ಲ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
That counsel for respond number 2 submits that he has received the copy, therefore office objections would comply. 13 ನಲ್ಲಿ 13.1 ನಲ್ಲಿ ಇದನ್ನ ಹೇಳಿದ್ವಲ್ಲ, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ ನೀವು 13. ಸರಿ, ಇದು 13 ನಲ್ಲಿ ಎರಡು ರಿಸೀವಿಂಗ್ ಕಾಪೀಸ್ 13 ನಲ್ಲಿ IML ಇಂದ ಆರ್ಡರ್ 13.1 ನಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದೆ ಅಲ್ಲಿ ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಮೆಮೊ. ರಿಜಿಸ್ಟರ್ ಕೊಡಿ.
Amended appeal memorandum I'll file. It is ready to file. I'll file it.
10 days time is granted. Yes.
So number 14, KV Narasimhan, T Raghu Prakash for R3.
Government ಮಾಡ್ಬೇಕಂತವ್ರೆ.
The appellants, my lord. My lord, implemented. Yes, my lord.
Last time easy ಏನೇ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ರಲ್ಲ? Shall show the easy. In the court had directed to implead you, it can be allowed application.
Please.
ಹೌದು, ಲಾಸ್ಟ್ ಟೈಮ್ ತೋರಿಸಿಲ್ಲ ಅಂತನಾ? ಈಸಿ ಹೆಸರು ತೋರಿಸಿಲ್ವಾ? ಹೌದಲ್ಲ, ತೋರ್ಸೇ ಇಲ್ಲ ಅವ್ರ ಹೆಸರು.
Yes, my lord, it's not shown in the cause list.
ಹೌದು. I'll show the, but despite this court on 29/5/2024 directing the registry to show the name of ACA for proposed ಯಾರಿಗೆ ಅಂತ ಹೇಳಿಲ್ಲ, ನಮ್ಮದು ತಪ್ಪಿಡ್ತಾರೆ. ಕಾಸ್ ಲಿಸ್ಟ್ ಯಾರಿಗೆ ಅಂತ ಹೇಳಿಲ್ಲ, ಇಲ್ಲಿ ಮೇಲೆ ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರು. ಲರ್ನಡ್ ACA is directed except notice of IA 1 of 2023. ಹೌದು, ಆದ್ರೆ ಅವ್ರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ಈಗ. ACA accepts notice for ಎಷ್ಟದು ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
Number
5. Respondent number 5.
Accept notice for proposed respond number 5. His name shall be shown in the registry for the said respondent in the cause list henceforth. The appellant seeks to implead the state of Karnataka, proposed respond number 5 as respond number 5 in view of the directions of this court. ಹಿಂದೆಲ್ಲ ಇದ್ರಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದಾರಲ್ವಾ ನಿಮ್ಗೆ ಅವ್ರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡೋದಕ್ಕೆ?
Yes, my lord.
When was that? State a party, right? Got it. 13/4/2023. ಅವ್ರು ಯಾರು? ಇದಕ್ಕೊಂದು ಆಫೀಸರ್ ಅನ್ನ ಮಾಡಿರ್ತಾರಲ್ವಾ? ಇದು ಮನಿ ಲಾಂಡ್ರಿಂಗ್ ಕೇಸ್ ಅಲ್ಲ?
Money laundering.
Land grabbing. Okay. Since the state is necessary party, the application is allowed. The appellant is permitted to implead proposed respond number 5 as respond number 5, ಅಥವಾ state of Karnataka as respond number 5 in the appeal. And furnish the copy of the amended appeal. IA number 1 of 2023 is disposed of accordingly. Sir, the copies have got to say anything? Delay ಏನಿಲ್ಲ ಇದರಲ್ಲಿ? ಇದ್ರ ಮೇಲೆ ಹಿಯರಿಂಗ್ ಆಗಿದೆ. ಇದು ಮಿಸಲೇನಿಯಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Copy may be served directed counsel.
Petition dismiss miscellaneous petition time barred ಅಂತ dismiss ಮಾಡಿದ್ದಾರೆ.
Yes.
Restitution petition. ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. But sir, the copies are nil.
I'll serve the copies, ma'am.
Why they had filed 2 petitions? Once they filed 1 petition for restitution as per your notes only, and they filed another application. Him to be transferred, appellant rental appearance, order of dismissal for non-prosecution. Miscellaneous petition was filed by the appellant. Failed to be dismissed. Time barred ಅಂತ ಅಲ್ಲಿ delay condonation application ಹಾಕೊಂಡಿರ್ಲಿಲ್ಲ ಅಂತ dismiss ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಮಾಡ್ತಾರೆ. ಎರಡನೇ ಅಪ್ಲಿಕೇಶನ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ದಿನಾಂಕ 5/11/2018 ನ್ಯಾಯಪೀಠವು ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಸಲುವಾಗಿ ರದ್ದುಪಡಿಸಿ ಪುನಃ ಸಾಕ್ಷಿಯನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಇದು ಕೂಡ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು. ಒಂದು ಮಿಸ್ಲೇನಿಯಸ್ ಅರ್ಲಿಯರ್ ದೇ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ 18 of 2018. ಅದು ಕರೆಕ್ಟ್, ಅವರು ಎರಡು ಹಾಕೊಂಡಿದ್ದಾರೆ. ಮೊದಲು ಒಂದು ವೈ ಡಿಡ್ ಯು ಫೈಲ್ 2 petitions for restitution before the trial court? Third unrepresented ಇದೆಯಾ? You had filed earlier 1 petition for restitution that was dismissed. After 1 year you have filed, now you have come before this court in appeal.
It was dismissed for non-prosecution, ma'am.
No, once it was dismissed for non-prosecution. As per the order of the special court, you had filed petition in miscellaneous number 18 of 2018 for restitution. That was dismissed on 4/12/2018. Again, you filed this second petition. Order says, this was 6 of 2019. You filed another petition for restitution again before the same court. Why you did that? ವಜಾ ಆಗಿದ್ದೆಲ್ಲ ಸೆಟಿಸೈಡ್ ಮಾಡೋದಕ್ಕೆ 18 of 2018 ಅಂತ ಹಾಕ್ತಾರೆ. ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಇಲ್ಲಿ. ಅಂದ್ರೆ ಅದ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಏನೋ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ದಟ್ ವಾಸ್ ಅಗೇನ್ಸ್ಟ್ 18 or ಇನ್ನು ಮಿಸ್ಲೇನಿಯಸ್ 6 of. ಸೊ ಮೊದ್ಲಿನ ಆರ್ಡರ್ ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ ಅವರು, ಇದನ್ನ ಮಾತ್ರ ಕ್ವಶನ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ಸ್ ತಗೊಂಡು ನೋಡಿ ಹೇಳಿ ನೀವು. Impugned order states that earlier they had filed 1 petition for restitution that was dismissed. They have not challenged that order. They again go before the same court and file second application that is dismissed.
Kindly with next week, ma'am.
Copies could have. Yes, ma'am. Requested by Lord SP. Our admission list on
26.
26.
Cell number 15, Gurudev Gachinmat.
I filed this review petition, my lord. Has filed petition seeking for maintenance. A sum of rupees 3,000 my lords was awarded by the trial court. Challenging that, my lords, the husband has preferred a MFA before this honorable court. This honorable court was pleased to confirm it. My lords, B schedule property, my lords, which was a open site, my lords, was a charge was created over the B schedule property. Lords, the review petition is only, lords, to remove that charge, and instead of that open site, lords, to create the charge upon the pension that he is receiving. To that extent, lords, review has been.
Now you have said you have already alienated the property.
Alienated, that's the reason, lords, that I am seeking.
Court's permission, how did you do that?
ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ pension ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ.
We should assist you in doing that for flouting the court's order.
No, not at all. But now if the charge is created over the pension, the lady will not.
The moment he dies, pension goes.
The family pension will commence.
Family pension.
He is still a legally wedded wife. There is no divorce. There is no divorce, my lords, granted. And my lords, he is already 75 years. ಅವರು gift it ಮಾಡುವಂತ ಪ್ರಶ್ನೆ ಯಾಕೆ ಬಂತು ಅಂದ್ರೆ he was all alone. Only sister was looking after him. Not a response. Notice is yet to be issued.
notice ಕೊಡ್ತೀವಿ ನೋಡೋಣ.
I am ready to pay my lords, but charge may be created on the pension amount, not on the
ಎಷ್ಟಿರುತ್ತೆ ಅವ್ರಿಗೆ ಏನ್
40,000 ರೂಪಾಯಿ ಪೆನ್ಷನ್ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ. 40,000 ಪೆನ್ಷನ್ ಬರ್ತಾ ಇದೆ. ಅದರಲ್ಲಿ ನಾನು ಕೊಡ್ಬೇಕಾಗಿರೋದು 3,000.
ಯಾರು ಗವರ್ಮೆಂಟ್ ಪಾರ್ಟಿ ಇದೆಯಲ್ಲ.
Please, please.
State of Karnataka Executive Engineer Panchayat.
All those people, my lords, where he was working as a junior engineer, my lords, in Panchayat Raj department.
Whether AGA can take notice.
Yes, yes, ma'am. They can.
ಅವ್ರಿಗೆ ಬರೋದಿಲ್ಲ ಅದಕ್ಕೆ ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಟ್ರೆಸರಿ ಆಫೀಸರ್ ಅವ್ರಿಗೆ ತಗೋಬಹುದು. ಯಾರಿದ್ದಾರೆ?
Lords, even Panchayat Raj department also, my lords, they can take.
Only for Gram Panchayat, PDO and secretary, separate panel council. RDPR engineers, AGA only take.
ಯಾವ್ದಕ್ಕೆ?
Executive engineer.
ಅಲ್ಲ
R3 and R4, R5 and R6.
R3, R4
And R5 and R6.
ಅಲ್ಲ ಗವರ್ಮೆಂಟ್ ತಗೊಳ್ತಾರ ತಗೊಳ್ಳೋದಿಲ್ಲ?
ತಗೊಳ್ತೀವಿ.
ಅದನ್ನ ನೀವು
You can take.
2 to 7 minutes. 2 to 7. Only notices to be issued to respond number 1.
ನೀವು 2, 6 and 7 ಮಾತ್ರ ಬರುತ್ತೆ. ಏನು ನೋಟಿಫಿಕೇಶನ್ ಇದೆ? ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಪಂಚಾಯತ್ ರಾಜ್
2 to 7 ಮಿಲ್ಲರ್. District treasury officer ಇರ್ತದೆ. 2 to 7.
ಅವ್ರಿಗೆ ತಗೋಬಹುದು ನೀವು 2, 6 and
ಅಲ್ಲ
7
ಇವ್ರಿಗೂ ತಗೋಬಹುದು. RDPR ಗೆ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ. ಇಲ್ಲ. Only ಗ್ರಾಮ ಪಂಚಾಯತ್ only.
ಇದ್ರಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಅಲ್ಲ ನೋಡಿ RDPR ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಗೆ ಅವ್ರು ತಗೋಬಹುದು.
2 to 7.
They are served, my lords. In MFA, they are served.
For R1 Shankar Narayan Bhatt for R1 R2 to 7 served.
Served.
ಅಷ್ಟೇ.
ಅಷ್ಟೇ served.
ಅವ್ರಿಗೆ ಯಾರು ಗವರ್ಮೆಂಟ್ ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಯಾರು
Government is only a formal party.
ಟೇಕ್ ನೋಟಿಸ್ ಫಾರ್ them.
Please, please.
ಯಾರು
AGA ಮಿಲ್ಲರ್.
So and so Leonard AGA accepts notice for response 2 to 7.
2 to 7.
2 to 7. His name shall be shown in the published accordingly. Copy serve ಮಾಡಿದೀರಾ?
I'll serve.
Copy, sir.
He submits that he has already received the copies. Issue notice to respond number 1. List on 3 weeks. 3 weeks.
Grateful.
8-7.
Grateful.
For admission, cell number 16, Naveen GS, MP Geeta Devi.
It's appear for the appellant 2 of ESA Act, wherein my lords, the Labor Court has dismissed my application preferred under section 75, wherein I challenge an order passed under section 45A. My lords, under section 82, only when there is substantial question of law, I can prefer an MFA before this honorable court. My lords, the substantial question of law that has been raised, my lords, the lordship may kindly peruse page number 23, my lords. That's an order passed by the Labor Court. Page 22, para 9, my lords, in the bottom of the page, my lords. The next contention taken by the applicant is that the SSO, Social Security Officer, has not furnished the inspection report before passing order dated 14/7/2016. That's an order under section 45A, my lords. The respondent corporation has admitted that inspection report has not been submitted to the applicant. The Honorable High Court of Karnataka in so and so has held that supply of inspection report to the establishment is mandatory before initiating an action under section 45A of the ESA Act. In view of the principle and the contention raised by the applicant, whether the order dated 14/7/2016 suffers from legal infirmity is to be examined. The applicant not pointed out any provision of ESI Act which mandates the inspection by SSO before passing an order under section 45A of the ESI Act. The lordship may kindly refer to section 44(2), my lords, of the ESI Act.
Your organization is?
Lords, it's an educational institution, lords. Lords, what happened, my lords, I was registered in 2016. They retrospectively imposed all the burden upon me from 2011.
No, it was registered in 2016.
16, my lords. But they retrospectively passed an order from,
Why?
lords, for the reason that, my lords, there was a lapse on the part of the ESI for the reason. In 2011, a notification was issued by the government of Karnataka stating that the education institution comes under the establishment and they should be included. The burden, my lords, under section 44(2) and section 45, read with regular.
You were running the institution even in 2011?
Yes, my lords. Yes, my lords. I was running.
Only thing is you are registered with the.
Yes, my lords, the burden was upon the ESI to intimate the establishment, my lords. Section 44(2), my lords.
What is?
Employees to furnish returns and maintain registers in certain cases. Subsection 2. Where in respect of any factory or establishment, the corporation has reason to believe that the return should have been submitted under subsection 1, but has not been submitted, the corporation may require any person in charge of the factory or establishment to furnish such particulars as it may consider necessary for the purpose of enabling the corporation to decide whether the factory or establishment is a factory or establishment to which this act applies. First thing, they should have issued a notice under section 44(2).
May anta ಇದೆ ಅಲ್ವಾ ಅದು?
Minutes, I may be.
Corporation may require any person or factory.
Yes, my lords. That apart, my lords, kindly, my lords.
Necessary.
Section 45A, my lords. Kindly, it may be referred.
Saying this is mandatory.
Yes, my lords. For the reason, my lords, section 45.
Not mandate.
44(2) says may, not.
Kindly, my lords, section 45A may kindly be perused, my lords.
Just
Kindly,
read,
kindly.
read it once again.
Lords, it has to be read in conjunction with section 45A and regulation 10B, my lords. Kindly, my lords.
Correct, but this is not with regard to SSO's inspection.
It is not
Then
with,
44(2) is not-
kindly,
Your
section,
submission is that SSO's inspection report was not furnished to you.
kindly, 45A may kindly be seen, my lords. 44(2), 45 and 45A. Read with regulation 10B, it should be
48.
read conjointly, my lords.
Okay, read it.
Where in respect of a factory or establishment, no returns, particulars, registers or records are submitted, furnished or maintained in accordance with provisions of section 44, or any social security officer or other official of a corporation referred to in subsection 2 of 45, prevented in any manner by the principal or the immediate employer or any other person in exercising his function or discharging his duties under section 45, the corporation may, on the basis of information available to it, by order determine the amount of contributions payable in respect of the employees of the factory or the establishment. If 44(2) is not complied with, then, my lords, the SSO has to visit the premises under section 45(2). My lords, I am referring to a judgment of Honorable Apex Court, wherein or is read as conjunction rather than as interjunction, my lords.
That is referred in that judgment also it says.
Lords, kindly. Wherein, my lords, herein the or is used, wherein, my lords, the Honorable Apex Court interprets as and. ಇದರಲ್ಲಿ ಆರ್ ಅಂತ ರೆಫರ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಅದನ್ನ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಇಂಟರ್ಪ್ರಿಟೆಡ್ ಆಸ್ ಕಂಜಂಕ್ಷನ್ ರಾದರ್ ದನ್ ಇಂಟರ್ಜಂಕ್ಷನ್. Kindly, my lords, para 15 of the judgment, my lords. In page 595, my lords. 595. 595.
Yes.
Let's para 15 minutes. Section 45A provides for determination of contributions in certain cases. When the records are not produced by the establishment before the corporation, and when there is no cooperation, the corporation has got the power to make assessment and determine the amount under section 45A and recover the said amount as arrears of land revenue under section 45B of the Act. So first, if I have not submitted any documents before the ESI corporation, the second step is to the SSO to inspect the premises and take the account books and the ledgers into his custody and to do an inspection. That is the inspection report that he has to submit to the establishment, my lords. The Apex Court interprets as a conjunction and states that once there is no submission of documents by the establishment or the entity, then it is a duty of the SSO to visit the premises. It is read as and, my lords. It is not read as or. Because section 45A to section 45G, my lords.
The corporation has got the power to make assessment and determine the amount.
Please, my lord.
Kindly, my lords. It may be read from the beginning. Section 45A provides for determination of contributions in certain cases, not in all cases. when the records are not produced by the establishment before the corporation. That is one instance, that is section 44(2). And when there is no cooperation, the corporation has got the power to make assessment and determine the amount under section 45A. That cooperation refers to section 45(2), pertains to SSO. When SSO tries to visit the premises, and if the employer or the immediate employer does not,
2007 judgment, have you not cited it for the trial court?
no, my lords, that is the reason, my lords, that is the contention that was missed out in the trial court.
Where para page number 23 of my lord, where they are held in 1-4 cases are short note 362.
Page 23 of paper.
Page 23, internal page
Field
9.
papers or judgment?
In judgment, my lord.
No, my lords, in appeal memo, I think. Appeal memo, my lords, appeal memo.
In the appeal memo, page number 23, my lord, internal pages 9 of the impugned order, my lord. Where,
The appellant has not pointed out any provision ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು.
please, even they relied on this
Let's-
judgment. This
There is
judgment
no
has been
provision
overruled.
in the law making it mandatory ಅಂತ. Here were not, they were not able to show any provision ಅಂತ.
And my lords, kindly regulation 10B of the regulations may kindly be seen, my lords.
Then B, no?
10B, my lords. Under ESI General Regulations 1950, collection of contributions, etc. Registration of factories or establishments.
Page number
10B states that the employer in respect of a factory or an establishment to which the act applies for the first time and to which an employer's code number is not yet allotted, and the employer in respect of a factory or an establishment to which the act previously applied but has ceased to apply for the time being, shall furnish to the appropriate regional officer not later than 15 days after the act becomes applicable, as the case may be, to the factory of the establishment, a declaration of registration in writing in Form 1. B, my lords, the employer shall be responsible for correctness of all particulars and information required for and furnished on the employer's registration form. C, it gives a responsibility upon the officer, my lords. The appropriate regional office may direct the employer who fails to comply with the requirements of paragraph A of this regulation within the time stated therein to furnish to that office employer registration form duly completed within such further time as may be specified, and such employer shall thereupon comply with the instruction issued by the office in this behalf. So,
correct, all these section, all these provisions, it is
10B,
said,
please.
they may do it.
my lords, it's a social security,
Mandate.
my lords, it's a
For
social
10B,
security
what you are-
legislation, my lords. It's a social security legislation. The notification or the act which will be passed by the government will be well within the knowledge of the officer rather than the institutions or the establishments, my lords.
They are the educational institution.
Yes, my lords,
They
I
are
mean,
educating the people,
kindly, my lords, lords.
not any factory or.
Yes, my lords, yes, my lords. This is the third contention, my lords. But, my lords, there is a duty casted upon the officer under regulation 10BC stating that if they don't do as
Was their explanation why it was not given, why it was not
My lords,
respected?
from 2011, they don't do anything.
Any explanation is given why they have not done?
My
No,
lords,
my lords, there was no explanation.
The educational trust themselves, they have sought for coverage, my lord. Even that has been recorded in
They
this finding.
themselves sought
Please,
coverage.
yes.
Which year?
That was registered in 2016, my lords.
My lord,
69.
page 22, my lord.
No, in which year they filed application for seeking?
16, my lord, 16.
Next time.
Para 8, my lord.
Hmm.
From the fourth line, the applicant himself has admitted that he has uploaded all the details in the official website to register educational institute for the purpose of contribution under the ESI Act.
The applicant himself has admitted that he has uploaded all the details in the official
Please,
website
Please,
to
my lord.
register the educational institution. Adi yavaga, when that was?
That was in 2016, my lords.
16 or 2011?
16, my lords.
Verify that.
Such institution has been expertly covered through notification dated 16/3/2011.
Lords, we are
My lord,
only agreed for the reason, my lord.
Regulation 10B doesn't arise here, my lord, because the
Regulation 10
10B
says that if they fail to do, you may
in this
call upon them to
when
do
there is
that.
number is not yet allotted. my
No,
lord.
no, no, my lord.
In this, already the number has been allotted.
When was allotted?
16, my lords. It was
I'll
16.
verify that in
No,
which
no.
year.
retrospectively you have
Yes.
assessed them. You had given any notice in 2011.
No, my lord, no.
When-
I'll verify it when it was registered under the ESI Act.
You're not sure?
I'll need to verify, my lord, because in this, the number, date has been not,
Lords, if at all I have registered in 2011, every year I have to file the returns, my lords. I have to give them all the documents.
Pending ಇದೆ. When have you taken notice? No, now whether that is mandatory or
Lords,
discretionary.
those are the substantial question of law, my lords. This honorable court has to decide, my
no,
lords.
my lord, because.
Kindly,
they
my
based
lords,
a different
at page number 8, sorry, my lords. Page number 10, my lords. I have,
ಇಲ್ಲ, ಇದು mandatory ನಾ ಅಂತ ಈಗ they
Yes,
have
my lords.
question- See, your substantial question number 1 is whether non-compliance of service of notice.
And-
Whether ಅದು ಈಗ compliance of service of notice is mandatory.
yes, my lords.
That is the question, not it has vitiated, etc. You are presupposing.
No, the personal objective was.
No, my
given,
lords, for the reason, my lords, if at all the,
ಎರಡೇ question ಮಾಡಿದೀರಾ, whether inspection, okay, that is, whether inspection of the premises.
under section 45 mandatory, whether the proceedings under 45 be initiated only under,
Is a precondition ಅಂತ, precondition for
to initiate the proceedings under 45A. my lords.
45A.
Yes, my lords. It's a coercive method to recover the amount, my lords. That's why it was initiated. That's why, my lords, honorable apex court says it in certain cases.
This may be the one substantial question at the most. Whether the
Two
inspection of the premises of the factory or establishment.
and 3, my lords, it may be considered a substantial question of
Even
law.
we have said how it is, how it
Because,
was.
my lord,
contribution
section
was assessed, my lord.
82 may be seen, my lords. Section 82(2), my lords. Appeal law, save expressly as provided in this section, no appeal shall lie from an order of an employee's insurance court. An appeal shall lie to the High Court from an order of an employee's insurance court if it involves a substantial question of law. These two are the, my lords,
It's a substantial question. Now your contention is that it was mandatory for them to send their SSO.
Yes,
and
my
get
lords.
the inspection done and
Yes.
serve the notice on you.
Yes, my lords.
That is, whether that is mandatory or
That is the substantial question of law.
you have made 4 substantial questions.
My lords, it is, my lords, for this honorable court, my lords, consider the substantial questions of law.
No, in respect of what
Is
they
it
have said.
mandatory or discretionary?
No, it is,
settled-
it is discretionary, it is not
No,
mandatory.
is
Even
there settled by any law, any precedents?
we go through it
That's-
and tell.
Lords,
In
if,
respect of.
if we refer to, my lords, the judgment, my lords,
ಅಲ್ಲ ಅದು ಬೇರೆ, ಅದು ಮಾಡಿದ್ದಾರೆ 45 ನಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರಿಗಲ್ಲ. ಅವ್ರದ್ದೇನಂದ್ರೆ 45A proceedings initiate ಮಾಡೋದಕ್ಕಿಂತ ಮೊದಲೇನೆ
Yes,
it
we
should
have-
be
we have issued
read as
notice to
and,
them.
my
That
lords,
has been recorded, my
instead
lord.
of or, it should be read as and for the reason
Page number-
45A,
condition precedent to initiate proceedings under section 45A.
yes, my lords.
Right, that is
It should be used
the
sparingly,
inspection
my
of
lords.
the SSO and furnishing his report to you is the condition precedent for initiating.
Yes, my lords, yes, my lords,
A proceedings.
yes, my lords.
That
The
is the
Shokas
question
notice
that
has been
is-
issued, my lord. The Shokas notice what my learned friend is,
That was in 2016.
no, 16, my lord, when after.
But we have assessed it with effect from
2011.
When the notification was issued by the
Quantum.
government,
Shokas notice is issued. How do you decide the quantum?
by uploading, they'll upload the details of their employees, my lord. Based on that, we assess the contribution.
They have uploaded in 2016.
That I need to verify, my lord, but
Yeah, how
After
did you
that-
assess in 2011?
please.
These many employees were there all along from 2011 to 16. How did you arrive at that conclusion?
My lord, even in this education, what they have done, they have taken the, from the immediate employer, the, few of the faculty were
That
in this.
Substantial question ಮಾಡಿ records call for model. By that time, you can also verify.
Please, my lord.
Whether
Lords, 2 and
Prior to
3.
that, my lord, one number submission, para 13 of the impugned order, my lord. Page number, internal page 10, page number, appeal in appeal, page number 24.
page number ಎಷ್ಟು?
Page number 24 in appeal memo,
20.
para 13, my lord, impugned order. Sit down. The RW1 has stated that the opportunity of hearing has been extended to applicant and the.
Yeah, opportunity of hearing is that is.
For
under section
45A, my lords.
He is not, it's not his case that opportunity was not given. His contention is that your assessment is incorrect. This calculation is incorrect because you had not furnished, your SSO did not visit the
Please,
establishment. He did not assess. ಈಗ 2011 ನಲ್ಲಿ 10 ಜನ ಎಂಪ್ಲಾಯೀಸ್ ಇರ್ಬೋದು, 2016 ನಲ್ಲಿ ಅದೇ 100 ಆಗಿರ್ಬೋದು. That is your contention.
Kindly.
How did you assess from 2011 to 2016? That had no basis. According to him, you should have inspected and taken note of all these things and served on him as a condition precedent for initiate.
Kindly.
That is, that
45
was,
proceedings.
Kindly,
Please,
kindly.
my lord, but that is what even my submission is, my lord. We didn't inspect the institution, even that has been recorded in para 11 of the impugned judgment. What we are saying is based on the details he is provided, which he was provided.
Yeah, 2016 when they uploaded,
Please.
whether they uploaded with effect from 2011.
That I need to verify,
No,
whether
my
it is from 2011 or 2016, that I have to need to verify.
What
If,
is your?
if at all minutes we have registered in 2011, they would not have waited till 2016 to issue a
No,
notice.
he is saying 2016 when you uploaded.
Yes, Manoj.
Whether you uploaded the information of your employees from 2011 onwards or only in 2016.
Notes, 2016 I registered, my lords. Registration is
Based on
different.
his details, we have
he
assessed the
says-
contribution.
Evidence, according to the evidence you had uploaded in 2016.
My lords,
Your employees' details.
No, my lords. Registration is something different, my lords. Furnishing of documents is something two different things, my lords. Once I registered, my lords, a number will be.
But according to, did you take up any defense in before this ESI court that these were the number of employees from 2011 to 2016 who
No.
were covered under the act?
No,
My lords, my contention before the ESI court was, my lords, threefold, my lords. One was, my lords, I am not coming under the establishment. That is not, my lords, that is not amenable, my lords. Second condition was, my lords, contention was, my lords, that the SSO had to inspect the establishment and he has to furnish.
It was mandatory.
That was a mandatory, my lords. Third one, my lords, I had taken up a contention stating that with respect to, my lords, I had given contract to some persons, my lords. With regard to that, my lords, they had assessed me also. That they couldn't have assessed me on that basis, my lords.
You were not the immediate
Employer and that is,
Call employer, immediate employer.
yes, my lords, that is what my contention. My other contention was, my lords, that I was only registered.
Simple question. is,
Kindly, my lords.
You registered in 2016.
16, my lords.
But as per law, you were covered from
2011 itself.
Did you furnish the number of your employees covered under the act from 2011 to 2016?
My lords, complete documents, my lords, I think has not been furnished.
Records call. ಗೊತ್ತಾಗುತ್ತಲ್ವಾ ಅದು? ಬಂದಿದೆ, records ಬಂದಿದೆ ಅಂತಲ್ಲ, ಇದನ್ನ ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀರಾ?
Or a short date, maybe, I'll verify in the ESI corporation, what are the documents? we have
Correct,
provided.
ಅವ್ರಿಗೆ ಅದು ಗೊತ್ತಿಲ್ಲ. He furnished in 2016. 2016, whether he furnished the list of the employees from 2011 to 16 or only of the year 2016.
That I need to verify.
Examine.
Please.
ಅಲ್ಲೇನೋ ಬಂದಿರುತ್ತೆ. ಅಲ್ಲ ಅದು ಬಂದಿರುತ್ತೆ ಅವ್ರ ರೆಕಾರ್ಡ್ಸ್ 45A ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಬಂದಿರುತ್ತಲ್ಲ ಅಲ್ಲಿ.
My lords, I think only trial court proceedings has been.
ಇವ್ರದ್ದು this application 2016 application or
No, that I need to verify,
Registration,
because
my
in
lords.
this there is no any date
2016
mentioned
was
here.
my registration.
vouchers 150 May ಅಂತ ಇದೆ.
But that is, my lords, that has to be
Can
interpreted. my lords.
elaborate that on seeing the document.
Please.
For initiation of the proceedings under section 45A of the ESI Act, ESI Act 1948, whether inspection of the establishment, inspection of the appellant establishment by the SSO and furnishing of his report to the appellant establishment is mandatory and precondition.
Yes.
That is the only
My lords,
section.
furnishing of report is mandatory, my lords.
For you, no,
Kindly, kindly.
inspection and
And,
furnishing.
yes,
both.
yes, kindly. And my lords, that regulation 10B, my lords, since it's a social security legislation, my lords, the
Adine,
Ah.
inspection is under article, under. section
45, my
44.
lords.
Inspection of the establishment under, by the SSO, social security officer, under section 44(2) of the act.
Well, it's 45, my lords, 45 to 44 to is for me to submit documents.
44 to 45 to
45 2 minutes.
So 45A speaks about the details uploaded by.
1 second. Rules ನೋಡ್ತಾ ಇದ್ದೀನಿ. 45 to na
2 minutes, 2 minutes.
ಅದು 2 is about recovery ಅದು.
No minutes, 45B is
Then
recovery minutes. 45 2 is any social security officer.
5B,
45 2 minutes. Section 45 subsection 2,
not 44.
not 45B minutes. Any SSO appointed by corporation under subsection 1 or other official of corporation.
45 to
Yes,
45.
minutes.
45A.
ನಿಮ್ಮ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ 44 to ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀರಿ.
Minutes, that is with
And 10
That could not be a substantive question of law because
ESI General Regulations Act 1950. No, he is saying ಅಲ್ಲಿ section ನಲ್ಲಿ may ಅಂತ ಇದೆ.
please.
He is saying that it is
So
mandatory.
because
Though it
44
is-
ಇರೋದು ಅವರು
Now,
furnish ಮಾಡ್ಬೇಕು
ಅಲ್ಲಿ
ಅಂತಿರೋದು.
empowered ಅಂತ ಇದೆ.
for the reason, minutes, it's a social security legislation.
ಅದೇನ್ ನೀವು
Both of us cannot sleep over it, minutes. Both of us has the same responsibility.
ಈಸ್ ಏನು ಸೆಂಟೆನ್ಸ್ ಪೂರ್ತಿ ಓದಿ ಅಲ್ಲ ಸೆಂಟೆನ್ಸ್ ಮೊದಲನೇದ ನಾವು ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದು ಪೂರ್ತಿ ಮೊದಲನೇದ No, the appeal is admitted to consider the following substantial question of law. For initiation of proceedings under section 45A, whether inspection of establishment. As per section 45 to 2B and regulation number 10B.
Means regulation 10B is to direct us to register, minutes.
Even
ನೀವೇನ್ ಹೇಳಿದ್ರಲ್ಲ
10B is
10B is,
ಡೈರೆಕ್ಟ್ 10B ಅಲ್ಲಿ ಸಿ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವೀಗ.
how's minutes? That is for direction 2 for me to
Appropriate
register.
regional officer may direct the employer who fails to comply with the requirements of paragraph A
Yes,
of
ma'am.
this regulation within the time stated therein to furnish to the office employee's registration form duly completed within such further time as may be specified.
That is registration, minutes.
Now we are concerned only about 45.
Minutes 45 2 with respect to inspection and furnishing of report. Section regulation 10BC is, minutes. When the employer fails to upload the document, 10BC says the officer may direct them to furnish the document to verify and check whether the establishment comes
but
under the definition of that 1(5). So in May, minutes,
Establishment. only.
yes, minutes, under the establishment. If
They have not disputed that now.
no,
It's
I have
already
not
uploaded the
disputed,
document.
minutes, but it will cast a responsibility upon the ESI corporation that if there is any entity, minutes, which comes under the establishment, even though they are not coming, they have not furnished the document, if they direct them, minutes, if it is interpreted as shell, minutes, there will be employees who will be benefited. Minutes, if, minutes, for the moment,
In your case, your only contention is that section 44, Mr. 2B.
45 2. I have raised this content for the reason, minutes, in 2016, I have
Public interest.
minutes, no. In 2016, I registered, minutes. They assessed me from 2011. If they had directed me in 2011, it,
Whole question, you were covered from 2011 only.
yes, minutes.
The whole question now is, how did they assess it?
Yes, yes,
Your
minutes.
contention is that their assessment is incorrect because they have not inspected your
Yes,
premises.
yes, minutes.
And they have not given you a list
Inspection
saying that,
report.
see, in 2011, these many employees were, 2012,
Yes, yes,
these
ma'am.
many. So that is incorrect. anta.
Yes,
So
minutes. That is,
you are not given that opportunity. anta. Whether
Yes.
that is mandatory or not.
yes, minutes. 10B I referred for the reason, minutes. If at all they have directed me in the year 2011 itself, this
There is no estoppel against law. No, only this.
no,
one.
minutes. If they have directed this dispute has not arisen, minutes. If the duty is casted upon the corporation also, minutes, then, minutes, there will be employees who would be benefited.
Advocate ಆಗಿ ಬರ್ಬೇಕು ಅಂದ್ರೆ ನೀವು ಸನದ್ ತಗೊಂಡ್ ಬರ್ಬೇಕು ಅಂತ ಎಲ್ಲರಿಗೂ ಹೇಳಕ್ ಆಗತ್ತಾ?
ಅಲ್ಲ.
You should do that. No, only that.
Kindly, minutes, kindly.
ನೀವು ನಂಗೆ 10 ವರ್ಷದಿಂದನೇ ಹೇಳಿದ್ರೆ ನಾನು ಅವಾಗಲೇ ಸನದ್ ತಗೊಂಡ್ ಬರ್ತಿದ್ದೆ
No,
ಅಂದ್ರೆ.
minutes. Since it was a social security legislation, that was only, minutes.
Ignorance of law is not an excuse.
No, my lords, if the duty has cast it upon them, they
This
can
one
also.
For final hearing list now? Date, 2023.
Lords, only trial court records from labor court has come, I think, my lords.
ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ
I'll verify it.
not.
Kind.
You can furnish if
If it's
Great, sir, my lords.
45 records are required.
P. Ravindra.
It's not 100%.
Number 12.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ರಾ? ವೈ? ಕರೆಕ್ಟ್, ಬಟ್ ಅಪಿಯರ್ ಆಗಿ ಇಲ್ಲಿ ಮಾತ್ರ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್. ಯುವರ್ ಗ್ರೀವೆನ್ಸ್ ಇಸ್ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ awarding the permanent element.
Permanent. Well, he is a government employee, police constable. And both the matters, divorce petition as well as the same is ended in compromise. He is agreed for the 3,000 each to the wife and children's every month. In spite of that, the trial court voluntarily directed him to pay a sum of rupees 10 lakhs as a permanent alimony.
Where is that compromise petition?
Compromise
No,
petition
whether that
annexed.
compromise petition, they have said that they have given up all their rights of maintenance.
Yes, madam. Yes, madam.
Records ಬರ್ಬೇಕು.
That is copy number, annexure B and C.
Records call for madam.
Call for. Stay may be granted.
Stay, records ಬಂದ್ಮೇಲೆ ನೋಡೋಣ ಹಂಗಂದ್ರೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ ಇದಾರೆ.
At least you have the record, show us this exhibit P16 and P17. P16 at least. You have the certificate copy of exhibit P16?
No.
But see, they should say there that accepting that amount, accepting that they have given up their rights. If that is done, then we could have said, otherwise we pass conditional order.
Because
Not stay order.
it was not her prayer in the petition.
ಕೈಯಲ್ಲಿ ಒಂದು ಯಾರು ಪಾರ್ಟಿ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. Served unrepresented ಇದೆ ಲಕ್ಷ್ಮಿ ಅಂತ. ಒಂದು, either you give us that copy of exhibit P16, then we'll grant you stay. Otherwise, on receiving the records, we'll grant stay.
Yes.
Consider that. Grant
Time may be given. 2 weeks time may be given. I will submit.
TCRs. IA 1 of 2021 shall be considered after receiving the TCRs.
The number 18, Nishant SK, SPP.
For the statement.
302 offense has been convicted. Accused number 3. That is coming for the first time.
You're notice ತಗೊಂಡಿಲ್ವಾ? You are
Ah.
ready? You are ready for ಏನು suspension ready ಇದೀರಾ hearing ಗೆ?
Yes, madam.
Ready ಇದಾರಾ?
Please, my lords. Trial court records may be necessary for this reason, my lords. Fire is registered against, my lords, unknown persons. Thereafter, my lords, the event had taken, my lords, the incident had taken place, my lords, around 10:30 in the night. My lord, the witnesses say, my lord, does not say about the source of light, my lords.
Yes.
In the test identification parade, my lord, PW1 and PW3, they have identified all the accused, my lord, A1, A2 and A3, my lord.
That is what I am disputing, my lords. I have marked exhibit D1 to D3.
Records ಬರ್ಲಿ ಬಂದಲ್ಲ ನೋಡೋಣ.
Please, my lord. My lords, already in a connected appeal, my lords, your lordships have directed for call for records, my lords.
ಯಾವ್ದು connected appeal ಹೇಳಿ ಹಾಗಾದ್ರೆ ಜೊತೆ.
881 of 2024. my lords.
ಎಷ್ಟು?
Criminal appeal 881 of 2024.
Submitted that this matter is connected to criminal appeal number 880 at
Where, my lords, accused number 4 has preferred the appeal. 24, my lords.
2024. And the said matter is already admitted. ಅಲ್ಲಿ suspension ಆಗಿದೆಯಾ?
ಅದೆಲ್ಲ ಆಗಿದೆ A4 ಗೆ.
ಹಾಗಾದ್ರೆ ಮೊದಲು ಅದ್ರ ಜೊತೆಗೆ ಲಿಸ್ಟ್ ಮಾಡ್ಲಿ ನೋಡ.
Please.
If both of them are standing on the same footing,
My lord, slightly different.
Different footing.
My lord, allegation is A4 is, my lord, he was, his role was only on conspiracy. Whereas, my lord, the allegation against this person is that, my lord, he was present at the spot.
He was present along with A1 and A2, my lord, when the assault took place on the
overacting. What is his overtime? This man's
He was present along with A1 and A2.
present ಇದ್ರೆ ಆಗೋದಿಲ್ಲ.
Apart from that,
Whether infliction of
please,
injuries.
no, my lord.
So,
With injury, he was granted bail and.
Please, he was on bail, my lord, during the trial.
According to something we saw in the.
Thereafter, my lord, he was again enlarged on bail.
He again,
Earlier, my lords,
he was again released on bail.
please, please.
His bail was granted. I mean, recalled.
It was granted, my lord, this court, my lord, cancels it on the ground that, my lord, it was not, the victim was not heard.
So that was.
So it was remanded and liberty was given to rehear the matter.
It was again.
Then the Sessions Court grants bail, my lord.
Very circumstantial evidence is the trial court and bail grant for
Records, my lord, they are also disputing. And also, my lords, the,
That's why we asked, what is the overt act of this accused? He
there is no
is,
specific overt action against this. Three, my lords, A3.
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಏನು ಕಾಣ್ತಾನೆ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋಡ್ಬೇಕು ಈಗ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡ್ಬೇಕು ಅನೀಶ್.
Overt acts, my lords, are against A1 and A2, my lords.
A1 and 4 hashed criminal conspiracy, it is number 2 and 3. A1 to 4 is 2. ಇಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಕೋರ್ಟ್ ಆಕ್ಟ್ ಏನು ಇದ್ರಲ್ಲಿ ಕಾಣ್ತಿಲ್ಲ ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ರೆಕಾರ್ಡ್ಸ್
No, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇದೆ.
Yes.
What was your defense?
My lords, I have not been identified. There was no source of light.
Total dispute.
I totally dispute. I deny, my lords. My lords, the incident has taken place, my lords, around 10:45 PM in the night. My lords, absolutely there was no source of light. Even in the complaint also, the complainant does not say, my lords, there was any source of light, my lords, for seeing, my lords, anybody. And thereafter, my lords, importantly, on 11/8/2015, my lords, the pictures of the accused persons were published in the newspaper. And thereafter, my lords, identification period was conducted. That is how, my lords, the witnesses, my lords, identified.
Injured witness is there. CW.
PW1, my lords, is the injured office.
He has identified this accused.
Yes, identify, my lords, all the 3 accused persons. But whereas, my lords, initially it was published in the newspaper, our photographs and identity were disclosed. Thereafter, identification period was conducted. And PW2, my lords, who was also participated in the identification period, he says, my lords, the Tahsildar has shown these are the accused persons, so I have identified. My lords, the very foundation for the identification period itself is disputed.
See, allegations of physically assaulting when this CW1 was against accused number 1.
Please.
ಇಲ್ಲಿ general allegations ಇದೆ so far as that deceased accused number 1 to 4 in persons of criminal conspiracy assaulted Nasir on his eye forehead by using talwar and caused grievous injuries and committed his death ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಈ ಅಕ್ಯೂಸ್ಡ್ ಏನ್ ಮಾಡಿದ್ರು ಅಂತ ಇಲ್ಲ
ಇಲ್ಲ
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಾದ್ರೂ ಇದೆಯಾ?
Even there is no.
Actually, the point for consideration.
There is no charge sheet. I have only one copy, my lords, my apologies.
ನೋಡೋದಕ್ಕೆ ಕೊಡಿ ನೋಡೋದು ಏನಾದ್ರು at least ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಈಚ್ ಅಕ್ಯೂಸ್ಡ್ ಗೆ ಸ್ಪೆಸಿಫಿಕ್ ವೋಟ್ ಟ್ಯಾಕ್ಸ್ ಅಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿದಾರಾ?
Column 17.
A3 ಅಲ್ಲ?
A3.
ಆರೋಪಿ ಎರಡನೇ ಆರೋಪಿ ತಲವಾರಿನಿಂದ ನಾಸೀರ್ ಮೊಹಮ್ಮದ್ So even as per the charge sheet, it was accused number
1 and 2. 1 and 2.
number 2 who assaulted the victim with not this accused. He is
PW2
accused
is eyewitness. PW2 is eyewitness to the incident.
CW1 is examined as
PW2 is eyewitness to the incident. And he was traveling in a bike. When he was traveling in the bike, a bike light with light and ನಾವು ನೋಡಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Those all developed.
Then his statement was recorded.
In the initial stages, he doesn't say, even in the 164 statement recorded also, he doesn't say that there was any source of light. Subsequently, during the examination, my lord, before the trial court, after charges are framed, he says there was street light, gadi light, subsequent to that, he says.
Correct. Whether these accused were known to them earlier.
My lord,
No.
But known ಅಂತಾನೆ ಹೇಳ್ತಾರೆ sir. Initially he says, my lords, he knows.
Initially he
My lords,
says he knows.
whereas FIR is registered for unknown persons.
But he himself was a complainant.
He himself was the complainant. The
PW1
injured
is the
witness,
injured-
DW1 himself was the complainant.
PW
Not name these accused.
No, my lords, he did not name.
ಹಾಗಾದ್ರೆ ಅದ್ರ ಜೊತೆಗೆ ಪುಟ್ ಅಪ್ ಮಾಡ್ಲಿ ನೋಡೋಣ.
Please.
ಅದ್ರಲ್ಲಿ ಏನ್ what view we are taking. Seems to be, but even according to the charge sheet, the allegations of actual assault are not against this accused number 3.
All are against A1 and A2, my lords.
Informs plus newspaper.
ಅಲ್ಲ ಅವ್ನು ಹೇಳೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಲೈವ್ ವಿಟ್ನೆಸ್ ಇದ್ದವನು though he claims that they were known to him, he doesn't name them in the FIR.
He does not name in the FIR.
But in the CI parade, he identifies.
And
Subsequently,
ಎಷ್ಟು ದಿವಸ ಆದ್ಮೇಲೆ ಮಾಡಿದ್ದು? It was being said that
The defective ಇದೆ.
these names were already
published in the newspaper, my lords. On 11/8/2015, my lords, it was published. And on 18/9, my lords,
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದ್ರು ಮತ್ತೆ ಕೊಟ್ಟಿದಾರಲ್ಲ.
please, my lords.
ಕೊಟ್ಟ ಬಿಡೋಣ ಅಂತೀರಾ? ಕೊಡೋಣ. ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಬರ್ಲಿ ಅದು ಮೂರು ಏನ್
Order ಇದೆಯೇನ್ರಿ?
ಸಬ್ಮಿಟೆಡ್ ಅದರ ಕಾಪಿ ಇದೆಯಾ ಮೊದಲಿಂದ
Please, ma'am.
888 ಒಳಗೆ ಸಸ್ಪೆಂಡ್
Please, please.
ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು this matter is collected to so and so and the same is already admitted, therefore this matter is also admitted for hearing. ಮತ್ತೆ ಇದು ಬೇರೆಯವ್ರ ಮುಂದೆ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾಗುತ್ತಲ್ಲ. There is a circular. ಇದು ನಮ್ಮ ಬೆಂಚ್ ಅಲ್ಲ.
Vacation bench. It was before vacation bench, my lords, bail was granted.
RDH ಅಂತಾರೆ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯಾರೋ ಒಬ್ರು ಇದ್ದಿದ್ದಾರಲ್ಲ ಆದ್ರೂ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡ್ತಾರಲ್ಲ. ಅಲ್ಲ ಏನ್ ಹೇಳುತ್ತೆ ಆ ಸರ್ಕ್ಯುಲರ್ ನಾವು ಮಾಡ್ಬೋದಾ ಮಾಡ್ಲಿಕ್ಕಿಲ್ಲ? ಮಾಡ್ಬೋದು. ನಾವೇ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ಮಾಡ್ಬೋದು. ಎಷ್ಟು
Records may be called for.
ಇದು ರೀಸೆಂಟ್ ಲೇಟೆಸ್ಟ್. The subsequent bail application under section 439, including applications for interim bail, shall be listed before them that who at the earliest decided any earlier bail application arising out of the same FIR. ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ ಇವ್ರಿಗೆ.
It's not a subsequent bail petition.
Hmm?
It's a fresh.
ಇಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸೇಮ್ FIR ಮೇಲೆ ಅಂತ.
Please.
ಅಲ್ಲಿ ಹೋದ್ರೆ ನಿಮಗೆ will get it ಅಷ್ಟೇ. Arising out of same FIR. Subsequent ಅಲ್ಲ. ಇಲ್ಲಿ ಒಂದಿದೆ.
Success.
Avoid any confusion in future, it would be appropriate manner to mention the application file, grant officer. Therefore, illegal, therefore, as directed, all the officers and options working in the registry, and all courts functioning shall strictly comply with the above directions with regard to listing of the bail applications and to ensure that the mandatory details as of ಇಲ್ಲ ಇನ್ನೊಂದಿದೆ ಅಲ್ಲ ಅದೇ ಆ ಕೇಸಲ್ಲಿ ಬಂದಿದೆ.
Same FIR should be listed before the same judge.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು ಅಂತ.
Some of the cases where the judge has been
ರಿಟೈರ್ಡ್ ಆರ್ ನಾಟ್ ಅವೈಲಬಲ್ ಅಂತ. It is submitted that earlier bail application of the co-accused slash appellant was disposed of by this court by the bench consisting
They were
of
arrested together. But Talwar was looking from A2.
in view of the circular in dated 7/2/2000, circular number circular RJ number 24 of 2024 dated 7/2/2024. The revision is requested to then it will, yes, ಅಲ್ಲಿ place ಮಾಡಿ.
Let the matter be connected along with the other.
ಮೆನ್ಷನ್ ಮಾಡಿದೀವಿ, ಆದ್ರೆ ಅದ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹೋದಾಗ ಒಟ್ಟಿಗೆ ಮಾಡ್ತಾರೆ.
Yes.
ಕನೆಕ್ಟೆಡ್ ಟು ಅಂತ ಹೇಳಿ. ಇದು ಹೋಗಿ ಬರ್ಲಿ, ಆಮೇಲೆ ಬರ್ತಾರೆ, ಸಾಕಷ್ಟು. ಆಯ್ತು ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್
Other hearing,
Great.
number 19, Ramesh P. Kulkarni, P.S. Malipatil Prapan, Praveen Naglu, Parkour and Arpit.
Anything?
The last occasion, two questions remain. One, there was no cause of action, and another is the claim is barred by limitation. So far as cause of action is concerned, paragraph number 9 of the petition, it says the date of lending loan. Page number 4.
One ನಿಮಿಷ. Page number 4 of the petition.
Page number 4 of the petition in the trial court record.
Page number 4, no?
Page number 4,
Cause of action.
cause of action.
Arose.
Date of, without mentioning the date, lending is shown a cause of action, and issuance of notice is shown a cause of action.
Final notice on 13.
So far as the appellant is concerned, it is true that no notice was issued to him. But then I have two submissions to make. This is a proceeding for recovery of money. Law does not mandate issue of notice. I cite two examples. One is that of 138 Negotiable Instruments Act, where notice is mandated. Unless notice is shown, no further proceedings could go on. Another is, it is just an example, suit for partition. There also notice is mandated, but then plaint itself is construed to be a notice. Similar is this case. It is a fact that loan was lent on the surety of this appellant. It is a fact that there was default in repayment. Therefore, the fact that no notice was issued before initiation of proceeding, it fades into insignificance. Cause of action, as we understand, it is not defined. It is a bundle of facts which give rise to.
Judgment was cited, no?
ಇಲ್ಲ ಇದ್ರ ಬಗ್ಗೆ ಯಾವ
ಇಲ್ಲ,
citation?
notice.
ಇಲ್ಲ ನಾವು
ಇದ್ರಲ್ಲಿನಾ?
I cited the Supreme Court judgment and my learned friend cited the Supreme Court.
Yes, sir. ಅಲ್ಲ, ಎರಡು ಮಾಡ್ಬೇಕು. ಅಲ್ಲ, ಏನು?
My learned friend cited, so
Starts running only when actually a demand for payment is made and it was refused by the guarantors. ಇದ್ಯಾವ್ದಿದು?
that was.
Syndicate Bank versus Chanvirappa,
Yes, ma'am.
Beleri. However, such a demand should not be time barred against the principal debtor.
But I am placing two judgments of the this honorable court and the honorable Supreme Court regarding the limitation, whether it is barred by limitation under the SFC Act.
The question is, his submission, it seems to be, even if no notice is
Yes,
issued,
yes.
cause of action arises.
Yes.
Yes.
That was one submission.
Yes.
And according to you, it seems your submission, if the cause of action arises the moment the principal borrower commits default, right?
Very well.
Yes.
That is correct.
But each judgment only, some other views taken. it
This
seems.
judgment cannot be relied upon for the purpose of our case because facts are different.
The facts cannot be identical in any case.
I mean, there is no identical facts also. So please see, this is,
One second.
no, please see para 5.3 onwards.
Cause of action already. Principal
Yes.
Yes, you are relying on, you are also one of the
No, I am one of the
No, who-
I am for
guarantors. He is
the corporation.
corporation.
corporation. You
As the guarantor, not he is the surety, not who executed the guarantee.
This appeal is
ನಾವಿಬ್ರು
filed-
guarantors.
Appellant, ಇವರೆಲ್ಲ ಇಬ್ರು guarantors.
two appeals, I mean.
Only one guarantor
One
has,
is a guarantor, he is also a guarantor. Now the appeal
Yes.
is preferred only by one guarantor, that is B.S. Jyoti anta ಹೇಳಿ.
Jyoti.
ನೀವು ಯಾರನ್ನ represent ಮಾಡೋದು?
I am for the appellant. He is the guarantor.
That is Jyoti.
Whom do you represent?
I am another guarantor. I have also
But
support.
you have not preferred any appeal.
I have not preferred any appeal,
Correct.
but I am assisting this honorable court on the point of law.
You have not questioned this judgment.
Yes.
Okay.
I have not questioned. I am assisting this honorable court on the question of law.
No, no, he's not supporting. He's opposing that.
No, he's putting judgment.
No,
I'm-
he's not.
I am opposing his appeal.
Not supporting.
I am opposing
He's
his
a
appeal.
co-guar-
Judgment of the.
No, no, he's not supporting. He's opposing that. He is a co-guarantor.
He is my enemy.
May I make my stand?
Suppose ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರು. He's supporting him. ಅವ್ರನ್ನ time ಬಾರ್ಡ್ ಅಂತ ಹೇಳ್ತಾರೆ.
I am not supporting, I am opposing. I am opposing the appellant. I want this appeal to be dismissed.
Okay, you want to say that,
I want this appeal.
you want to take the benefit that it should be proceeded against him.
ಅದು ಆಮೇಲೆ ಅದು ಪ್ರಶ್ನೆ.
Last time, correct, now we recollect. But he was.
ಈಗ
telling about
I have one
limitation.
submission to make. Limitation, barred by,
No, opposing means you are pressing upon the point that petition was time barred.
time bar ಒಂದಕ್ಕೆ ನಾನು ಸಪೋರ್ಟ್ ಮಾಡ್ತೀನಿ. ಟೈಮ್ ಬಾರ್ ಅಂತ ಹೇಳೋದಾದ್ರೆ ತಾವು ಪಿಟಿಷನ್
Whatever contention he is raising, that you are supporting.
ಪಿಟಿಷನ್
Then how are you opposing him?
only on that point I am supporting the appeal.
Correct,
ಟೈಮ್ ಬಾರ್ಡ್ ಅಂತ ಆದ್ರೆ I will also not have liability.
ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಅವ್ರಿಗೆ ರಿಕವರ್ ಆಗ್ಲಿ, ನಾವು ಸೇವ್ ಆಗ್ತೀವಿ ಅಂತ ಅಷ್ಟೇ. No execution is initiated. Last time we asked this question also, it seems, whether you proceeded against them. Because now
No,
order
no,
has
no
attained
exec-
finality against them. Have you proceeded against them in execution?
Not yet.
Not. No,
ಅವ್ರಿಗೆ ನಿಮ್ ಮೇಲೆ ಮಾಡ್ಬಿಟ್ರೆ ಅವ್ರು ಸೇವ್ ಆಗ್ತಾರೆ. You have more money, I mean, more properties.
because of this appeal, no execution is filed by the
This
corporation.
appeal is only against,
That's correct, it is not. They are only sureties, no property has given as a guarantee. Because of that,
you want to
we
proceed
have
only
to
against the
trace,
missing cow.
we have to trace the properties of the sureties and then execution is to be filed there.
Their surety is only personal surety, na, ಅಂದ್ರೆ secured surety, guarantee ಅಲ್ವಾ ಅವ್ರದ್ದು?
Guarantee there.
His clients
He is a
guarantee.
surety, guarantee.
The surety guarantee.
Guarantee one, yes.
Guarantee whether by, I mean, mortgaging any property or
They do not have any property, not the
don't
appellant.
have any property.
Only that appellant has the properties.
Yes. Then he can submit. Now we have accepted this,
But yes,
this judgment.
not my friend has urged, not 2 points, one is, it is my petition, not under miscellaneous petition is barred by limitation. And the another is not that notice was issued to the appellant.
Cause of action.
No cause of action,
He
that is
admits
before,
that no cause of action arose against him.
yes.
31 AA notice, issuing notice is mandatory.
And the how, that is what his argument.
We were little confused when he intervened.
Section, my submission is that not,
Consider between these two lists. Correct, he raised 2 points. One is there was no cause of action. The other one is loan was barred against the principal debtor. Correct, Mr. Karnataka?
not principal bar.
As against me, my lord, within the
As
limits.
against them.
This petition was not maintainable because no notice was issued to you.
Yes.
And second thing, you said that you had issued them a notice of
After the
retirement.
time, time to initiate the proceeding against borrower has more, it has gone more than 3 years.
That's what, that is one thing. You had three things. One is that you had withdrawn your guarantee. And thereafter also loan was
Yes, ma'am.
given to them, so you are not liable.
Yes.
First foremost is that you were not issued any notice, so 31 EAA was not complied. Second one, principal, against the principal debtor itself,
Time.
the loan was, claim was time barred.
Yes.
Third one is that, ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ದು ನೀವೀಗ?
ಇನ್ನೊಂದು
No cause of action.
ಇನ್ನೊಂದು continuing guarantee cannot be, he has cancelled the continuing guarantee. That's what.
Third one is that they had withdrawn.
So far as that is concerned, the Supreme Court judgment is clear. It cannot be, he cannot wriggle out of the liability.
Yes. Unless they agree ಅಂತ ಇದೆ. ಆಮೇಲೆ ಟರ್ಮ್ಸ್ ಆಫ್ ಗ್ಯಾರಂಟಿ ನೋಡ್ಬೇಕು ಅಂತಾನು ಇದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
Yes.
What do you say? These points you have to answer.
Your lordship last time wanted to know whether loans were granted after termination of the guarantee.
Yes, that also.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಇದು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು. ಯಾವತ್ತು ಯಾರು ಎಷ್ಟೆಷ್ಟು ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ?
I did not prepare the.
Yes.
Page number 13 of PW1.
PW1.
Page number 13 of deposition of PW1.
Page number 15. PW1 15 ಅಂತ ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ, 13 ವರೆಗೆ ಮುಗಿದಿದೆ. ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು ಹೇಳಿ?
Print the page number 13 of PW1.
13, yes.
ಈಗ ನನಗೆ ತೋರಿಸಲಾದ ದಾಖಲೆ 1995ರಲ್ಲಿ ಎದುರುದಾರರ ಕಂಪನಿಗೆ 17,85,000 ಮಂಜೂರು ಮಾಡಿರೋ ಬಗ್ಗೆ ಕಳಿಸಿರೋ ಪತ್ರದ ಜಿರಾಕ್ಸ್ ನಕಲು ಎಂದರೆ ಸರಿ. ಅದರ ಅಸಲು ಪತ್ರ ನಮ್ಮಲ್ಲಿದೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಸಾಲಕ್ಕೆ 5ನೇ ಎದುರುದಾರ ಜಾಮೀನುದಾರರಲ್ಲ ಎಂದರೆ ಸರಿ. 1994ರ ನಂತರ ಕೊಟ್ಟಿರುವ ಸಾಲಗಳಿಗೆ 5ನೇ ಎದುರುದಾರರು ಜಾಮೀನುದಾರರಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿ. 1994ರವರೆಗೆ ಕೊಟ್ಟಿರುವ ಸಾಲ ಎಲ್ಲ ತಿರುವಳಿಯಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 4/7/96ರಂದು 5ನೇ ಎದುರುದಾರರಿಂದ ನಮಗೆ ನೋಟಿಸ್ ಬಂದಿದೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Therefore, for this loan, they clearly admit, and your lordship will find in the main petition para number 4, 4 month. In the claim petition, para number 4, last 4 lines below, on 16/5/2000, RSR facility for reviving of sick unit by rescheduling the existing loans and funding interest arrears was extended to the company.
RSR ಅಂದ್ರೆ ಏನದು?
ಅದು it is a new loan only. Your lordship will find.
Revival ಅಂತ ಕೂಡ. What is the last
Fasal-
form of RSR?
And in effect, they give the new loan, wipe off the old one and reschedule payment. Your lordship will find it in exhibit P4. P4 is the guarantee.
Reviving the sick unit by rescheduling the existing term loans. ಅಲ್ಲ reschedule ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ reschedule old loan ಗೆ ಮಾಡಕ್ ಬರೋಲ್ಲ ಅವ್ರಿಗೆ. They give the new loan, clear the old one.
No, they treat it as a new loan. ಅದನ್ನ ಅದಕ್ಕೆ adjust ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಅಲ್ಲ ಅದನ್ನ that meaning your lordship will get it in exhibit P4.
P4.
Guarantee, no?
Guarantee.
P4 ಅಲ್ಲಿ it is page number 2, but 3 ಅಂತ ಪ್ರಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. It is a guarantee deed to which I am not a party.
P4 ಅಲ್ಲಿ?
P4 is a guarantee deed dated 13/9/2000.
Yeah, you said last time also you are not party to this, yes.
ಇದರಲ್ಲಿ ನಾನ್ ಪಾರ್ಟಿ ಇಲ್ಲ. I am not a guarantor.
2000?
13/9/2000. 13th September 2000. Your lordship may kindly see the next
The
page.
revival.
But
This was a rescheduled loan.
other reschedule, what is rescheduling? This indicates. Now, your lordship may kindly see the last paragraph. Now this indenture witnesses in consideration of the
Last paragraph of?
Huh?
Top page ಅಲ್ಲಿ last paragraph.
Page number 3, my lord.
Page number 3.
Page number 3.
And now this indenture is.
Now this indenture witnesses in consideration of the corporation having lent, agreed to lend a sum funded interest arrears of rupees 55 lakhs point 10 lakhs and loan outstanding so and so. Therefore, there is a agreement to lend further. This is the loan that was granted under RSR.
The corporation lent, already lent, agreed to lend some funded interest arrears of this 55.10. This was already, and loan outstanding 45.45 lakhs. Soft loan 2 lakhs and DG set loan, etc. Then
Therefore, the corporation says, we are giving you 55.10 in consideration of the pending loans.
correct.
Therefore, it is a new loan only, giving a new loan to wipe off old one and reschedule this new loan.
I think they only redo it, that's all. Now they treat it as a new loan.
Yes.
There was so much of arrears.
Yes.
Now, you get interest to and principal ಸೇರಿ ಒಂದು 10 ಲಕ್ಷ ಇದ್ರೆ they treat it as a new loan and fix new terms for that.
New schedule for paying the newly advanced loan.
Correct.
Therefore, it is a new loan only. New loan to wipe off the old loan.
Their old loan is not wiped off. That is given a new color, that's all. ಇದನ್ನ ಲೋನ್ ಅಂತ ಕರೀತಾರೆ ಅವ್ರು ಮತ್ತೆ. ನಿಮ್ದೀಗ ಒಂದು 10 ಲಕ್ಷ, it was already outstanding.
Yes, madam.
As on 1/1/2024, they call it as a new loan and reschedule the payments.
They bring the.
And they take new guarantee for that.
For that, there will be totally new set of documents.
Already.
And I am not a party to.
According to you,
I am not a party.
loan was cleared under this document.
And for this document, I am not a party around. New guarantor has come there.
You are saying that old loan was cleared.
Yes.
Yes, that's all. Yes, Leonard Council, they have to address these things. That notice under section 31AA invoking.
31(1)AA.
Therefore, no cause of action at all. And your petition is premature. And second one is claim against the principal borrower itself as time barred. Third one is invoking guarantee in 1994.
Yes,
That was accepted according to it. So they are not liable to the future.
that is the argument.
Liabilities which arise thereafter.
Yes. Yes, my submission is this, my lord. This is the proceedings initiated under section 31(1)AA. This is not a suit.
Correct.
Not therefore, not under section 31(1)AA. Statute does not contemplate issuing of notice before filing the petition. Therefore, my submission is that if
Yes.
the notice was, the demand notice was not issued, will not hold good in this case. Only not we proceed against the guarantor
So according to you, under section
After
31,
exhausting the remedy provided under section 29. In this case, section 29 was invoked. The property and the machineries were sold. After not adjusting the amount, the sale proceeds to the loan account. For the balance amount, the miscellaneous petition was filed. And the
last time provision over here.
section 31 one way. Yes.
Makes
Can you-
any default in repayment of
Tell
any
us. Shall I read more
or
from
in
the
meeting
beginning?
its obligation in relation to, yes,
Where an industrial concern in breach of any agreement makes any
default.
default in repayment of a loan or advance or any installment thereof, or in the meeting its obligation in realization of any guarantee given by the corporation or otherwise fails to comply with the terms of the agreement with the financial corporation, or where the financial corporation required an industry concerned to make the immediate repayment of any loan or advance under section 30, or industrial concern fails to make such repayment, then without prejudice to the provision section 29 of this act and section 69 of the Transfer of Property Act, an officer of the industrial corporation, financial corporation, generally or specially authorized by the board in its behalf, may apply to the district judge within the limits whose jurisdiction the industry concerns carries on the whole or substantially part
Word
of its
requires
business.
only with regard to the industrial concern.
Yes. It has
Corporation
some
requires
parts of its business for one or more of the following reliefs, namely, for an order for the sale of the property pledged, mortgaged, hypothecated, or assigned to financial corporation as a security for the loan or the advance. Second, AA, two, for enforcement of liability of any surety. I stop here. Here,
ಗ್ಯಾರಂಟಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ, unless they issue a notice of demand in require ಅನ್ನೋ ವರ್ಡ್ ಇದೆಯಲ್ಲ, or otherwise fails to comply with the terms of agreement with financial corporation, or where the financial corporation requires an industrial concern to make immediate repayment of any loan or advance at a security. ಅದಕ್ಕೆ ಅಂತ ಅದಕ್ಕೆ ಗ್ಯಾರಂಟಿಗೂ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. That amounts to, that relates to industrial concern. Not.
yes, my lord. My submission is this, my lord.
So his submission was that section 31 that has a word requires anta idella, that applies to surety also anta ಹೇಳಿ.
Yes.
Section 30 notice is required. This require ಅನ್ನೋ word use ಮಾಡಿರೋದು section 29 ಗೆ. That notice is under section 30 ಬರುತ್ತೆ. 30 is section 30 notice. Section 30 notice relates
30 is or to
that,
recall the repayment. of-
industry, and not to the guarantors.
Not to the guarantor,
Section 30 notice is
to the borrower,
industry and not.
not to the guarantor.
Yes.
Therefore, my lord, submission is this, the contention of the learned counsel that no notice was issued before, my lord, initiation of the proceedings may not hold good, because it is not mandatorily, my lord, contemplated under the act. I can not, after exhausting my remedy under section 29, I can straight away file a petition before the learned district judge for enforcement of the liability by the from the surety. That has been done. But after not filing a petition, they took up the contention that not she has resigned the to the post of this directorship in 1994. Therefore, not her liability to pay the balance amount is cannot be enforced against the appellant. Not is the contention taken by the before the trial court, district judge. That has been not accepted by the court below in para number.
Correct, why?
Because it is a continuing guarantee.
What is the terms of guarantee says?
Yes, you will also para page para number.
Document ತೋರಿಸಿ judgment note argument ಮಾಡಬೇಡಿ. Shows from the record guarantee agreement.
Yes, sir.
In exhibit P1, please see recital
This
number.
lady executed by this lady.
Exhibit
Your Jyoti ಅನ್ನೋ
guarantee deed executed by Jyoti. Yes, my lord.
exhibit ಎಷ್ಟದು?
Exhibit P1.
P1.
P1 ನಲ್ಲಿ recital number 2 at page number 4.
Jyoti son of so and so, ladies ಅನ್ಕೊಂಡು. ಇದ್ರಲ್ಲಿ
May I read it?
Number 3 ಯಾವ್ದು ಸರ್? ನನ್ನ ಕಡೆ ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ.
ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ.
Number 3 ne?
Industrial concern.
And on their thought and if they does not honor that, then they can enforce
No,
any
no,
of this.
notwithstanding then without prejudice to the provisions of section 29. ಅದನ್ನ ಮಾಡದೇನೆ ಇವ್ರನ್ನೇನ್ ಮಾಡ್ಬೋದು? 29. ಅದು ಸಣ್ಣ ಅಂತ ಅವ್ರ ಗ್ಯಾರಂಟಿ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ಎಲ್ಲ ವರ್ಕ್ ಮಾಡಿ ಹೇಳಿ ಕೈ ಕಟ್ಟಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಯಾವ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಗ್ಯಾರಂಟಿ ಅಗ್ರಿಮೆಂಟ್?
Clause 1.
Guarantee shall be enforceable against guarantors for the due repayment of the loan to the corporation by the company under
2, 3, 13, 14.
guarantee to postpone for any. ಇಲ್ಲಿದೆ ಪ್ಯಾರಾ 3 ಅಲ್ಲಿದೆ page 4 ಪ್ಯಾರಾ 3 ನಲ್ಲಿ the corporation shall have fullest liberty without affecting this guarantee to postpone for any time
From time to time.
from time to time the exercise of the power of sale or any other power of powers conferred under the security documents and exercise the same at any time in any manner to enforce or forbear enforcement of
Clause
Governance.
Clause 1 will,
Principles.
clause 1 will
Okay,
indicate.
last 4 lines may please be seen.
ಯಾವ್ದ್ರಲ್ಲಿ which paragraph?
Other remedies or securities available to corporation, the guarantor shall not be released by any exercise by the corporation. Shall not be released.
Okay.
So therefore, there can't be any release.
Shall
from,
not be
this
released by any-
obligation.
That is correct. ಅಂದ್ರೆ a rescheduling that we cannot accept that. But the other contention is that even after he issuing retirement notice or withdrawal notice, some loan was granted. For that he is not liable because this guarantee stood rescinded by that date.
He
No,
can
no,
be
no. Even for that also not this.
Clause ಇದೆಯಾ? There cannot be unilateral withdrawal of the guarantee ಅಂತ ಹೇಳಿ.
This is the
ಅದನ್ನು ಇದೆ.
clause. This is the
Even
clause.
for the future, not even for.
This is about the continuing guarantee. The whatever loan they grant, are they even thereafter after this agreement also they can go on granting
please.
guarantee.
Please see recital number 6. The guarantor shall also hereby agree and declare that the company will be free to raise further money from the corporation or from any other financial institution in addition to the said principal sum and or to secure any other facility, such facility for guarantee of deferred payment, foreign currency.
Correct, this is
loans.
all correct. This is all correct, provided he did not issue a notice of guarantee. He is liable up to the date of his, revocation of the guarantee. If suppose a person says
The
that.
the Supreme Court judgment I have relied upon says there cannot be any notice to wriggle out of the liability.
liability which he had incurred when he was the guarantor.
Even for future
Even
loans
for
as
future.
well, even for future loans as well.
Future loan ಆ ಕೇಸಲ್ಲಿ ಅವರು withdraw ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಈ ತರ ಯಾವ್ದದು which is that judgment? Which is that judgment? In this case, what happens after his withdrawal,
2000.
also further loan was granted. Apart from this rescheduling, another loan was granted.
ಹೌದು.
ನಾವು ನಿಮ್ಗೆ ಕೇಳಿದ್ವಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದು ಯಾವ ಡೇಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ
That I read out that deposition, but
17 lakhs.
EW on deposition 17.8.
ಇದು ಈಗ ಇನ್ನೊಂದು ಓದಿದ್ರಲ್ಲ ನೀವು rescheduling that loan ಅದು ಯಾವುದು?
ಅದು exhibit P4 ಅಲ್ಲಿ ಅದು rescheduling entire loan of
Entire. You are
58.
liable to pay that rescheduled loan. But our only doubt is it fair a person to pay some amount even after he withdrawing his surety, if it is granted after his withdrawal? And he was not a party to that subsequent guarantee agreement.
ಅಲ್ಲ,
this
contention-
guarantee I am not a
ಆ ತರ
part.
ಏನ್
contention ತಗೊಳ್ಳೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. That is what 2008 Supreme Court says.
2008.
8.
No, in this case, whether he had revoked that guarantee, revocation of guarantee
There can't be-
before loan was advanced to the debtor. Gave that benefit by entering into agreement of guarantee with the bank. ಇಲ್ಲಿ ಅದೇ ಈ agreement clause ಅಲ್ಲಿ ಆ ರೀತಿ ಇದ್ರೆ irrevocable ಅಂತಿದ್ರೆ that is correct. ಇಲ್ಲಿ facts ಓದಿ ಇದ್ರದ್ದು ಗೊತ್ತಾಗುತ್ತೆ. Who was a guarantor in respect of loans advanced by Punjab National Bank. Pursuant to in this appeal, the income judgment. Contract act ಕೊಡಿ. Only before such loan was actually paid to define number 1 to 4.
Paragraph number 3 of the judgment.
One second, just let's see this one.
The only question that was raised on behalf of the appellant was that in view of statutory provision under section 130 of the Indian Contract Act, where High Court was justified in holding that the appellant who was guarantor of the loan advanced to defendant number 1 to 4 was liable to pay the decretal amount on the ground that the appellant had revoked the guarantee before such loan was actually paid. Same are the facts of this case.
He executes the guarantee agreement. Subsequently, loan was dispersed. Here he says that in the meantime, he withdraws it. So it appears it was contended that before the disbursement of the loan, I had withdrawn it. Therefore, I am not liable. It seems to be like that. ಇಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ ಹಾಗಲ್ಲ. He is liable to pay whatever was granted earlier, but after he withdrawing, new loan was granted. ಅದನ್ನ whether it is
Withdrawal ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. That is what section para 6 and 7 says.
ಅಲ್ಲ ಅದನ್ನ ಪ್ಯಾರಾ 3 ಓದಿ ಯಾವಾಗ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮ್ಗೆ?
The only question that was raised on behalf of the appellant was that in view of statutory provision under section 130 of the Indian Contract Act, whether the High Court was justified in holding that the appellant who was a guarantor of the loan advanced to defendant number 1 to 4 was liable to pay decretal amount on the ground that the appellant had revoked guarantee before such loan was actually paid.
Actually paid. ಅಂದ್ರೆ he becomes loan sanction ಆಗುತ್ತೆ. Sanction ಆದಾಗ he becomes the guarantor. Before the loan was actually dispersed, he tries to withdraw his guarantee. ಆ ಸಂದರ್ಭದಲ್ಲಿ they cannot ask that.
ಈ ಕೇಸ್ನಲ್ಲೂ ಹಾಗೇನೆ.
No, in this case, I mean, he is submitting the witness has admitted ಅಂತ ತೋರಿಸಿದ್ರು ಅವರು. Earlier loan.
May I make one submission? Witness cannot make any admission contrary to the contents of document.
Your own witness. He was granted earlier some crores or some lakhs rupees of loan. That had become overdue. Again, that was rescheduled. He is liable to pay that, even if But
ಅದು
he
reschedule
after
ಇಲ್ಲ
he
ಅಂತ
revoking that fresh loan was given ಅಂತ ಹೇಳ್ತಾರೆ, for which he was not a guarantor.
ಇಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Fresh loan ಅಲ್ಲ.
ಲೋನ್ ಅಲ್ಲ, ರೀಶೆಡ್ಯೂಲ್
Reschedule ಇಲ್ವೇ ಇಲ್ಲ.
ಹ್ಮ್.
There is no reschedule.
ರೀಶೆಡ್ಯೂಲ್ ಇಲ್ಲ ಇಲ್ಲ.
Meaning ಗ್ಯಾರಂಟಿಯಲ್ಲಿ ಟರ್ಮ್ ಏನಿದೆ ಅಂತ ನೋಡಿ. ಬಟ್ ನಾನು ಹೇಳ್ತೀನಿ ಸಪೋಸ್ ನಿಮಗೆ ನಾನು ಗ್ಯಾರಂಟಿ ಆಗಿರ್ತೀನಿ 1 ಕೋಟಿ ರೂಪಾಯಿ, ಆ 1 ಕೋಟಿ ರೂಪಾಯಿ ಅವನು ನೀವು ಆಕ್ಚುಲಿ ಡಿಸ್ಪರ್ಸ್ ಆಗೋಕ್ಕಿಂತ ಮೊದಲು ಅವನು ಗ್ಯಾರಂಟಿ ವಿತ್ಡ್ರಾ ಮಾಡಿದ್ರೆ ಈಸ್ ಲಯಬಲ್ ಟು ಪೇ. ಈಗ ನಿಮ್ಗೆ 1 ಕೋಟಿ ಕೊಟ್ಟ ಮೇಲೆ ಅದು ಡಿಸ್ಪರ್ಸ್ ಆಗುತ್ತೆ ನೋಡಾಗುತ್ತೆ. ಆಫ್ಟರ್ ಸಮ್ ಟೈಮ್ ವಿತ್ಡ್ರಾ ದ ಗ್ಯಾರಂಟಿ, ಅದಾದ್ಮೇಲೆ ಅವ್ರು 30 lakhs ಕೊಡ್ತಾರೆ, ಅದು ಟರ್ಮ್ಸ್. A continuing guarantee may at any time be revoked by the as to future transactions. Future transactions can by notice to the ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಆ ಕೇಸಲ್ಲಿ ಹಾಗಿರೋದಿಲ್ಲ, ಅವ್ರು ಅವ್ರ ಲಯಬಿಲಿಟಿ ಆಲ್ರೆಡಿ ಅರೈಸ್ ಆಗಿರುತ್ತೆ, ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅವರು ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಗ್ಯಾರಂಟಿ ಅಂತ.
In any case, recital number 17.
Transaction by notice of the creditor. A in consideration of case discounting. A guarantees B to the extent of 1,000 rupees that she shall pay all the bills that he shall draw upon him. B draws upon C. C accepts the bill. A gives notice of revocation to dissolve. C dishonors the debts of agent. It is liable to pay his guarantee.
In any case, recital number 17 of
ಈ
exhibit
ಕೇಸಲ್ಲಿ
P1, it is very clear.
ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರುತ್ತೆ, ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿ ಅವ್ರು ಡಿಸ್ಪರ್ಸ್ ಮಾಡಕ್ಕೆ ಬದಲು ಅವ್ನು ವಿತ್ಡ್ರಾ ಮಾಡ್ತಾನೆ, ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವ ತರ ಅಲ್ಲ ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಕೀಪಿಂಗ್ there cannot be any dispute that appellant had clearly agreed that guarantee that he had entered into with the bank was a continuing guarantee, and the same was to continue and remain in operation for all subsequent transactions. Andre
therefore it's not open for the appellant to turn around and say that in view of section 130 there, since the guarantee was removed before the loan was not liable to pay.
then before the loan was advanced andre actual disbursement, future advances alla, future sanctions alla, ಏನು ತೋರಿಸಿಲ್ಲ ಅದನ್ನ. ಎಸ್ ಈಗ ಅನ್ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ, ಈಗ ಇದ್ರು ಎಲ್ಲರೂ ಬರೋರು ಇಲ್ಲ ಇನ್ವೋಕ್ಡ್ ಅಂತಿಲ್ಲ, ಸೆಕ್ಷನ್ 130 ಪ್ರೊವೈಡ್ ಮಾಡುತ್ತಲ್ಲ ಇನ್ವೋಕ್ ಮಾಡೋದಕ್ಕೆ. ಫಾರ್ ಫ್ಯೂಚರ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ದೇ ಕ್ಯಾನ್ ಇನ್ವೋಕ್ ಅಂತ ವಿತ್ ನೋಟಿಸ್, ಅದ ನೋಟಿಸ್ ಕೊಟ್ಟು ಇನ್ವೋಕ್.
Here, my lord, what corporation has not, my lord, sanctioned, my lord, the second loan or third loan, no schedule. Nothing, only one loan was, my lord,
That's
only
what we
one.
asked him to show whether ಅಲ್ಲಿ
ಇಲ್ಲ.
ವಿಟ್ನೆಸ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಇಲ್ಲ, ನಾವ್ ಎಲ್ಲಿ ಒಂದೇ ಲೋನೇ ಕೊಟ್ಟಿರೋದು,
2005 ನಲ್ಲಿ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ವಿಟ್ನೆಸ್
ಒಂದೇ ಲೋನ್ ಕೊಟ್ಟಿರೋದು.
ಡಿಪೋಷನ್ ಅಲ್ಲಿ ವಿಟ್ನೆಸ್ ಡಿಪೋಷನ್ ಅಲ್ಲಿ ಏನೋ ತೋರಿಸಿದ್ರು
ಈ
ನೋಡಿ.
ಶೆಡ್ಯೂಲ್ ಇಲ್ಲ. After the default, my lord,
Witness cannot admit against him, contrary to law.
ಪ್ಯಾರಾ 4 ಎಲ್ಲ ಬರ್ಕೊಂಡಿದೀವಿ. Exhibit P4 is the only loan. P4 ಏನೋ ಅಂತ ತೋರಿಸಿದ್ರು ರೀಶೆಡ್ಯೂಲ್ ಆಗಿದ್ದು.
ಇಲ್ಲ.
Which is that document you showed reschedule ಆಗಿದೆ ಅಂತ ತೋರಿಸಿದ್ರಲ್ಲ.
Exhibit P4.
P4.
I am not a guarantor to it.
ಅಲ್ಲ
ಅಲ್ಲ, ಅವ್ರು
P4
ನೀವು
ನೀರಾ ಗ್ಯಾರಂಟಿ. ನೀವು ಇನ್ನೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸಿದ್ರಿ ಯಾವ್ದೋ ಅದು Exhibit P4 ಓಲ್ಡ್ ಲೋನ್ ಕ್ಲಿಯರ್ಡ್ ಅಂತ. P4 ಅಲ್ಲಿ ಓಲ್ಡ್ ಲೋನ್ ಕ್ಲಿಯರ್ಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. P4 ಅಲ್ಲಿ ಹೇಳಿದಾರ. ಅಲ್ಲ ದಿಸ್ ವಿ ಕೆನಾಟ್ ಎಕ್ಸೆಪ್ಟ್. ಇದು ಯಾವ ಇಯರ್ ದಲ್ಲಿ ಇದು 39/2000. ಆ ವಿಟ್ನೆಸ್ ಹೇಳೋದು ಅದಕ್ಕೆನಾ?
10-3 ಒಂದು
ಡಿಪೋಷನ್ ಕೈಗೆ ಸಿಗೋದಿಲ್ಲ ನಮ್ಗೆ ಬೇಗ, ಬಿಕಾಸ್ ಇಟ್ಸ್ ವೆರಿ ಬಲ್ಕಿ ರೆಕಾರ್ಡ್ಸ್. PW1 ನೀವು ಹಾಕಿರೋ ಸ್ಲಿಪ್ ನಲ್ಲಿ ಅಲ್ಲ ಯಾವ್ದೋ ಲೈನ್ PW1 ಪೇಜ್ ನಂಬರ್ 13 19 7/4/96 94ರವರೆಗೆ ಕೊಟ್ಟಿರುವ ಎಲ್ಲಾ ಸಾಲ ತೀರುವಳಿಯಾಗಿದೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. 94ರ ನಂತರ ಕೊಟ್ಟಿರುವ ಸಾಲಗಳಿಗೆ 5ನೇ ಎದೆದಾರರು ಜಾಮೀನ್ದಾರರಾಗಿಲ್ಲ ಅಂದ್ರೆ ಸರ್ ಹೌದು he is not guarantee, he has not executed subsequently, but that was earlier agreement was a continuing guarantee. He has not stated, you said he has stated that loan was sanctioned subsequently. Other 2000 though, that is only rescheduling, not a new loan.
Not a new law.
Yes. That's,
Yes. Not-
we'll continue in the afternoon. Madhya continue.
May I request the court to have it tomorrow?
ಬೇಡ ಬೇಡ ಇವಾಗ ಮಧ್ಯಾಹ್ನ ಮತ್ತೆ ನಮಗೆ ಮರ್ತು ಹೋಗುತ್ತೆ. These are the only points now. One point he 31A notice ಬಗ್ಗೆ he has clarified. Now this continuing guarantee, this loan was a not a new loan ಅಂತ ಅದನ್ನು satisfy ಮಾಡಿದ್ರು. ಮತ್ತಿನ್ನೇನು ಅವ್ರು ರೇಸ್ ಮಾಡಿದ್ದು claim against principal borrower was time barred ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು.
That is not.
ಅದನ್ನ ಇವಾಗ ಅದನ್ನೊಂದು ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ. The invoking guarantee was when the loan was in subsisting. Yes.
One subject.
Yes.
Serial number 33, my lord. Appeal memo ಬಿಟ್ರೆ CR ನನ್ನ ಹತ್ರ ಇಲ್ಲ. ಅವ್ರು appellant ಹತ್ರನೂ ಇಲ್ವಂತೆ.
33.
33, madam. I have only the appeal memo. They were directed to furnish a copy.
33.
Appeal memo.
ಯಾರು ಅವ್ರ ಹತ್ರನೂ ಇಲ್ವಂತ ನಾವು we are seeing a trend, all the senior advocates who are here only judgment, trial court judgment ಹಿಡ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು. I do not know, ಅದು ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸು ಇಂಥವೆಲ್ಲ RFಗಳು ಇದ್ರಲ್ಲೆಲ್ಲ ಇರೋದು.
Without which I can't argue.
ಈಗ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ, ನೋಟ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ವಿಲ್ ಮೇಕ್ ಯಾರು SN ಭಟ್ರು ಇದಾರ ಇದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ವೇರ್ ಇಸ್ ಅವ್ರಿಗೆ ತಗೊಂಡ್ how does he argue without the records?
But Rajit may have it next week. I will ask.
As it was, amicus query submits that the copies are not furnished to her. Appellant's counsel shall furnish the records to her within, ಇಲ್ಲಾಂದ್ರೆ appeal dismiss ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇನೆ. Within 1 week ಆಯ್ತು ಒಂದು ಚಾನ್ಸ್. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಇದ್ರಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರಂತೆ ಅವ್ರು, ನೋಡೋಣ. ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರಂತೆ ಅವರು, ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
At least he doesn't have copies, so I requested him to apply and furnish.
ಆಯ್ತು, ಲಿಸ್ಟ್ 37.
My lord, serial number 26, my lord. My lord, I am not keeping
ಈಗ
well
ಎಲ್ಲಾರು
today.
ಬಿಟ್ಟಿದ್ರೆ ನಾವು ಅದನ್ನೇ ಮಾಡ್ಕೊಂಡಿರ್ಬೇಕಲ್ಲ ಈಗ. Otherwise we could have continued the hearing of that matter afternoon.
ಇದೆಲ್ಲ ತೊಗೊಂಡಿದ್ದೀನಿ, ಸರಿ ಹಾಕ್ಸ್ಕೊಂಡು ಬಂದ ತಕ್ಷಣ ಹಾಕ್ಸ್ಕೊಂಡು ಇದೆಲ್ಲ ತೊಗೊಂಡೋಗಿದ್ದಾರಾ ಅಷ್ಟೇ, ಇನ್ಯಾವುದಿಲ್ಲ ಅಂತ.
ಇಲ್ಲಿ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರಾ?
dismissal of the appeal under Proceedings. ಒಳಗಡೆನೂ corrective ಆಗಿದೆ. ಇದನ್ನ ಯಾಕೆ ಗೊತ್ತಿಲ್ಲ? ಈ 17 case. ಅಲ್ಲ ಅಲ್ಲಿ ಎಸ್ಪಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಾನೆ ಅರ್ಥ ಆಗಲ್ಲಪ್ಪ. ಎಲ್ಲದಕ್ಕೂ
Your lordship, kind permission. My lord, serial number 26. My lord, kindly have it day after tomorrow. I am not keeping well, my lord.
26, fine. As listed, day after tomorrow. 20th, 26.
My lord,
That matter Satlaka is there. Also given a letter, not extend lot to candidate, show that letter. In the regard.
Yes, sir, one time settlement.
They have requested my lordship for to consider the OTS.
Okay.
It is in the process.
It is in the process. ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಅವರು ಹೇಳಿದ್ರೆ both counsel seek time on the ground that the matter is being settled.
Not settled. It is in the process of settlement, my lordship.
Yes, sir. Being settled and.
No. They have requested for the to consider the OTS. my lordship.
Filing a memo, no?
Memo, letter ಕೊಟ್ಟಿದ್ದಾರೋ
They have to deposit 25% for the initial to consider the OTS, my lordship.
OTS ಅಂತ ಇದೆ.
Yeah.
Both counsel submit that money. ತಗೊಳ್ಳೋಣ. Counsel for the applicant submits memo with the copy of the letter addressed by respondent, sole respondent to the appellant regarding negotiation for one-time settlement.
One days.
Serial number
That
20.
request ಯಾವಾಗ ಎಷ್ಟು ಟೈಮ್ ಆಗುತ್ತೆ?
They have to deposit 25% of the principal dues, my lordship. They have requested, after deposit only we can consider that, my lordship.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇದು
ಅಲ್ಲ,
2015.
So that is what.
We are arranging that amount, 3 lakhs.
Hmm.
Thereafter.
As requested, ಎಷ್ಟು ಪ್ರೋಗ್ರೆಸ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತಿಲ್ಲ. 3 weeks ಆದ್ರೆ ಆದ್ಮೇಲೆ ಹಾಕೋದು.
4 weeks.
List on 10 sir.
My lord, serial number.
Serial number 24, my lord.
Take it, sir. Serial number
24, my lord. Raise 1 week time for instruction, my
serial
lord.
number
24.
24. ಈಗ ಒಂದು ಯಾರೋ mention ಮಾಡಿದ್ರು. 24, there are 2 matters, 24 and 24.1.
Crop 12, I appear for.
You appear for
Appellant in crop 12 of.
cross objector. Both are.
Uh, I'm MFA 6163 in appellant, my lord.
As requested. This is 2016 matter.
Yes, my lord.
List on 17, 24.1.
Much obliged.
My lord.
10 days time is granted to do the needful. 6/1, is to the 26.
24.
24 ಅಲ್ಲ 10 days ಆಗುತ್ತೆ. 17. 10 days time is granted to do the needful, failing which cross objection shall stand dismissed.
My lord, serial number 27, my lord. I am for the respondent. In this matter, the name of respondent as advocate as shown as Pawan Kumar. It should be shown as M.N. Madhusudan, my lord. Last date of hearing, we were absent due to that, my lord.
Who is Pawan Kumar then?
I am Pawan Kumar, but it should be listed in the name of M.N. Madhusudan, senior, my lord.
He has filed.
He has filed the workout. I am along with him, but M.N. Madhusudan.
Is conducting the case on behalf of the respondent. For the respondent. Raised shall show his name in the cause list. Accordingly. Gangi Reddy or colleague. ಅವ್ರಿಗಿಲ್ಲಲ್ಲ ಇವ್ರಿಗಿರೋದು. ನೀವೇ ಬಂದು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿ. ಇನ್ನು ಅರ್ಲಿ ಹಿಯರಿಂಗ್. Yeah, who has filed is 2 of 2019? Early hearing application, who has filed? ನೀವು ಹಾಕಿದ್ದೀರಾ? ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನಲ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಫೈನಲಿ ಬಂದಿದೆ. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನಾವು ಅಬ್ಸೆಂಟ್ ಆಗಿದ್ವಿ. ಅದು ಕ್ಲೈಂಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತು. ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ
ತೋರಿಸಿದಾರಲ್ರಿ, ಅದಕ್ಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಡಕ್ಕೆ that is not a ground.
My lord, we will check in only senior's name, my lord. My name, Wakalat is in senior's name.
ವಕಾಲತ್ತಲ್ಲಿ ಹೆಸರಿಲ್ವಾ?
ಅಲ್ಲ, ನನ್ನ ಹೆಸರಿದೆ, ಬಟ್ ವಿಲ್ ಚೆಕ್ ಇನ್ ಸೀನಿಯರ್ ನೇಮ್.
ಅದನ್ನ ತೆಗೆದ್ಬಿಡಿ ಅಷ್ಟೇನೆ. ಎಸ್, ಆರ್ ಯು ರೆಡಿ ಫಾರ್ ಹಿಯರಿಂಗ್? ಎಸ್, ನಿಮ್ದೇನು ಆಯ್ತು. ಇವಾಗ ನಾವು 2015 ತಗೊಂಡಿದೀವಿ, ನಾಳೆ ಹಾಕೊಂಡು. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕೊಂಡಿದ್ದೀರಾ? ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಸ್ಟೇ ಇರುತ್ತಂತ ಮಂಡೇ ಹಾಕೊಳ್ಳೋಣ. ಲಿಸ್ಟ್ ಅನ್ನು ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ, ಅದ್ರದ್ದು ಅದು ಯಾವ್ದು
Application.
IA 1 of 19.
19, it was filed by the petition appellant.
1 of 19. IA 1 of 19. ಬರ್ಕೊಳ್ಳಿ. ಮೊದಲು ಬರ್ಕೊಳ್ಳಿ. That request one, ಅಲ್ಲ, that request 1 week time is granted to do the needful on IA 1 of 2019, failing which the application shall stand dismissed. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಫಾರ್ ಲಿಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್
26 ಕೊಡ್ತೀನಿ ಮೇಡಮ್.
26. ಇಲ್ಲ ಮಂಡೇ ಹಾಕೊಳ್ಳಿ, ಇಲ್ಲ ಬೈ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಂತ ಹೇಳ್ತೀನಿ ಅದನ್ನು.
24/6.
My lord, meanwhile at that time show the name of Madhusudan.
IA 1 of 2019, honor before next hearing date, failing which the application shall stand dismissed. Adanmele as requested list on 24, 24/6, IA 2 of 2019 for early hearing date disposed of accordingly. Yes.
Show the name of Madhusudan.
Date ಕೊಟ್ಟಿರಲ್ರಿ?
ನೀವು ರಿಟೈರ್ ಆದ್ರಿ ತೋರಿಸ್ತೀವಿ ಅವ್ರ ಹೆಸರು, ಆಯ್ತಾ?
ಡೇಟ್ ಕೊಟ್ಟಿದೀವಿ ಬನ್ರಿ.
ಅಲ್ಲ, ಡೇಟ್
ಹೇಳಿದ್ರು ಅವರು ಗಂಗಿರೆಡ್ಡಿ ಎಲ್ಲ ಅವ್ರ ಹೆಸರು ಬೇರೆ ತೋರಿಸಿದೀವಿ ಜೂನಿಯರ್ ಅಂತ.
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಇದು ಮಧುಸೂದನ್ ಅಂತ ತೋರಿಸ್ತಾ ಇತ್ತು, ಬಟ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಚೇಂಜ್ ಆಗಿದೆ.
Doesn't make any difference. You get the information, no? List ಬರುತ್ತಾ ಇಲ್ವಾ ನಿಮಗೆ? ಅಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್ ಮುಗಿಸಿ.
Much obliged.
Number 36.
I appear for the appellant. Your lordship permits me to withdraw the appeal, I will withdraw the appeal because a degree of divorce is granted by it. Now, what we wanted to settle here also, that confirming the order of the, what is granted. And as far as the guardianship, all the things, not, an appeal is filed by herself. No guardian application was also filed. Matter is already admitted, matter is pending for more than 7.
ನಮಗೊಂದು ಅಪರೆನ್ಷನ್ ಏನಂದ್ರೆ ನಾಳೆ ಈಗ ನಾವು ಮಾಡಿದ್ರೆ
Three minutes.
ಕೋರ್ಟ್
permit me-
ರೆಕಾರ್ಡೆಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ
If your lordship permit me to withdraw the appeal, I will file a memo to the.
ಅವರು ಅದೆಲ್ಲ ಮಾಡೋದ್ ಬೇಡ ಅಂತ ಬಿಟ್ಟು ಅದ್ರಲ್ಲಿ ಆ ಮೆಮೋದಲ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಇದೆಯಾ ಜಾಯಿಂಟ್ ಮೆಮೋದಲ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ಆರ್ ವಿತ್ಡ್ರಾನ್
As far as that is concerned, Mr. Ambaji has to tell.
ಹಾಗೆ ಮಾಡಿದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ನಾವು ಅದನ್ನಾದ್ರೂ ಮಾಡಬಹುದು
Please.
we said no we
No, I
can also
understood.
observe that
I
trial court
understood.
has not
But in the memo, such thing is not mentioned. His statement could be recorded.
ಬರಿತಾ ಇದ್ದಾರೆ
Please,
that is done now we can record
Please,
it because trial court has not examined the doctor who treated her
please,
with that observation we can do that
I understood.
or there is every likelihood of questioning compromise
The allegation made between the parties before the trial court is hereby withdrawn amicably.
withdrawn ಅಂತ ಬರ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ
Please,
ನೀವೇ decree will be confirmed
please, my lord, please.
ಏನೋ ಹೇಳಿದ್ವಿ both parties and their counsel are present the parties are duly identified by their respective
ಬೇಡ,
counsel
ಅದು ಬೇಡ, ಅದು ಬೇಡ, ಅದು ಬೇಡ. ಇದು ಕೊಡ್ತೀವಿ.
they submit they submit the joint memo ನೋಡೋಣ ಹೇಳೋಣ ಜಾಯಿಂಟ್ ವಿತ್ಡ್ರಾಲ್ ಜಾಯಿಂಟ್ ಮೆಮೊ ಕೊಟ್ಟರೆ ನಾವು ಅದ್ರ ಮೇಲೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಿದ್ವಲ್ಲ ಇದನ್ನೇ ಬೇಕಾ ನಿಮ್ಗೆ ಆಸ್ ಯು ವಿಶ್ ನೀವು ಹೇಗೆ ಹೇಳಿದ್ರೆ ಹಂಗೆ ಮಾಡ್ತೀವಿ ಅಲ್ಲ ಇದು ಇಫ್ ದರ್ ಇಸ್ ಎನಿ ಡಿಫಿಕಲ್ಟೀಸ್ ಫಾರ್ ದ ಪಾರ್ಟೀಸ್ ಆಯ್ತು ಹೀಗೆ ಮಾಡ್ತೀವಿ ಏನಂತ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ನಿಮ್ದು ಒಬ್ಬರದೇ ಇದೆ ಅಲ್ಲ ಇದು ಸಿಗ್ನೇಚರ್ ಪಾರ್ಟೀಸ್ ಇಲ್ಲ
ಅಲ್ಲ ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಸಿಗ್ನೇಚರ್ ನಾವು ಮೊದಲ ಜಾಯಿಂಟ್ ಮೆಮೊ ಕೊಡ್ತಿರೋದು ಜಾಯಿಂಟ್ ಮೆಮೊ ಕೊಟ್ರೆ ಅದು ವಿ ಕ್ಯಾನ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ not the parties of the joint memo both submitted I have ಇದು ಬೇರೆ ಕೇಸ ಅದೇ ಕೇಸ ಮೆಂಟಲ್ the parties in the joint memo they admit voluntary execution of the joint memo ಅವ್ರು ಕರೀರಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಅವ್ರ ತಾಯಿ ಆದ್ರೂ ಕರೀರಿ ಒಂದ್ ನಿಮಿಷ ಇಲ್ಲಿ ಬರಕ್ ಹೇಳಿ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರ ನೋ ವಿ ಆರ್ ಅವರ್ ಮಿಸ್ಟರ್ ಬಟ್ ಅಂತ ಕಂಡೀಷನ್ ಇದ್ರೆ ಬಹಳ ಕಷ್ಟ ಇರುತ್ತೆ ಅಂದ್ರೆ ಮ್ಯಾನೇಜ್ ಮಾಡೋದು ಬಹಳ ಕಷ್ಟ ಇರುತ್ತೆ ಇಫ್ ರಿಯಲಿ ಸಚ್ ಕಂಡೀಷನ್ ಇಸ್ ದರ್ because we have seen such instances ಏನಮ್ಮ ನಿಮ್ಮ ಹೆಸರೇನು ನೀವು ಡೈವರ್ಸ್ ಕೊಟ್ಕೊಂಡಿದ್ದೀರಲ್ಲ 35 ಲಕ್ಷ ಇಸ್ಕೊಂಡು ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಿ ನೀವು ಏನು ಇದರಲ್ಲಿ 50 ಲಕ್ಷದಲ್ಲಿ 10 ಲಕ್ಷ ಡಿಡಿ ಎಲ್ಲ ಕೊಡೋದು ಎಲ್ಲಾನು ಪೇಮೆಂಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ
Yes, my lord.
stated 14/6/2020
ಎಲ್ಲ ದುಡ್ಡು ಬಂದಿದೆ ನಿಮಗೆ
14/6/10 months 3 ಡಿಡಿ ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಅಮೌಂಟ್ ಎಲ್ಲ
ಕ್ಯಾಶ್ ಒಂದು 5 ಲಕ್ಷ ಕೊಡಿ
3 ಡಿಡಿ so exchange of hold articles arising from the parties and allegations in both the parties withdraw. So decree shall stand confirmed ಅಂತ ಹೇಳಿದ್ರೆ
Please, please.
and she admits the appellant admits ಆಯ್ತು admits having received rupees 35 lakhs by way of permanent alimony as stated in the joint memo. Found that the terms of admissible in the law. And then next, the trial court had granted decree for divorce on the ground of the incurable mental unsoundness of the appellant. Now, the respondent has withdrawn. The parties have withdrawn. the
Both parties
allegations-
have withdrawn their
parties have
respective
withdrawn
allegations.
The allegations made against each other as per joint memo. Further, the trial court had arrived at a conclusion that the appellant herein was suffering from suffering from incurable mental illness. Only based on some medical records summoned without examining the doctor who treated her or the author of those documents. Considering the opposite circumstances, facts and circumstances, the joint memo is recorded. The appeal is allowed. The confirmation ಅಂತ ಕೇಳಿದಿರಲ್ಲ judgment ನಿಮಗೆ you want divorce decree no
ಹೌದು.
ಅಷ್ಟೇ.
Your lordship may make changes. Sorry. So that they can proceed further in their life.
He is hereby set aside. The MC number 221 of 2013 is allowed in terms of the joint memo. The marriage of the appellant and respondent. The appellant, petitioner and respondent in MC number 221 of 2013. Solemnized on 23/4/2004 at Rajagopal Rao Rashinkar Adultery, Mysore is dissolved. Draw decree according. Draw decree dissolved. Withdraw. Parties. Resolution of ಆಯ್ತು ಅಷ್ಟೇ
ವಾಪಸ್ ಕೊಟ್ಬಿಡು ವಿಡ್ರಾ ಅಂತ ನೋಡ್ಕೊಂಡು
ಅದರಲ್ಲಿ ಬರೀಬೇಕು ಮುಂದೆ appellant and her mother are parties ಅಂತ appellant, her mother and respondent are representative parties.
For further hearing, still number 19, Ramesh B. Kulkarni, Mani Party.
Now only point is
Regarding my lord, the principal bar, what my learned friend has said, my lord, that principal, the suit was, it is barred by limitation. Here in this case, my lord, the guarantors themselves, my lord, are the directors of the company. As a directors, they my lord borrowed money and apart from signing the documents, they executed a personal guarantee. Therefore, my lord, section 29, immediately after, my lord, section 29 proceedings were concluded on 17/5/2006.
they were initiated.
That is within time.
They were initiated within time.
Yeah, they were initiated within time, not
Within time.
17/5/2006.
ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಬಂದಿದೆಯಾ ಇದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ
ಅದರಲ್ಲಿ ಇಲ್ಲ. That is not in dispute. After that, my lord, the miscellaneous petition was filed, my lord, on 13/7/2007. Within, my lord,
correct 1 second
1 year.
29 proceedings were concluded when
29 proceedings were concluded, my lord, on 17/5/2006.
17/5/2006
After, my lord,
ಕೇಸ್ ನಂಬರ್ ಗೊತ್ತಿದೆಯಾ
ಅಲ್ಲಿ ಕೇಸ್ ನಂಬರ್ ಇರಲ್ಲ, ಅಲ್ಲಿ 29, my lord, under ourselves, my lord, without intervention of the court.
Sold ಅದು ಸೇಲ್ ಡೇಟ್ ಅದು
29
confirmation of sale date.
I'm not sorry.
17/5/2006 is what date?
2006, my lord, is the sale
date ಇದು.
ಸೇಲ್ ಆಯ್ತು. ಆಮೇಲೆ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಟು ದಿ ಪರ್ಚೇಸರ್ ಆನ್ 4/12/2006. It is without evidence.
And thereafter, not this miscellaneous is filed on 13/7/2007. Now they cannot now say that not the original loan is barred by limitation against the principal borrower. They themselves are the principal borrower.
But where is the, I mean, deposition and ಎಲ್ಲಾದ್ರೂ ಬಂದಿರ್ಬೇಕಲ್ಲ probably your witnesses deposition ಅಲ್ಲಿ we have taken action against them and concluded ಅಂತ. ಅದು ಪೆಂಡಿಂಗ್ ಇದ್ರೆ that's over ಮತ್ತೆ limitation question ಬರೋದಿಲ್ಲ. Exhibit P1 guarantee, ledger extract, legal notice. Notice to respondent number 1 is exhibit P15. ಅದೇ ಯಾವತ್ತಿನ date? Exhibit P15. Deposition ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
About initiation of the proceedings under section 29.
ಹಾ.
P15 notice ಅಂತಾರೆ, notice ಇಲ್ಲಿ ಬರೀ acknowledgement.
Page number judgment ಅಲ್ಲಿ page number 5.
Principal borrower ಅಲ್ಲ.
Page number 5 ನಲ್ಲಿ ಬರ್ತೀವಲ್ಲ.
Notice ಅಲ್ವೇ ಅಲ್ಲ, ಬರೀ acknowledgement. ಈಗ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು.
Legal notice ಅಷ್ಟೇ.
ಅವರು ಮಾರ್ಕ್ ಮಾಡುವಾಗ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. 15 notice. ಇವ್ರಿಗೆ ಕೊಟ್ಟು ಕಂಪ್ನಿಗೆ ಅಲ್ಲ. This is to this appellant. P17. P15 ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. P15 is.
Judgment ಅಲ್ಲಿ para number 5 lordship, page number 5 of the judgment.
ಪೇಮೆಂಟ್ ಮಾಡ್ತಾ ಹೋಗಿದ್ರಲ್ಲ.
Impugned order.
Just a minute. ಏನೋ ನೋಟಿಸ್ ಕಾಪಿ ಕಾಣ್ತಾ ಇದೆ.
Miscellaneous 63 of 2007. ಇಲ್ಲಿ F ನಲ್ಲಿ.
Which one?
F not
Page number.
para ಇಲ್ಲ ಅಲ್ಲಿ F ಅಂತಿದೆ. A B C D E F.
ಯಾವ್ದು judgment?
F. Order ನಲ್ಲಿ.
Yes.
After issue of notice and following due procedure, respondent number 1 unit was taken over under section 29 SFC Act to recover the dues. After some due publication of sale notification to sell the primary assets, the land, building, plant and machinery were sold for a sum of rupees 1,20,00,000 to the highest bidder. And as on 10/6/2007, the amount has been adjusted as following. So as on 10/6/2007, the respondents are jointly and severally liable to pay the amount detailed in the petition and the interest also. So immediately after sale, not the miscellaneous is filed for the recovery of the balance amount. Therefore, my lord, the contention that.
Examination is a copy of this petition.
ಹೌದು.
Dates ಏನೋ ಬಂದಿಲ್ಲ. Right, how do you say that claim against principal borrower was time barred? Because there was a recovery, section 29.
Recovery, they have not given any date, my lord, when the sale was completed and recovered from the according.
Director of the company.
Who are the director?
And the others have not challenged this finding also. Other respondents.
The respondents, I don't know, my lord, they are against me only.
50% against you, 50% against them.
Yes, my lord.
Is that so?
That's all.
Your lordship, kindly permit me 2 minutes, my lord. The guarantee deed, my lord, clause 1. In all the guarantee deeds, they read as
Clause 1.
if at any time.
One second. Clause 1, if at any default.
If at any time default shall be made by the company in the payment of principal sum of rupees so and so, and interest, commitment charges so and so, for the time being due so and due to the corporation under the security documents, the guarantor on demand shall pay. Therefore, there is no demand. Therefore, there is no cause of action.
No, but section 31 EAA does not say.
No, I will come to that, very little different. Not they contend after the sale of the properties, they will have the time. So once the property is sold, they have to find out what is the balance.
My lord, when they have sold, there is nothing, my lord. My lord, in the paragraph number, 8 of the petition, my lord. After issuing notices, after following the due procedure, and the unit was taken over under section 29 SFC Act to recover the dues. The corporation has published sale notification to sell primary assets, and that is land, building, plant, machinery were sold for a sum of rupees 1 crore 20 lakhs for the highest bid received by the corporation after adjustment of the sale proceeds. The account shows the following balance as on 10/6/2007. Lord, this cannot be the date of disposal of the property. Now, your lordship looks at
Correct, you say that the claim was barred by time.
Lord,
According to you, when the cause of action arose, you
Lord,
say that claim was barred by time against the principal
yes,
borrower.
ma'am. Yes, ma'am.
Right, when the cause of action arose against the principal borrower, according to you, you should show
Lord,
the court
My lord,
that
I
this
have
was
a,
the point.
well,
when
I
the-
have twofold reply for this, my lord. Firstly, if there should be a demand as against me, there is no demand.
That is.
Yes, my lord. So far as the sale, the contention of the KSFC, that after the sale, we find out the balance, then the limitation will start, that is their contention. If your lordship looks at this paragraph, there is absolutely nothing when it was sold and when the money was realized.
See, when you have come to the court saying that the claim was time barred against the principal borrower, not
Yes,
against you. You have to show how it was barred by time against the principal borrower.
My lord, I have taken up a plea that it is time barred. But there must be some material that has to be produced by the other side, because they are in custody of the entire set of documents to show when the property.
The claim was recovered, how it gets time barred?
My lord, when that was recovered, when that was recovered. From that date, it will arise. If they have kept quiet, my lord, they say that here 10/6/2007, that was the balance. When they issue notice, long before that, there they say the following balance on 10/12/2006.
The account extract is produced. In that it is not mentioned when.
My lord, it does not indicate.
When that adjustment was made.
Yes.
It does not indicate sale.
Yes, learned counsel for KSFC.
Yes, ma'am.
You have produced the accounts extract.
ಹೌದು.
Does it show this recovery and
Exhibit
adjustment
P6.
under section 29?
But in the petition 2006,
ಏನಾಗಿರುತ್ತೆ ಅಂದ್ರೆ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರುತ್ತೆ, ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿ ಇನ್ನೂ ಡಿಸ್ಕಸ್ ಆಗಿರೋದು ಇವರನ್ನೆಲ್ಲ he is liable up to that date ಎಷ್ಟು
paragraph 8 in the petition was added to show as if it is within time, only for that purpose. My lord, I have, in the objection, I have fully denied that, saying that it is a concocted one. Therefore, they should have produced document.
In the cross examination of PW1, you have disputed the recovery. Now probably this is the repetition of
ಅದರಲ್ಲಿ ಏನಿಲ್ಲ, chief examination.
cross examination ಅಲ್ಲಿ ಅದು 29 proceedings deny ಮಾಡಿದೀರಾ? Now you are saying nothing is produced ಅಂತ ಹೇಳಿ.
Proceeding, I have not denied, but what is the date when it was completed?
No, your contention is it was barred against the principal
madam.
borrower, not against you. ಈಗ principal borrower ಇಂದ recovery ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಅವರು, where is the recovery is part of it. Where is the question of bar of limitation?
Recovery ಮಾಡ್ಕೊಂಡಿದ್ರೆ the date of recovery, from that date limitation will begin. From that date, the limitation.
No, it's not. That judgment says, if the claim is barred against the principal borrower himself, then that they cannot proceed against it.
Yes, my lord.
Huh.
So far as CL disposal is concerned, my lord, the judgments, my friend relied upon a judgment which says after the sale, what is for 3 years? That is the limitation. But when it was sold, absolutely there is nothing. In the petition, they say 2007 something was due. In the legal notice earlier to that, 2006 that was the due. When it was sold, my lord, your lordship may kindly have a look at the legal notice. Para 5, they say that was the amount due in 2006.
It was better amount.
Then when was it sold, my lord? Absolutely there is nothing, no material at all.
Now, in the cross-examination of PW1, whether he have denied that there was recovery. Or you should have examined the principal borrower.
That is already wound up long back. Principal borrower.
As against it, ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿದಿರ ಅವ್ರು ವಿಟ್ನೆಸ್ಗೆ 94 ಆದ್ಮೇಲೆ ಸಾಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ನೋಡಿ ಇಲ್ಲಿ ಸಜೆಸ್ಟ್ ಮಾಡಿದಿರ ಎದುರುದಾರ ಕಂಪನಿಗೆ ಕೊಟ್ಟಿರುವ ಸಾಲಕ್ಕೆ ಸರ್ಕಾರ ಮತ್ತು ರಾಜ್ಯ ಸರ್ಕಾರದಿಂದ ಬಹುಶಃ ಕೇಂದ್ರ ಸರ್ಕಾರ ರಾಜ್ಯ ಸರ್ಕಾರದಿಂದ ಪ್ರತ್ಯೇಕ ಸಹಾಯಧನ ಬಂದಿದೆ ಅಂದ್ರೆ ಇರಬಹುದು. ಅದನ್ನು ಸಾಲಕ್ಕೆ ಜಮಾ ಮಾಡಿಕೊಂಡಿರ್ತೇವೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಈ ರೀತಿ ಸಹಾಯಧನ ಬಂದಿದ್ದು ಅದನ್ನು ಸಾಲದ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಿದ್ದೇವೆ. ನೀವೇ ಇಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಇಲ್ಲಿ ಸದರಿ ಸ್ವತ್ತು ಮಾರಾಟ ಮಾಡಿ ಬಂದ 1,20,00,000 ರೂಪಾಯಿಯನ್ನು 94ರವರೆಗೆ ಬಾಕಿ ಇದ್ದ ಅಸಲಿಗೆ ಜಮಾ ಮಾಡಿದ್ದೇವೆ ಎಂದರೆ ಸರಿ. ದಿನಾಂಕ 10/6/2007 ಮಾರಾಟ ಮಾಡಿರುವ ಸ್ವತ್ತು ಎದುರುದಾರ ಕಂಪನಿಗೆ ಸೇರಿರುವುದರಿಂದ ಕಂಪನಿ ಹೆಸರಿಗೆ ಮಾತ್ರ ನೋಟಿಸ್ ಕಳುಹಿಸಿರುತ್ತೇವೆ. ನಿಮ್ದೇ ಸಜೆಷನ್ ಪೇಜ್ ನಂಬರ್ 12 ಆಫ್ PW1. 10/6/2007 that was sold ಅಂತ ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರಿ.
17/5/2006 was the sale.
17/5 no?
17/5/2006, my lord.
There is no suggestion made by me.
ಆದ್ರೆ how do you ಈಗ ನಿಮ್ಮ ಅವ್ರದ್ದು guarantee according to the guarantee agreement you should initiate the proceedings by issuing a demand notice. He showed this class 1 guaranteed it. Statute in if at any time default shall be made by the company in payment of principal amount, interest, etc. Due to the corporation under the security documents, the guarantors on demand shall pay the corporation the whole of such principal sum, interest or other monies which shall then be due to the corporation aforesaid will indemnify. This 2007 notice was not issued to them, not issued to this appellant.
ಇಲ್ಲ ಒಬ್ಬರಿಗೆ ಇಲ್ಲ 3 ಜನಕ್ಕೆ ಬೇರೆಯವರಿಗೆ ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
Correct.
ಕಂಪನಿ
ಅವ್ರಿಗೆ issue ಮಾಡಿಲ್ಲ
ಕಂಪನಿ
ನೀವು. ಇಲ್ಲ notwithstanding ಅಂತ ಹೇಳಿದ್ರೆ amendment ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಮೇ ರೀಡ್ ಬ್ಲಾಡ್ ಸೆಕ್ಷನ್ 30
Litigation start ಆದ್ಮೇಲೆ ಇವ್ರು guarantee invest ಮಾಡಿದ್ದಾರೆ. ಆದ್ರೆ ನೀವು ಮಾಡೋದಿಗೆ ಪ್ರಿನ್ಸಿಪಲ್ ಲೆಟರ್ ಅಗೇನ್ಸ್ಟ್ ಟೈಮ್ ಬಾರ್ ಆಗಿರುತ್ತೆ. Yes,
section 32 ಬ್ಲಾಡ್ 1A capital A
32 SFCR.
procedure to be followed.
Correct. You agreement, you are bound by your agreement also.
ಅಲ್ಲಿ not show cause notice will be issued by the court. When the application is for the relief mentioned in clause AA.
When the application is for no, that is about court issuing notice. Now, in your agreement, there was a clause. Both of you are bound by this guarantee agreement. And as per this clause, that guarantor shall pay on demand made by the corporation. You have not made any demand to him. Fiction notice demand ಆಗುತ್ತಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದು. Very complex.
Synopsis
May I?
ಅಲ್ಲಮ್ಮ ಇದು legal notice issued terminating his guarantee.
Continuing cause of action. ಅವರು 2007 ನಲ್ಲಿ ರಿಕವರ್ ಮಾಡಿದಾಗ
May I draw the attention of this honorable court?
ಡಿಫಾಲ್ಟ್ ಯಾವತ್ತಂತೂ ಅದು ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಬಾಕಿ ಉಳಿಯುತ್ತಲ್ಲ. Yes.
May I draw the attention of this honorable court to section 46B? This is overriding effect. Now, this is not ordinarily worded overriding effect, but it is something special. By what I understand is even contractual provisions are overridden by the provisions. I shall read it. The provision of this act, any rules or other
Section
order
46.
46B.
Power to make other.
The provisions of this act and of any rules or order made thereunder shall have effect notwithstanding anything inconsistent therewith contained in any other law, contained in any other law for the time being in force, or in the memorandum or articles of association of industrial concern, or in any other instrument having effect by virtue of any law other than this act. That means
This will prevail.
act prevails, and even the provisions of the contract are overridden.
Unless inconsistency, they will not be over.
Now, contract says there shall be a demand in notice. Act does not say, therefore,
So thinking, demand, now there is no notice. A petition was filed and notice was issued to him. That also, whether that also amounts to demand. There was no notice by them directly to the borrower, guarantee.
yes.
Petition was filed. Thereafter, petition notice was issued to them.
Yes.
That also amounts to a demand. That also amounts to a demand in terms of that guarantee agreement.
Yes.
He has not sent directly notice. He has sent a notice to the court making this demand.
Yes.
Whether that can be construed as a demand.
As I said in case of a suit for partition, the plaint itself is a demand.
But you don't have, it seems you don't have this account extract ನೋಡಿ ನಮ್ಮಲ್ಲೂ ಹೇಗಾಗ್ಬಿಟ್ಟಿದೆ ಅಂತ.
ಇಲ್ಲ.
ಅದರಲ್ಲಿ ಇದ್ರೆ.
Is that your lordship wants
Well,
that the last payment made by him to find out the cause of action?
29.
ಅಲ್ಲ ಇದರಲ್ಲಿ not in this case that will not arise in my respective.
Not our 29 action initiate ಮಾಡಿದಾಗ ಅಲ್ಲಿ ಅಮೌಂಟ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ದು ಅಕೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಅಲ್ಲಿ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿರುತ್ತಲ್ಲ. So we get something on record.
That is a separate proceedings, my lord, therefore that will not be.
Proceeding separate ಆದ್ರೂ ನೀವು ಅಕೌಂಟ್ ನಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡಲೇಬೇಕಲ್ವಾ ನಿಮ್ಮ ಅಕೌಂಟ್ ಪ್ರೊಸೀಡಿಂಗ್.
ತಗೊಂಡಿದ್ದೀವಿ ಅದು ಅಕೌಂಟ್ ತಗೊಂಡಿದ್ದು.
ಅದೇ ನಿಮ್ಮ ಈ ಅಕೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಸಿಗುತ್ತೆ?
ಅದರಲ್ಲಿ ಇಲ್ಲ.
ಅಕೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ನಲ್ಲಿ ಇವ್ರ ಹತ್ರ ಮಾಡ್ಬೇಕಂದ್ರೆ ಅವ್ರ ಲಯಬಿಲಿಟಿ ಏನಿದೆ ಅಂತ ಹೇಳಿ ಮಾಡ್ಬೇಕಲ್ವಾ? ಪ್ರಾಬಬ್ಲಿ ಇದ್ರಲ್ಲೆಲ್ಲೋ ಇರುತ್ತೆ ಅದು.
ಇದೆ.
ಯಾವಾಗ ನಿಮ್ ಪ್ರಕಾರ
2006 my lord is the sale. Amount adjusted to the account my lord was on
2007. ಅದೆಲ್ಲ ಉಲ್ಟಾನು ಇದೆ, ಹೀಗಿದೆ ಅಕೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಎಲ್ಲ ರಿವರ್ಸ್ ನಲ್ಲೂ ಇದೆ. 2003 2007 ಡೆಬಿಟ್ ಟು ಕ್ರೆಡಿಟ್. ಇಲ್ಲಿ ಯಾವ್ದೋ ಇದೆ ಅಲ್ಲ 1,53,09,41. ಒಂದ್ ಯಾವ್ದೋ ಕ್ರೆಡಿಟ್ ಆಗಿದೆ ಅಲ್ಲ 1,53,00,000. ಇದೇನಿದು ಇಂಟ್ರೆಸ್ಟ್
ಇಲ್ಲಿದೆ ನೋಡಿ.
ಇಲ್ಲ ಕ್ರೆಡಿಟ್ ಹಿಂಗಿಟ್ಕೊಂಡು
August ಇದು.
KSFC ಅವ್ರಿಗೂ ಹೀಗೆ ಇಟ್ಕೊಳ್ತಾರೆ ರೆಕಾರ್ಡ್ ನೋಡಿ ಎಲ್ಲ. ಕ್ರೆಡಿಟ್ ತೋರಿಸ್ತದೆ, ಅದು ಇಂಟ್ರೆಸ್ಟ್ ಲೋನ್ ಹೆಂಗಾಗುತ್ತೆ? ಅಷ್ಟು ಪೇ ಮಾಡಿರ್ತಾರೆ ಅಂತಲ್ಲ. ಇಂಟ್ರೆಸ್ಟ್ ಡೆಬಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಇಂಟ್ರೆಸ್ಟ್ ಪೇ ಮಾಡಿದ್ದಾರೆ ಅಂತಾನು. ಸರ್ others are not challenged, I think. But
Date of sale in the account entry, immediately they have to make an entry.
ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿದಿರಲ್ಲ PW1 ಗೆ 2007 ಅಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ.
ಇಲ್ಲ.
You are suggesting.
No, my lord,
Just now we read over that devotion to you. PW1.
There is no suggestion, madam.
ಇಲ್ಲೇ PW1 page 12. ದಿನಾಂಕ 10/6/2007 ಮಾರಾಟ ಮಾಡುವ ಸ್ವತ್ತು ಎದುರುದಾರ ಕಂಪನಿಗೆ ಸೇರಿರೋದ್ರಿಂದ ಕಂಪನಿ ಹೆಸರಿಗೆ ಮಾತ್ರ ಮಾರಾಟ ಮಾಡಿದ್ದೇವೆ. ಇದೆಲ್ಲ ನೋಡುದು.
It is not a suggestion, madam.
ಅಲ್ಲ ಅದಲ್ಲ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಸಜೆಷನ್
ಎದುರುದಾರರ ವಿರುದ್ಧ ವಸೂಲು, it is not suggestion, my lord. It is not suggestion.
ಅಲ್ಲ ಇದು ಡಿನೈನು ಮಾಡಿಲ್ವಲ್ಲ ನೀವು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇದನ್ನ ಎಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ? Cross examine, this was elicited in
My contention has been, I don't know anything because I have suggested that they have not informed me at all. They have not at all informed me.
anything else?
Even the judgments relied upon my friend, they indicate cause of action will begin once the notice is issued. Therefore, there are no points for considerations are framed in regard to cause of action and limitation. Without that, my lord, the learned judge has decided.
Challenge the order for recovery of money past by recovery of an amount ಇದೆ. separate ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನ 25 lakhs, 71,000, 17 lakhs, etc. Past by the additional first edition district and judges input in 60 miscellaneous number 63 of 2007. On the petition under section 31(1) AA and 32 of the State Finance Corporation Act. The fifth respondent to the said case has preferred this appeal. Respondent number 1 was the petitioner. Respondents 2 to 5 were respondents 1 to 4, and the respondent, the appellant was respondent number 5 in miscellaneous number 63 of 2007. For the purpose of convenience, the parties are referred to henceforth according to their ranks to the trial court. The petitioner filed miscellaneous number 63 of 2007 against the respondents under section 31(1) AA and section 32 of the State Finance Corporation Act 1951, for short SFC Act, for recovery of recovery of why that was split up in so many things. Total recovery was 1 crore 90 lakhs 99,809. Total amount. For recovery.
1 crore 20 lakhs
1 crore.
by sale.
20 lakhs. Total recovery
Total
1 crore 90 lakhs, 99,809.
Oh.
0.34. ಇಲ್ಲ ಅದು ಒಂದೇ 60 lakhs ಇದ್ರದ್ದು ಇಷ್ಟ ಆಗಿದೆ. Interest other overdue ಇಷ್ಟು total ಅಂತ. Amount has been adjusted as follows. Recovery of different sums as follows ಅಂತ ಮಾಡ್ಕೊಂಡಿದ್ವಿ. Number 1, ಆ ಲೋನ್ ಅಕೌಂಟ್ ಹೇಳಿಲ್ಲಲ್ಲ. 25,071 lakhs 785 with interest at 16% per annum. Number 2, 20 lakhs 90,496 with interest at 18% per annum. Number 3, 28 lakhs 97,899 with interest at 18.57%. 1 crore 15 lakhs 39,629.34 correct ಅದ ಇದ್ದಿದ್ದೆ ಇಲ್ಲೇ ಇದೆ. With interest at 12.5% per annum. Comfortable at quarterly rates. Correct. All of them were the directors. Response 2 to 5, all were directors.
ಹೌದು.
Respond number 1 ಇಲ್ಲ ಪಾರ್ಟರ್ಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
3 to 5.
No, this Aldia Electronics Private Limited.
3 to 5.
3 to 5. 1 and 2 are one and the same.
Correct. ಎರಡು ಕಂಪ್ನಿ ವೈ ಟು ದಿಸ್ ಥಿಂಗ್ ಎರಡು ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇದ್ದದ್ದು ಅಂತನಾ. One is at ವಿವಿಪುರ,
One at Bangalore, one at Tumkur.
ತುಮಕೂರು, one is Bangalore. But same firm,
Same firm.
partnership firm,
No, it is a limited company.
limited company. They were directors. Respond 1 and 2. Your head office ಯಾವುದು?
Industry unit ಮ್ಯಾಗಿನ head office.
Correct. So head office was respond number 1.
Office was in Bangalore, factory was in Tumkur.
Correct. Registered office ಅಂತ ಇರುತ್ತಲ್ಲ ಒಂದು ಕಂಪನೀಸ್.
Bangalore only. But it has been wound up long back.
Correct. ಅಂದ್ರೆ ಎರಡೆರಡು ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಎರಡೆರಡು ಸೇಮ್ ಕಂಪನಿ ವೈ ಟು.
Because they made two parties, I was forced to make here by the office.
ಅವ್ರು ಮಾಡಿದ್ದೆ ಕೇಳ್ತಾ ಇದ್ರು. Respond number 1 and 2. For a private limited company having its registered office at the address at first response address and industrial unit at a second response address. Response 3 to 5 were the directors of the same company. The petitioner KSFC has sanctioned disperse ಎಲ್ಲ ಆಗಿದೆಯಾ? Sanctioned the following loans. Term loans and the request of the respondents. ಬರ್ಕೊಳ್ಳಿ ಅಂದ್ರೆ 1, 2, 3. Rupees 48 lakhs 45,000. ನಮ್ಗೆ ಈ ಟರ್ಮಿನಾಲಜಿನೇ ಅರ್ಥ ಆಗೋದಿಲ್ಲ. ವಾಟ್ ಇಸ್ ದಿಸ್? 48 lakhs 45,000 ಅದು ಶಾರ್ಟ್ ಟರ್ಮ್ ಲೋನ್ ಇರ್ಬೇಕಿಲ್ಲ. ಅಲ್ಲ ಸ್ಯಾಂಕ್ಷನ್ ಟರ್ಮ್ ಲೋನ್, ಇದು ಶಾರ್ಟ್ ಟರ್ಮ್ ಲೋನ್ ಇರ್ಬೇಕಿಲ್ಲ. ಟರ್ಮ್ ಲೋನ್ 48 lakhs 45,000. Number 2, short term loan, short loan ಅಲ್ಲ 2 lakhs. Bridge loan 3, 6,60,000. Additional term loan 13 lakhs. Next Additional soft loan, 2 lakhs. Next, additional bridge loan, 4,10,000. Next, additional bridge loan, 2,92,000. Additional term loan, 17,85,000 and one after another. From different dates ranging from 26/7/1989 to 28 to 1995. By the time that had become sick industry, ನೀವು ಪ್ರಿನ್ಸಿಪಲ್ ಬರೋರ್ ಮುಂದೆ ಮೇಲೆ ಪ್ರೊಸೀಡ್ ಆಗೋ ಅಷ್ಟೊತ್ತಿಗೆ it had become sick industry. As security for repayment of the said loans, the respondents executed hypothecation agreements. Respondents 3 to 5 executed continuing guarantee agreements. Response 1 and 2 became a sick industry. Therefore, the petitioner on 16/5/2000 RS ಅಂದ್ರೆ ಏನಂತ ನಿಮ್ಮನ್ನ ಅವಾಗ ಕೇಳಿದೆ ನಾವು. The petitioner on 16/5/2000 granted
That is a scheme for revival of the loan.
ರಿವೈವಲ್ ಆಫ್ ಸಿಕ್ ಇಂಡಸ್ಟ್ರಿ ಹಿಂಗೇನೋ ಇರ್ಬೇಕು ಲಾಂಗ್ ಫಾರ್ಮ್ ಹೇಳಿದ್ರು ನಾವೇ ಅದನ್ನ ಇದ್ರಲ್ಲಿ ನೋಡಿ ಹಾಕೊಳ್ಳೋಣ ಬಿಡಿ ಗೂಗಲ್ ಅಲ್ಲಿ. RSR facility for reviving the sick unit by rescheduling the existing term loans and funding of interest arrears to the principal borrower. Despite that, response 1 and 2 failed to pay the loan as per the schedule. Therefore, the petitioner initiating action under section 29 of the SFC Act to recover the dues, sold the primary assets of respondent number 1 and 2, that is land, building, plant and machinery for a sum of rupees 1,20 lakhs in auction and adjusting the same in the loan balance, adjusting the same on against the loan and as on 10/6/2007, the response were still due to pay rupees 1,90,99,809.34. Respondents 3 to 5 being the guarantors are jointly and severally liable to pay the said amount. 2 to 6 ಅಂತ ಹೇಳ್ತಾರೆ, 3 to 5. ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 2 to 6 ಅಂತ ಹೇಳಿದಿರಿ. ರೆಸ್ಪಾನ್ಸ್ 2 to 6 ಆರ್ ಜಾಯಿಂಟ್ಲಿ. 2 to 6 ಇಲ್ಲ ಅಲ್ಲಿ. 5 ನಿಮ್ ಪಿಟಿಷನ್ ಪ್ಯಾರಾ 10 ಅಲ್ಲಿ 2 to 6 ಆರ್ ಜಾಯಿಂಟ್ಲಿ ಅಂಡ್ severally liable ಅಂತ ಹೇಳ್ತೀರಿ. 6 ಇಲ್ವೇ ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್. The petitioner claimed that on issuing notice dated 13/2/2017, the guarantors failed to pay the amount. Therefore, invoking the provisions section 31(1) AA, the SFC sought, KSFC sought recovery of the loan amount as aforesaid. Respondent only respond number 5 contested the petition by filing its objections. The claim of contention of respondent number 5 in brief is as follows. The availment of the loan and execution of the guarantee agreements was not disputed. But he resigned from the directorship of the first respondent company with effect from 29/3/1994. And the same was intimated to the petitioner by notice dated 26/4/1994. And then 26/4 or 16/5/94 that notice. The said fact is duly intimated through letter dated 26/4/2000.
Issued notice to the terminating the.
ಅವರು ರಿಟೈರ್ ಆಗಿರೋದು ಇಲ್ಲ ಕರೆಕ್ಟ್ 26 which was served on the petitioner on 16/5/1994. Respondent number 1 suffered losses due to the mismanagement of then directors of respondent number 1. Respondent number 5 has initiated winding up proceedings. Avare madidra winding up proceedings on his application it was.
Maybe voluntary winding up, my lord. When I filed it, some dues were paid to me, I withdrew it.
Extract ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Voluntary winding.
32 it's written statement.
Court proceedings ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ.
In the petition filed by me, they paid my money and it was dismissed. Later, they voluntarily, it appears what.
Initially you filed it.
I had filed it.
Despite such mismanagement and default, the petitioner went on continued to grant additional facilities to the first respondent company by such negligence on the part of the petitioner. The fifth respondent is relieved of its liability. Company petition number 17 of 1996 ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
ಹೌದು, ನಾನು ಹಾಕಿರೋದು.
The petitioner, fifth respondent filed company petition number 17 of 1996. 4790, he has also issued notice on 4796.
Yes. That is retirement.
Alla.
Of the terminating guarantee.
Notice stating a guarantee given by withdrawn and rescinded.
Yes.
But ನೀವು ಹೇಳಿದ notice 16/5/94 ಅಲ್ಲ ಅದು? Exhibit.
Their demand notice is 13
ಅಲ್ಲ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು ನೀವು ಕೊಟ್ಟಿದ್ದ notice exhibit ಎಷ್ಟು? R3 date ಎಷ್ಟದು? 16/5/94.
It is 4796.
ಹಾ 47. ಮೊದಲು ಒಂದು ಕೊಟ್ಟಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. Fifth respondent. By notice dated 4/7/1996. ಇದು ಯಾರಿಗೆ ಕಳ್ಸಿರೋದು ಇದು? ಮ್ಯಾನೇಜರ್.
R3 ಆಗಿದೆ. 4796 is R3.
ಇದನ್ನ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡಿದಾರಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
It is not disputed.
Issued notice to the petitioner. Revoking the guarantee agreement. What is that threatening criminal action? Respond number 5 has issued communication to the state company on 28/11/1997. It's not very material. Fifth respondent. So even after the retirement of the fifth respondent, even after invoking the guarantee, the petitioner has continued the financial lending loan to the first respondent, for which he is not liable. He is not liable. Statement of objection ಅಲ್ಲಿ limitation ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದ್ದೀರಾ? No cause of action ಅಂತ ಹೇಳಿದ್ದೀರಾ? 3 and 15. 15 no cause of action ಅಂತ ಹೇಳಿದ್ದೀರಾ? The petition against him is barred by time, and there is no cause of action against him, hence he sought dismissal of the petition against him. Okay. The petitioner in support of its case examined two witnesses as P1 and 2 and got for exhibit P1 to P70. Respondent 5 was examined as part of 1 and on his behalf exhibit R1 to R3 were marked. The trial court, on hearing the parties unnamed, by rejecting the contentions of the petition, fifth respondent allowed the petition for the sums claimed by the petitioner. Next one. Challenging the said order. Judgment and order. The fifth respondent has preferred the above appeal. ಇದರಲ್ಲಿ ಏನು ನಾವು ಅವಾಗ ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿದ್ವಲ್ಲ 32(9) and 42 ನಲ್ಲಿ there is no specific ಅದರ ಸ್ಕೋಪ್ ಆಫ್ ಅಪೀಲ್ ಬಗ್ಗೆ 32(9) is about trial court proceedings. 46, 42. 42 is offenses. ನಿಮ್ಮ ಅಪೀಲ್ ಯಾವ ಪ್ರೊವಿಷನ್ ಅಲ್ಲಿ ಇದೆ? 32(9). Such appeal, High Court may, after hearing the parties, pass such orders. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಮಾಡಿದಿರಲ್ಲ, ಅಪೀಲ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 32(9) ಅಂತ ಒಂದು ಮಾಡಿದಿರಿ, 42(1) ಅಂತ ಮಾಡಿದಿರಲ್ಲ. ವಾಟ್ ಇಸ್ ದಟ್ 42(1)? 42(1) is about offenses. ನೀವು ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ 32(9) ಅಂತ ಹಾಕಿ ಇನ್ನೊಂದು 42(1) ಅಂತ ಹಾಕಿದಿರಲ್ಲ. Has preferred the above.
42(9) ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡಿ ಮೇಲ್ ಬರ್ದಿದ್ದಾರೆ.
ಸ್ಟ್ರೈಕ್ ಆಫ್
Strike off ಮಾಡಿದ್ದಾರೆ.
ನಮ್ಮದ್ರಲ್ಲಿ ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡಿದ್ದೇನೆ ಕಾಣ್ತಾ ಇಲ್ಲ.
Very feebly it is visible here.
ನಮ್ಮದ್ರಲ್ಲಿ ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡಿಲ್ಲ, ಸ್ಕೋರ್ ಮಾಡಿಲ್ಲ, ಅದನ್ನ ಹಾಗೆ ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲಿ ಕಾಣಿಸ್ತಿದೆ.
But appeal lies under section 32(9) only. Shri, let's say, the Kulkarni, the Kulkarni, the council appearing for that. Slash respond number 5, reiterating the grounds of appeal, challenges the order really on the following grounds. Number 1, that no notice invoking the guarantee as required under section 31 was issued to fifth respondent. Therefore, and in terms of the contract was issued to the respondent number 5. Therefore, there was no cause of action against him. The petition was untenable. Number 2, even after the fifth respondent revoking the guarantee agreement, the petitioner went on lending the money, guarantee agreement, and after his retirement, petitioner went on lending the money, for which the fifth respondent cannot be held liable. The claim against principal borrower itself was barred by time. Therefore, the claim against fifth respondent was also barred by time. Notice was issued. Notice was issued. ನೀವು ಕೊಟ್ಟಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವುದು? In support of his submissions, they have given any judgment, Mr. Our ಕೊಟ್ಟಿದ್ದು.
2006.
Yes, Malik Patil. ಅವ್ರು ಕೊಟ್ಟಿದ್ದ ಇದ್ರಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರ?
ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು.
ಇಲ್ಲ, ಕರೆಕ್ಟ್ ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ. ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್.
ಸೀತಾರಾಮ್ ಗುಪ್ತಾ is mine.
In support of his submissions, realize on ಯಾವ್ದೋ ಮಡ್ರಾಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
That Madras judge,
ನೀವು ಕೊಟ್ಟಿದ್ದು ಮಡ್ರಾಸ್
it runs contrary to the 2008 Supreme Court, therefore I gave it up. Madras.
ನೀವು ಕೊಟ್ಟಿದ್ದು ಒಂದೇ.
ಹೌದು, initially it was given.
ಟಿಕೆಟ್ ಬ್ಯಾಂಕ್ ವರ್ಸಸ್ ಚೆನ್ನವೀರಪ್ಪ.
ಹೌದು, ಅದರಲ್ಲಿ the Madras, Honorable Madras High Court said contravention.
You are not insisting on these judgments, no? ನಿಮ್ಮ ಎದುರು ಜೊತೆ ಕೊಡಿ. He relies on the judgment of the Supreme Court, following judgment of the Supreme Court. Syndicate Bank versus Channavirappa, Bailey and others. 2006 AR SCW 2134. Our Malik Patil, level counsel. Level counsel appearing for SFC. He'll be first respondent. SFC. And Shri, ನೀವು ಯಾರ್ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ಈಗ? 4 and 5. ನೀವು ಅಲ್ಲೇ ಕಾಂಟೆಸ್ಟೇ ಮಾಡಿಲ್ಲ, ತಗೊಳ್ಳಿದ್ದು ಹೀಗಾಗಿದೆ ನೋಡಿ. ವಿಷ್ಣು ಕುಮಾರ್, ಬಾಲರಾಜ್. Arvind, Shri Arvind Naglu, level counsel appearing for respondent number 4 and 5. Submit that the guaranteed agreement executed by the fifth respondent was a continuing guarantee. Therefore, he is bound by the he is bound by the liability incurred by respondent one. Even subsequent to issue of consent. Scope ilva invocation ಮಾಡೋದಕ್ಕೆ ಇದು ರಿವೋಕ್ ಮಾಡಕ್ಕೆ ಗ್ಯಾರಂಟಿ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಬೇಕಾಗಿಲ್ಲ.
ಈಗ ಒಂದು ಕಾಂಟ್ರಾಕ್ಟ್ ಇದ್ರೆ ಅದನ್ನ ರಿಸಿಂಡ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಏನು ಇದನ್ನೇ ಇಲ್ವಾ? ಆ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಏನಿದೆ ಗ್ಯಾರಂಟಿ ಅಗ್ರಿಮೆಂಟ್? ಇಟ್ ಇಸ್ ಇರ್ರಿವೋಕಬಲ್ ಗ್ಯಾರಂಟಿ.
ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದೇ ಇಲ್ಲ, ರಿವೋಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದೇ.
ಗ್ಯಾರಂಟಿ ಅಗ್ರಿಮೆಂಟ್ ಟರ್ಮ್ಸ್ ಏನಿದೆ?
Recital number 6 of exhibit P1.
P1.
He cannot wriggle out of liability. Because he has agreed so.
P1, paragraph 6.
6.
Recital number 17 at page 10.
ಅದಕ್ಕೆ ಅದು ಹೇಳಿಲ್ಲ.
17 at page 10. The guarantee herein contained shall not be revoked or affected
By the death, dissolution, insolvency or cessation or termination of the office of the director.
Yes.
ಅದು ಅಲ್ಲಿಗೆ ಆಯ್ತದು. It's not co-terminus. Or on any one or more of the guarantors, but shall continue to be binding and operative in respect of liabilities which have arisen up to the date of death, insolvency, dissolution, cessation, or termination of the office of the director, as the case may be, as well as ಇದ್ರಲ್ಲೇನೋ ಪ್ರಶ್ನೆ because he has admitted that 2000 ಗಿಂತ ಮೊದಲನೇ issue of the
15 says it is irrevocable.
termination. ಅಲ್ಲ ಹಾಗೆ ಬೇಡದು. The guarantee agreement itself states that the guarantee was not, the same was not revocable. Therefore, the appellant is liable to pay the dues of the first respondent. Section 31(1) AA does not contemplate issuing of notice of demand against the guarantor prior to the initiation of the action. And the notice issued, petition notice issued to the fifth respondent is sufficient to meet the demand notice contemplated in the guarantee agreement. So far as limitation, it was contended that the proceedings against the principal borrower under section 29 of the Act were concluded on 17/5/2006. 17/5/2006. The assets of the first respondent, which were sold were handed over to the purchaser on 4/12/2006. The petition was filed on 13/7/2007. Therefore, that was well within the period prescribed under Article 137. Under Article 137 of the Limitation Act. Therefore, there is no merit in the appeal, and the same is liable to be dismissed. In support of their submissions, they rely on ಇದು ದೀಪಕ್ ಭಂಡಾರ ಅರುಣ್ ಚಟರ್ಜಿ ಇದರಲ್ಲಿ ಪಾರ್ಟ್ಸ್ ಬೇರೆ ಇವ್ರು 2014 Sale proceeds are found insufficient, not from the date of the loan is recalled. In support of the submission, they rely on the following judgments. Okay, Deepak Bhandari versus Himachal Pradesh. Others matters we may not be able to take up, we'll repeat those matters. 349 ಅಂತ ನಮ್ಗೆ ಯಾವ್ದೋ ಒಂದು. Yes, ಗಂಗಾಧರಪ್ಪ ಅವ್ರೆ, ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ತೀವಿ ಎಲ್ಲಾನು. ಯಾರಿಗಾರು ಬೇರೆ ಡೇಟ್ ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಹೇಳೋಗು. ಯಾಕಂದ್ರೆ ನಮ್ದು 2015 ಮುಗಿಸ್ಬೇಕು ನಾವು. Tomorrow they will be. ಅದನ್ನ ನಾಳೆನೆ ರಿಪೀಟ್ ಮಾಡೋಣ.
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಐ ಹ್ಯಾವ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಟು ಎಸಿಯರ್.
ಏನಾಗ್ಬೇಕೀಗ?
ನಾಳೆ ನಾನು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ, ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಆಗಿ.
ಅವ್ರ ಅರ್ಥ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು. ಇಲ್ಲಿ ಇದು ದಿಸ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್, ಅವ್ರು ಇರೋವಾಗ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ. ಎಷ್ಟು 2015 ಇತ್ತಲ್ಲ ಇದು. ಅದಕ್ಕೆ ನಾಳೆ ನಿಮ್ಗೆ ಕನ್ವೀನಿಯಂಟ್ ಇಲ್ವಾ? ಅಲ್ಲ ಅವ್ರಿಗೆ ಇಲ್ಲ ಅಂತಂದ್ರೆ if you want to ನಿಮ್ದೇ ತಗೊಂಡ್ಬಿಡ್ತೀವಿ ನಾಳೆ. ನಿಮ್ದು ಓಲ್ಡೆಸ್ಟ್ ಮ್ಯಾಟರ್ ಡೌನ್ ಇನ್ ದ ಲಿಸ್ಟ್. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹಾಕಿದೀವಿ. ಹಾಗಾದ್ರೆ ಮೇಲೆ ಇರುತ್ತೆ. ಟುಮಾರೋ ಕ್ಯಾನ್ ಕಮ್. ರೆಡಿ ಆಗಿಲ್ವಾ? ಹಾನಿ ಹೊಳ್ಳ ಏನೋ ಅವ್ರು ಮಾಡಿದ್ರು ನಿನ್ನೆ. ಅವ್ರು ರೆಡಿ ಇದಾರಂತಲ್ಲ. ನೀವು ಅದ್ರಲ್ಲಿ ಆ ಕೇಸಲ್ಲಿ ಇಲ್ಲ. ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ನೀವು ರೆಡಿ ಆಗ್ಬೇಕು. ರೆಡಿ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಕೂಡ ಅವ್ರದ್ದು 15,000 ರೂಪಾಯಿ ಕೊಡ್ಸಿದ್ಮೇಲೆ ರಿಲೀವ್ ಮಾಡ್ತೀವಿ. ಆಯ್ತು. The matters will be repeated tomorrow.
Serial number 25 may be called after 10.
ಅಲ್ಲಿ ಹೇಳ್ಬೇಡಿ, ಯಾಕಂದ್ರೆ ನಂದು ಅದು ನೋಡ್ಕೊಳ್ಳೋದ್ರಲ್ಲಿ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅನ್ನು ಬಿಟ್ಟು ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಬಿಟ್ಟು ಉಳಿದ ಜಾಸ್ತಿ ಕೊಡ್ತೀನಿ.
24th ಕೊಡ್ತೀವಿ.
ಹಿಮಾಚಲ್ ಪ್ರದೇಶ್ ಸ್ಟೇಟ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡೆವಲಪ್ಮೆಂಟ್ ಕಾರ್ಪೊರೇಷನ್ ILR 2014 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 961 ಗುಲ್ಹಾತಿ ಈ ILR 2007 ಕರ್ನಾಟಕ ಯಾಕೆ ರಿಲೈ ಆಗ್ತೀರಿ ಇವ್ರೆ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸಫಿಶಿಯೆಂಟ್ಲಿ ಕವರ್ಡ್ ಇದೆ ಅಲ್ಲ. ನೀವು ಮಾಲಿ ಪಟೇಲ್.
I am relying on the question of limitation. Or what they say, not that is barred by limitation, that the dishonorable court and the honorable Supreme Court has said that the cause of action to proceed against the guarantor would arise after exhausting my remedy under 29 anta.
My friend is incorrect.
ILR ರಿಲೈ ಮಾಡಿದ್ರಲ್ಲ, ILR 2007 ಕರ್ನಾಟಕ.
ILR
ಅಲ್ಲಿ ವಾಟ್ಸ್ಆಪ್ ಮೇ kindly see.
ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಹಾಕಿರೋದಿಲ್ಲ ಅವರು.
para 20 ನಲ್ಲಿ ಆಮೇಲೆ ಸೆಕೆಂಡ್
ಎಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ ಅದು? ಏನ್ ಪ್ರಪೋಸಲ್? ILR 2007 ಗುಲ್ಹಾತಿ and another versus Karnataka State Financial Corporation and others. ILR 2007 Karnataka page 44. Next 2008 ನೀವೇ ರೆಫರ್ ಆಗಿರೋದಲ್ಲ? ಸೀತಾರಾಮ್ ಗುಪ್ತಾ ವರ್ಸಸ್ ಅದೇ ಅವರು ಪಂಜಾಬ್ ನ್ಯಾಷನಲ್ ಬ್ಯಾಂಕ್ and others. ILR 2008 Supreme Court 2416. Syndicate Bank versus Channavirappa Bailey and others 2006. 2006 SCW SCW 2134. Next, on considering the submissions of both sides and examining the records, the point that arises for consideration is whether judgment of the trial court allowing the petition of KSFC under section 31(1)(a) 32 ಹಾಕೊಂಡಿದ್ರೆ of SFC Act is sustainable. Next page. None of the respondents disputed the fact of respond number 1 being the company and 3 to 5 being its directors. They also did not dispute the availment of the loan for by respond number 1 and 2 under for the industrial purpose. And the sum borrowed for the They did not even dispute the execution of the deed of guarantee, exhibits P1 to P5. P5. Exhibit P5 ಇವ್ರದಲ್ಲ, P4 P5 ಏನೋ ನಿಮ್ಗೆ. ಇವ್ರದ್ದು, this appellant. They also, ಒಂದ್ರಲ್ಲಿ ಅವ್ರು 2000 ಅಲ್ಲಿ ಮಾಡಿದ್ದಕ್ಕೆ he is not a party. Correct.
Exhibit P5.
Except exhibit P4. The appellant was fifth respondent before the trial court, was an executant in other guarantee deeds. The terms of the said documents were also not disputed. It was respondent number 1 and 2 became defaulters. And the petitioner proceeded against them under section 29 of the SFC Act and realized the assets of the said company. PW1, in the cross-examination of PW1, he clearly stated that on 10/6/2007, the assets of the company were sold. And rupees 1 crore 20 lakhs was realized from such sale, and that was adjusted to the loan account.
Yes.
Despite that, there was outstanding amount in the said loan.
Yes.
In the said loan account. The first regarding the first contention was of respondent number 5 is that before initiating the proceedings under section 31AA of the Act, 32 no notice was issued to, no demand notice was issued to him. Therefore, there was no cause of action against him, and petition under section 31AA and 32 was not maintainable. Section 31AA to consider that issue, section 31(1)AA are relevant for this purpose of this case, which read as follows. ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ನಾನು ಇಲ್ಲಿ ಅಂಡರ್ಲೈನ್ ಮಾಡಿದ್ದೀನಿಲ್ಲ, ಅದರಲ್ಲಿ ರಿಕ್ವೈರ್ಸ್ ಅನ್ನೋದನ್ನ ಸಬ್ಜೆಕ್ಟ್. The reading of the above provision shows that does not indicate issuance of any demand notice to the guarantors. That it has only employed the term requires to state that requires the sum and substance of the said requirement is that sum and substance. The requirement intended there is that if on issuing if on a financial corporation requiring the industrial concern, which is respondent number 1 and 2 in this case, if the said concern fails to make repayment, then without prejudice to the provisions of section 29 of the act, the corporation can proceed against the guarantors under before the district judge. Nowhere in the said section it is said that before filing a petition under section 31 AA, a notice shall be issued to, demand notice shall be issued to the guarantor.
The two judgments my friend has given, both of them say notice required.
Notice industrial concern ಗೆ ಅದು.
ಅಲ್ಲ ಇಲ್ಲಿ ಗ್ಯಾರಂಟರ್ಗೆ ಬೇಕು ಅಂತ.
ಓದಿ ಅಲ್ಲಿ ಗ್ಯಾರಂಟಿ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇರೋದಕ್ಕೆ ಒಂದ್ ನಿಮಿಷ ನೋಡಿ ಇದು ಹೇಗೆ ಹೇಳುತ್ತೆ, ವೇರ್ ಅನ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಕನ್ಸರ್ನ್ ಇನ್
ಗ್ಯಾರಂಟರ್ಗೆ ಬೇಕಾಗಿಲ್ಲ, ಇದು ಮೇನ್ ಬರೋವರೆಗೆ ಬೇಕಾಗಿಲ್ಲ.
ಮೇನ್ ಬಾರವರ್ಗೆಲ್ಲ ಗ್ಯಾರಂಟರ್ಗೆ ನೋಡಿ
ಗ್ಯಾರಂಟರ್ಗೆ ಬೇಕು.
ಪ್ರೀ ಕಂಡೀಷನ್ ಫಾರ್ ಫೈಲಿಂಗ್ ದ ಪಿಟಿಷನ್ ಅಂಡರ್ ಸೆಕ್ಷನ್
ಅಲ್ಲ ಸೆಕ್ಷನ್ ನಲ್ಲಿ there is nothing about the notice.
ಇಲ್ಲ ರಿಕ್ವೈರ್ಸ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ, ರಿಕ್ವೈರ್ಸ್ ಅನ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಕನ್ಸರ್ನ್ ಟು ಮೇಕ್ ಇಮಿಡಿಯೇಟ್ ರಿಪೇಮೆಂಟ್
ಹೌದು
ಅಂತ ಇದೆ. ಅವ್ರಿಗೆ ರಿಕ್ವಿಸಿಷನ್ ಮಾಡಿದ ಮೇಲೆ ಅವರು if they fail they can proceed against them under section 29 as well as against the guarantors.
Guarantor ಗೆ your lordship, two judgments my friend has relied upon, both of them say notice required. Your first judgment my lord of 2014 Supreme Court, your lordship may kindly see para number 22. Para number 22, last page of that judgment.
ಅಲ್ಲ ಅದರೊಳಗೆ ಇಲ್ಲ ಕರೆಕ್ಟ್ 22 ಇಲ್ಲ
2014 judgment.
ಅದು ನೋಡಿ ಇಲ್ಲೆಲ್ಲ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ನಂಬರ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್
Para number 22, right hand column, your lordship may kindly have a look at. Last about 5-6 lines. The right to sue on the contract of indemnity arose after assets were sold. The present case would fall under Article 55 of the Limitation Act, which corresponds to old Articles 115 and 16 of the old Limitation Act. The right to sue on a contract of indemnity guarantee would arise when the contract is broken. Then your lordship may kindly go to the second judgment. Internal page number 95.
Page number 95.
Second judgment, internal page number 95.
ನೋಡಿ ಅದರಲ್ಲಿ page number
Internal page number 95.
Yes.
Adರಲ್ಲಿ about 10 lines from the top. The right to enforce liability against the surety accrues on the date of serving of notice invoking the liability of the surety under the deed of guarantee. The starting point of limitation is the date when the
purpose of reckoning the limitation.
Pardon?
Reckoning the limitation when the right to sue accrued ಅನ್ನೋದು ಲಿಮಿಟೇಷನ್ ಎಲ್ಲಿಂದ ಕೌಂಟ್ ಮಾಡಬೇಕು ಅನ್ನೋವಾಗ ಆ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
Right to enforce liability against the surety accrues on the date of serving of the notice invoking the liability.
ಕರೆಕ್ಟ್. ಈಗ ಅದು ಯಾವ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಲಿಮಿಟೇಷನ್ ಕೌಂಟ್ ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲಿಂದ ಅವ್ರಿಗೆ ರೈಟ್ ಟು ಸೂ ಅಕ್ರೂಡ್ ಅಂತ ಇದೆ. The moment they become defaulter, right to sue accrues to him in this case.
My lord, so far as borrower is concerned, my lord, nothing of that sort is required, my lord. The judgment also in the
section 31 ನಲ್ಲಿ ಬಾರೋವರನ್ನೇ ಹೇಳಿದ್ದಾರೆ, ಬಾರೋವರ್ಗೆ ಅವ್ರನ್ನ ರಿಕ್ವೈರ್ ಮಾಡಬೇಕು.
my lord, the argument advanced was or notice was required for borrower. The my lord, the head note.
ಇನ್ನೊಂದು ತೋರಿಸಿದ್ರಲ್ಲ ಓವರ್ ರೈಡಿಂಗ್ ಇಫೆಕ್ಟ್ಸ್ ಅಂತ ಹೇಳಿ. This is for the purpose of limitation. Limitation ಗೆ ಯಾವ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್, ಲಿಮಿಟೇಷನ್ ಕೌಂಟ್ ಮಾಡೋದಕ್ಕೆ ಯಾವ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಶುರು ಆಯ್ತು. ಈಗ ಸಪೋಸ್ ಅವ್ರು ಶುರು ವೇಳೆ even assuming that they have not issued notice to you or they have not issued notice to you. The moment you come before the court and dispute your liability, it starts alva adu.
For making demand against the guarantors, there for initiating action, there is no,
Section and ತೋರಿಸಿ ನಮ್ಗೆ ಎಲ್ಲಿದೆ ಅಂತ 31AA. That is for enforcement of the liability.
that does not contemplate any demand notice.
This was in the context of when the limitation starts to run. ಆ ಕಾಂಟೆಕ್ಸ್ಟ್ ಆದ್ರೆ ಸೂ ಮಾಡೋದಕ್ಕೆ ಯಾವಾಗ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅರೈಸ್ ಆಯ್ತು ಅನ್ನೋದ್ರಲ್ಲಿ.
Right to sue means cause of action only, my lord. That is what my lord.
Correct. Now you are denying your liability. You have denied your 1996 ಅಲ್ಲ ಯಾವಾಗ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅವಾಗ್ಲೇನೆ ಡಿನೈ ಮಾಡ್ದಂಗೆ ಅದು 96
Yes.
ರಿವೋಕ್ ಡಿನೈ ಮಾಡಿಲ್ಲ, ನಾನು ರಿವೋಕ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. ದಟ್ ಎಕ್ಸಿಬಿಟ್ R7 ನಿಮ್ದು ರಿಪ್ಲೈ ಇದು R17 R7 ಅದು ಇದು R3 R3 this was 4/7/1996. ಅದಕ್ಕೆ ಅವ್ರು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ 16/5/1994 ಅಲ್ಲಿ. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ಎನಿಥಿಂಗ್.
Yes.
Notice is required to be given to required to be given to the guarantee. Okay. Learned counsel for the appellant referring to ಯಾವ paragraph of the judgment, referring to ಹೇಳಿದ್ರಲ್ಲ para 22 ಅಲ್ಲ ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ಹೇಳಿದ್ದು. para 22 of the judgment in Deepak Bhandari's case. ಇನ್ನೊಂದು ಯಾವ್ದದು para 92 ನ ಇಷ್ಟ ಹೇಳಿದ್ರಲ್ಲ para 30 of the judgment in Mulati's case contends that the right to enforce the liability against the surety accrues on the date of serving of the notice invoking the liability of the surety under the deed of guarantee. Reading of the said judgment show that such observations were made in the context reckoning the limitation to file petition under section 31AA of the Act, and no general principle was laid down that unless a demand notice is issued, petition under section 31(1)AA against the guarantor cannot be maintained. Further, the statement in the chief examination, statement in the cross examination of PW1 that limitation and notice in further on service of the notice of the petition, the respondent, respondent 5 has denied its liability. That goes to show that the petitioner has a cause of action against respondent 5. So, next, therefore, the contention that without notice, issuing demand notice, section 31AA petition was not maintainable, cannot be countenanced. Next, invoking guarantee in 1997. Next, so far as the bar of limitation, it was contended that in the year ಅದನ್ನು ಹೇಳ್ತಿರಲ್ವಾ ನೀವು ನಿಮ್ದು 94 ಅಲ್ಲೇ ನೀವು ರಿವೋಕ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ, ಅದಕ್ಕೆ ಆದ್ರೆ ಅಲ್ಲಿಂದ ಲಿಮಿಟೇಷನ್ ಶುರುವಾಗುತ್ತೆ ಅಂತ. That is your contention, bar of limitation?
Termination.
Termination of
Guarantee.
ಅದೇ termination of guarantee 94.
96.
94, exhibit R3. 96. It was contended that the
4796.
Respond number 5. Revoked the guarantee on 4/7/1996 itself. Thanks. Resigned ಅಂತ ಹೇಳಿದ್ದೀರಿ ಅದರಲ್ಲಿ. He has resigned from the directorship of the company with effect from 29/3. Letter dated 26 had also cancelled the guarantee by the said letter. In reply to the said letter, he have sent a letter dated 6. Shareholder continue. That the respondent 5 under exhibit R3, the notice dated 4/7/1996. 4/7. ಇನ್ನೊಂದು 95 ಅಲ್ಲಿ ಒಂದು 94 ಅಲ್ಲಿ ಒಂದು ಯಾವ್ದೋ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಅವ್ರು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದಾರಲ್ಲ ಮೇಲ್ದಲ್ಲಿ.
That is a letter informing that I have resigned, kindly relieve me. That is what I had requested. And my lord, for that the right answer saying they can't do it, but the learned judge has said it is the sending notice is not proved.
So you are not pressing that notice is not proved. Okay. Therefore, limitation started to run against the fifth respondent in 1996 itself, but the petition was filed in the year 2007. Therefore, that is beyond 3 years. Therefore, the same is barred by time. ಈ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದ್ ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂತನಾ? ಇಲ್ಲ, ಅದಕ್ಕೆ ಅದು ರಿಪ್ಲೈ ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಅಲ್ಲ, ಇದ್ರ ಸರ್ವಿಸ್ the respond number 3 to 5 did not dispute the terms of a deed of guarantee. Exhibit P1 to P5. ನಿಮ್ಮದು ಯಾವುದು? ನಿಮ್ದು ಇವ್ರದ್ದು his the appellants. Respondent number 5 was an executant in exhibit P1 to 3 and 5. P1 to 3 and 5. As rightly pointed out by the trial court. ಯಾವ ಕ್ಲಾಸ್ ಇದು? ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಗ್ಯಾರಂಟಿ ಇದು ಈಗ ರೆಫರ್ ಮಾಡಿದ್ರಲ್ಲ, ಎಲ್ಲದರಲ್ಲೂ ಇದೆ. ಈಗ ನೀವು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರಲ್ಲ ಅದು
17.
ಕ್ಲಾಸ್ 17.
Recital number 17.
ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಗ್ಯಾರಂಟಿ ಎರಡು ಕ್ಲಾಸ್ ಇದೆ ಅದ್ರಲ್ಲಿ. ಒಂದು ಇರ್ರಿವೋಕೇಬಲ್ ಅಂತ ಒಂದಿದೆ, ಇನ್ನೊಂದು ನೀವು ತೋರಿಸಿದ್ರಲ್ಲ, ನಾವ್ ಈಗೆಲ್ಲ ಅಂಡರ್ಲೈನ್ ಮಾಡಿದ್ವಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P1 5 ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರೆ ಯಾವ್ದು?
16 ಅಲ್ಲಿ ಒಂದಿಲ್ಲ, until repayment is 16.
6
All
3
until repayment in
or say and 3 is
6 and 17 and 14. 14 says it shall be continuing on.
3 and 6 correct ಇಲ್ಲಿ ಮಾಡಿದ್ರು. Guarantors also here.
for all
Para 6 of ಎಲ್ಲದರಲ್ಲೂ ಒಂದೇ ತರ ಇರಲ್ಲ,
ಎಲ್ಲ ಒಂದೇ.
Para 6 of the said
14
guarantee agreements.
14 ನಲ್ಲಿ the word used is continuing on.
ಅಲ್ಲ, para 6 ಅಲ್ಲಿ ಇದೆ. The guarantors also hereby agree and declare that company will be free to raise further monies from the corporation or from any other financial institution.
Yes.
In addition to the said principal sum, subsistence present. Guarantee herein contained will not be affected or vitiated in any way whatsoever.
Shall not be revoked at the 17th ನಲ್ಲಿ.
ಅಂದ್ರೆ ಎಲ್ಲ ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಗ್ಯಾರಂಟಿ ಅಂತ ಒಂದು ತರಿಸಿದ್ರೆ
ಇಲ್ಲಿ 14 ನಲ್ಲಿ ಇದೆ.
14.
Para 14. 17 guarantee herein contained shall not be revoked ಅದು para 17 ನಲ್ಲಿ.
14 1
The
4
guarantee herein contained shall continuing on.
ಮೇಲೆ
ಇದು ಕ್ಯಾನ್ ರೇಸ್ ಫರ್ದರ್ ಮನಿ ಅನ್ನೋದು ಇದಕ್ಕೆ.
guarantee
Para 14. And 17 of the guarantee agreements which are relevant in the context of such contention of the respondent read as follows. 1417 ಎರಡು expect
770
ನಾನೆಲ್ಲ underline ಮಾಡಿದ್ದೀನಿ
ಇವತ್ತಿತ್ತು ಏನಾಗಿದೆ ಅಂತ.
be advanced herein after ಅಂತ ಇದೆ. Further payment otherwise. ಆಮೇಲೆ 17 ಅಲ್ಲಿ reading of the above paragraphs go to show that the guarantors agreed that the guarantee is executed by them hold good not only for the loan lent as on the date of the said agreements, but also the future loans lent to respondent number 1 and 2. And the guarantee agreements were irrevocable. Therefore, the contention further ಅವರು ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಎಕ್ಸಿಬಿಟ್ ಮೇದಲ್ಲಿ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ which is that document exhibit legal notice to the guarantor ಅದಾದ್ಮೇಲೆ notice to respond number 4 exhibit P17 in response to P17 the notice of respond number 5 P17 exhibit R2 dated 26/4/1994 that he has resigned from the company and he shall not be liable to exhibit R2 ಒಂದು ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ರೆ ತುಂಬಾ ಈಸಿ ಇರುತ್ತೆ ಈ ಕೇಸ್ಗಳಲ್ಲಿ. ಇದೇನು ಹ್ಯಾಂಡ್ ರಿಟನ್ ಎಕ್ಸಿಬಿಟ್ R2 ಟೈಪ್ ದ ಕಾಪಿನ past accepting my resignation for releasing the personal guarantee given by to KSFC by me. And the company has relieved him of the liability of personal guarantee the petitioner issued exhibit P17 reply as per exhibit P17 dated 16/5/1994 stating that it has not relieved him of personal guarantee for the liability of the company and his prayer is rejected. Thereafter, respondent number 5 did not take any action. Seeking his relief. Therefore, it's not open to him that he was relieved. He had revoked the guarantee. Though he claimed that he had issued a notice exhibit R3 dated 4th July 1996. There was no proof of service of such notice denying his liability. Therefore, the same was rightly rejected by the trial court. It cannot be said that the cause of action to the petitioner started from that period, from that date, as the notice, proof of service of notice was not proved. PW1 in his cross-examination, the statement of PW1 in his cross-examination. His clearly stated that on 10/6/2007, the assets of the principal borrower, that is the respondent number 1, were realized by sale. And still there were, it is a claim of the petitioner that even such realization, after such realization, the amounts were not, there was still outstanding loan. The petition was filed in the year 2007. And therefore, there is no merit in the contention that the petition was cause of action accrued in the year 1994, and the petition was barred by time. That cause of action accrued to the petitioner. Indisputably, notices to the other guarantors, that is respondents 2 to 4, invoking the guarantee were issued on P14 to 16. Notice to 2 to 4, 3 and 4. 3 and 4, as per exhibit P14 and 16, are issued on ಯಾವತ್ತಾಗಿದೆ ಅದು exhibit P14? ಮೊದಲಿಂದೆಲ್ಲ ಜಾಯಿಂಟ್ agreements ಅಲ್ವಾ, guarantee deeds, jointly executed guarantee deeds, all the 3 together executed except 1.
ಹೌದು.
P ಯಾವತ್ತು ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅದು 14 and 16? 14 and 16? 19/2/2007. ಬೇಗ ಕೈ ಸಿಗೋದಿಲ್ಲ ಇಲ್ಲಿ. Exhibit P 14 and 16 ಬೇಗ ಕೈ ಸಿಗೋದಿಲ್ಲ ಅಂತ. ಇದು acknowledgement ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು, ಅವರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲಲ್ಲ ಅದನ್ನ. 13/2/2007, 15 ಅಲ್ಲ. ಅವ್ರದ್ದು ನೋಟಿಸ್ ಇಲ್ಲ, ಬರೀ ನೋಟಿಸ್ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ದೇ ಆರ್ ನಾಟ್ ನೋಟಿಸ್, ಓನ್ಲಿ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೇ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ 14 and 16. ಹೌದು, 27/2/2007. ಎಕ್ಸಿಬಿಟ್ P7 ನಲ್ಲಿ ಇಬ್ಬರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಶಶಿಧರ್ ಮತ್ತು ಶೋಭಾ ಶಶಿಧರ್. ಏನಂತ ತಗೊಂಡ್ರು? were issued under exhibit P7 on 13/2/2007, and they will clearly served on them. It's material to note that except exhibit P4, the other guarantee agreements, that is exhibit P1 to P3 and P5, were executed by all the by response 2 to 5 jointly. And the response 2 to 4. This response 2 to 4. I did not dispute the execution of service of the notice. Therefore, The cause of action, the trial court was justified in holding that the cause of action arose to the petitioner to proceed under section 31A on issuance of notice exhibit P7 in February 2007. Next. The next contention is that after other one time. Loans were lent, and then we dealt with that. We retired, we go to the loan, we have covered by this. Huge settlement. And our case under no cause of action, no notice of the claim against principal borrower was barred by time. Principal borrower ಮೇಲೆ loan. The other contention was that the claim against the principal borrower itself was barred by time. Therefore, the guarantee agreements could not have been enforced. ಯಾವಾಗ ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಅದು ಪ್ರಿನ್ಸಿಪಲ್ ಬರೋರ್ ಮೇಲೆ ಇದಾಗೋದು? On what ground you say that claim against principal borrower itself was barred by time?
Loans were very old. Last one was 2000. 2007 the case is initiated. There is no material date when the properties were disposed of.
The ground will, sorry. It was continued that last loan was a soft loan 2000 was lent to the principal borrower.
Rescheduling was the last one, 2000.
And action against them was not taken up to 2007.
7.
Up to 2007. Therefore, the claim against the principal borrower was time barred. The litigation starts to run against the principal borrower not from the date of lending the loan, but from the date of the demand of the from the date the default and from the date of demand by the lender and failure of the principal borrower to repay the loans. Nothing was elicited in ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಂತ ಗೊತ್ತಾಗೋದಿಲ್ವಾ? The exhibit there is no as already pointed out. The demand was made by the petitioner calling upon the principal borrower under the notice dated 2007 under notice exhibit common notice ಕೊಟ್ಟಿದ್ದಾರೆ ಎರಡಕ್ಕೂನು notice exhibit P7 dated 13/2/2007. 13/2/2007. The principal borrower himself did not raise any contention that the claim was barred by time. Similarly, the petitioner sold the assets of the principal borrower and adjusted the loan amount on 10/6/2007 as found in the evidence of one.
Your Lordship looks at the notice 10/12/2006 something.
13/2/2007 ಅಂತ ಇದೆ.
ಅದು ಪಿಟಿಷನ್ ಅಲ್ಲಿ,
ಪಿಟಿಷನ್ ನಲ್ಲಿ ಇರ್ಬೋದು.
ಪಿಟಿಷನ್ ಅಲ್ಲಿ 2007, ಬಟ್ ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಬ್ಯಾಲೆನ್ಸ್ ಡ್ಯೂ ಶೋನ್ ಇಸ್ ಆಸ್ ಆನ್ 10/12/2006 ಸೇಲ್ ಆಗಿದೆ ಅಂತ.
ಅಲ್ಲ, ಸೇಲ್ ಆಗಿರೋದು 10/6/2007 ನಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ್ರು ಅಂತ.
ಇಲ್ಲ. Because notice itself says we have done it as on 10/12.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳಿ.
Para 5 of the notice, page 2.
Para 5 of the notice. Exhibit P7, no?
Yes, ma'am.
Para 5.
Right from the beginning, the first of you were not able to run the unit. The first of you being chronic defaulter in repayment of the amount to the corporation, it was left with no other alternative but to initiate recovery action. After issuing the notice and following the due procedure, the unit has taken over under section 29 of the act to clear the dues. The corporation has punished the published sale notification and the machineries were sold for 1.20 crores for the highest offer received.
ಅದನ್ನ ತಗೊಂಡ್ರೆ ಟೈಮ್ ಬಾರ್ ಆಗೋದಿಲ್ಲ.
Ala sale, date of sale is nowhere, neither in the petition nor in the notice. But sale ಆಗಿದ್ದು ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ, but at 10/12/2006 ಗೆ ಬ್ಯಾಲೆನ್ಸ್ they are showing.
ಕರೆಕ್ಟ್. ಅವಾಗಾದ್ರೂ ಈ ಪಿಟಿಷನ್ ಟೈಮ್ ಬಾರ್ ಆಗೋದಿಲ್ವಲ್ಲ. ನಿಮ್ದು ಕೇಸ್ ಏನು, ಪ್ರಿನ್ಸಿಪಲ್ ಲೆಟರ್ ಮೇಲೆ ಟೈಮ್ ಬಾರ್ ಆಗಿತ್ತು ಅಂತ. ಅವರೇ ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ ಟೈಮ್ ಬಾರ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. Here also they are party. They have not taken up that contention.
Because your lordship has seen he is at loggerheads with me. He wants me to be punished. Therefore, it is obvious he has remained absent.
Correct. But ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರನು 10/12/2006 was the realization of the assets.
ಹೌದು. ಅದರಲ್ಲಿ 2007, but there is no document supporting any transfer or disposal of property.
You come to the court, you have to show that the limitation started, I mean, he became.
No, your lordship will
He
see.
made the demand and it was rejected by the principal borrower.
My lord, since 1997, Supreme Court has been saying the person who has the best evidence with him has to produce it. I don't have anything. I don't know when they have sold. They should come before the court and show, because their contention is incorrect. Varying statements they take 2006 and.
ಇಲ್ಲಿ 10/12/2006 ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನ್
ಅಲ್ಲ,
ಹೇಳ್ತಾರೆ?
ಸೇಲ್ ಮಾಡಿದ್ದ ಡೇಟ್ ಅಲ್ಲ ಇದು, ಸೇಲ್ ಮಾಡಿದ್ದ ಡೇಟ್ ಅಲ್ಲ.
Adjust ಮಾಡ. One.
ಆಫ್ಟರ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್, ಯಾವಾಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರು ಗೊತ್ತಿಲ್ಲ, ಯಾವಾಗ ಸೇಲ್ ಮಾಡಿದ್ರು ಗೊತ್ತಿಲ್ಲ.
ಅದನ್ನ ಯಾವಾಗ ಸೇಲ್
Therefore, they should have come before the court with sale details.
PW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ 10/6/2007 ಮಾರಾಟ ಮಾಡಿರೋ ಸತ್ತು ಎದುರುದಾರ ಕಂಪನಿಗೆ ಸೇರಿರೋದ್ರಿಂದ ಕಂಪನಿ ಹೆಸರಿಗೆ ನೋಟಿಸ್ ಕಳಿಸಿರುತ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, it is just oral statement which runs contrary to their own pleading.
ಇದನ್ನ ಕಾಂಟ್ರವರ್ಟ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ ನೀವು. ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅದ್ರ ಹೋಗ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನೀವೇನಾದ್ರೂ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಕಾಂಟ್ರವರ್ಟ್ ಮಾಡಿದೀರಾ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್? Because this was marked through PW1.
Your lordship knows the principal, my lord, who comes to the court has to establish his case. And the best evidence they will be having. I don't have anything.
ಅಲ್ಲ, ಅಕೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಇತ್ತಲ್ಲ, ಅದನ್ನಾದ್ರೂ ನೀವು ನೋಡಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ. ಏನು ನಿಶಾನೆ ಎದುರುದಾರರು ಮರುಪಾವತಿ ಮಾಡಿರೋ ಪೂರ್ತಿ ಹಣದ ಬಗ್ಗೆ ನಿಶಾನೆ PR ಅಲ್ಲಿ ನಮೂದಾಗಿದೆ. ಈಗ
Actual date of sale, nowhere it is found.
ಈಗ ಅವ್ರ ಅಕೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದವ್ರದ್ದು ಎವಿಡೆನ್ಸ್.
Account extract will not show the date of disposal.
ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ, ಅಲ್ಲೇನು ನೀವೆಲ್ಲೂ ಕೇಳೋದಿಲ್ಲ. ಇವ್ರು ಇಲ್ಲಿ ಹೇಳೋದೇನು, ಆಫ್ಟರ್
Lord, when I take up,
taken over under section 29 of the
Lord,
SFC.
when I take up a contention that barred by time, it is for them to show how it is within time.
You say when you are barred by time, now that principal borrower has not raised any contention. Then it is for you to show it was barred by time ಅಂತ ಅವ್ರನ್ನಾರ ಸಮನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಇಲ್ಲಿ see these kinds of contract, ಆಯ್ತು ನೀವು ಒಂದು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ at least you have not followed that, you have not filed any suit claiming that this agreement is not enforceable, I have revoked it ಅಂತ ಹೇಳಿ under contract act.
I should have done.
ಅದ್ಯಾವ್ದು ಸೆಕ್ಷನ್ ನಮ್ಮ ಓದಿದ್ವಲ್ಲ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ ಸೆಕ್ಷನ್ 130, ಅದನ್ನೊಂದು ರೆಫರ್ ಮಾಡ್ಲಿಲ್ಲ. 130 You have to invoke that provision ನಾವು ಅವಾಗ ಓದ್ತಿದ್ವಿ ರೆಫರ್ ಮಾಡಲಿಲ್ಲ. Revocation of a continuing guarantee may at any time be revoked by the surety as to the future transactions by notice to the creditor. ನೀವು ಇದನ್ನ ಪರ್ಸೂ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. The only thing is ನಮಗೂ ಅನ್ಸುತ್ತೆ ನೀವು ಅದನ್ನ ಇಂಟ್ರೆಸ್ಟ್ ಅದನ್ನ ಸೇರಿಸಿ ಅದನ್ನೇ ಸಿಕ್ಕಾಪಟ್ಟೆ ಮಾಡ್ಬಿಡ್ತೀರಿ ಗ್ಯಾರಂಟರ್ಸ್ ಮೇಲೆ ಪ್ರಿನ್ಸಿಪಲ್ ಬರೋರ್ನ ಬಿಟ್ಟು ಮಾಲಿಪಟ್ಟಿಲ್ರಿ ನೀವು ಅದು ಅದೇನು ಅಸಲಿಗಿಂತ ಅಸಲಿಗಿಂತ ಬಡ್ಡಿನೇ ಜಾಸ್ತಿ ಮಾಡ್ಬಿಡ್ತೀರಿ. ಅವ್ರ ಹತ್ರ ಮಾಡೋದಿಲ್ಲ.
Because it will go on multiplying the interest. It is a loan of the year 1990.
At the earliest, ಅವ್ರು ಬರೋರು ಯಾರು?
Even now, even if they not come for some settlement or OTS scheme, they may not get the benefit of the entire interest. Interest benefit or sigite or bank even after the judgment. If they come forward to settle it, they will do it.
It was that was not disputed. Referring to a recital in Exhibit P7, to the effect that the loan assets were sold for 1.20 crores, and after adjusting the sales proceeds, the loan balance as on 10/12/2006 was 1 crore 78 lakhs 18,197.34. It was, I'm sorry, the loan counsel for the counsel for the appellants into bracket respond number 5 submits that the petitioner has not clearly come out on which date the assets were sold. On which date exactly the assets were sold. The burden was on the petitioners to prove that the petition was within the period of limitation. Therefore, his contention regarding limitation shall be upheld. The principal borrower itself, principal borrower and other guarantors were also party to the petition.
Principal borrower or liquidator, they should have made a party because it was wound up. That they have not done. Our dispute.
ನೀವೇ ಹೇಳಿದಿರ ಒಂದು ಲಿಕ್ವಿಡೇಷನ್ ಪಿಟಿಷನ್ ಆಗಿ ಹಾಕೊಂಡಿದ್ರಿ ಅಂತ.
ಅಲ್ಲ ಅದು ನಮ್ದು.
How they can proceed? Only they can make a statement before the company court ಅಷ್ಟೇನೆ.
ಇಲ್ಲ ಕಂಪನಿ ನಂದು ಹಾಕಿದ್ದು ನಾವು ವಿಡ್ರಾ ಆಗಿ ಕ್ಲೋಸ್ ಆಗೋಯ್ತು.
ಮತ್ತೆ ಅದು
later it was wound up voluntarily. They know the KSFC knows it. Therefore
ನೀವು ಯಾವಾಗ ಪಿಟಿಷನ್ ಹಾಕಿ ಅದನ್ನ ಪರ್ಸೂ ಮಾಡ್ತಿರ್ತಿರೋ ಅಲ್ಲಿವರೆಗೂ how can they file a petition under section 31? ನೀವೆಲ್ಲೋ ನಿಮ್ಮ ಇದ್ರಲ್ಲ ಬಂದಿದೆ ಎಲ್ಲ ಹೇಳಿದಿರಿ ಈ ರೆಫರ್ಡ್ ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ.
ನನಗೆ ಅದು ವೌಂಡ್ ಅಪ್ ಆಗಿದ್ದನು ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲಿನೂ ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಸಮೇತ್ ದೇ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಅದು ಆಮೇಲೆ ಐ ವಿತ್ಡ್ರೂ ದಟ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಡಿಪೋಸಿಷನ್ ಅಲ್ಲ ಇದ್ರಲ್ಲ ನೀವು ಹೇಳಿದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್
there was some amount payable by the company did not pay accordingly.
ಕರೆಕ್ಟ್ ರೆಫರ್ ಪಿಟಿಷನ್ ರೆಫರ್ ಮಾಡಿದಿರಲ್ಲ
ಹೌದು
ಯಾವ ಇದ್ದದು
that was the one filed by me in 2017. The money was paid and ultimately this honorable court dismissed it. Thereafter there is a voluntary winding up
section ನಲ್ಲೂ ಎಲ್ಲೋ ಹೇಳಿದ್ದೀನಿ ಫೈಲಿಂಗ್ ಅಬೌಟ್ ಕಂಪನಿ ಪಿಟಿಷನ್ ಅಂಡ್ winding up petition.
I have stated in para number 2
of statement
page 2.
Para 2 page 2. 17 of company petition 17 of 1996 and that was withdrawn on ಯಾವಾಗ ವಿತ್ಡ್ರಾ ಮಾಡಿದ್ರಿ ಅದನ್ನ petition. They did not raise such contention. ಅಲ್ಲಿ ನೀವು ಆ ಕಂಟೆನ್ಷನ್ others have conflicting interest against me ಅಂತಾನು ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ನೀವು ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ. Therefore, when the principal borrower himself did not raise such contention, it is not open to the, it's not open. The contention of one of the guarantors, that is respondent number 5, in that regard, without any proof, cannot be accepted. Proof of bar of limitation cannot be accepted. It is also to be noted that the findings of the trial court with regard to the liability of the principal borrower and other guarantors, that is respondents 2 to 4, have attained finality. On that count also, the contention regarding the bar of limitation against principal borrower cannot be countenanced. Okay, ಮೂರು ಆಯ್ತಲ್ಲ, ಇನ್ನೊಂದು ಅದು ಜಸ್ಟಿಸ್ ಇವ್ರದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ತರುಣ್ ಚಟರ್ಜಿ in Channavirappa Beleri's case, the Honorable Supreme Court held that limitation starts running only when actually a demand for payment is made, and that was refused by the guarantors. Limitation to file an application. To file a petition under section 31A starts running only when actually a demand for payment is made, and it was refused by the guarantors. It was also held that there is a difference between a guarantee which stipulates that guarantor is liable to pay was also held that the liability to pay may arise on the principal debtor and the guarantor at the same time or at different points of time. ಇದರಲ್ಲೂ ಆ ಥರ agreement and a claim ಅಲ್ಲ ಅದರಲ್ಲಿ agreement ಅಲ್ಲಿ ಇರುತ್ತೆ ಇದ್ರಲ್ಲೂ. A claim may even be time barred against the principal debtor but still enforceable against the guarantor. And the parties may agree that the liability of a guarantor shall arise at a later point of time.
Yes, sir. That was 390.
Para 6 to 8. 6 to 8. Now,
Revocation 30 given.
with an appellant having entered into such an agreement. In a context, in Sitaram Gupta's case, the Honorable Supreme Court held that once the guarantor waives his right of revoking the guarantee, he cannot claim the benefit under section 130 of the Contract Act. In the present case also, under the guarantee agreement, all the guarantors have agreed that their liability continues despite retirement, death, etc. Therefore, even that contention In the contention that he was retired, etc. cannot be accepted. The, on careful examination of the entire material on record and the applicable law, we find no ground to interfere with the interim order, hence appeal is dismissed. We'll continue tomorrow. Dates ತಗೊಂಡಿದ್ದೀರೋ ಕೊಡಿ, ಉಳಿದಿಲ್ಲ.